I'm having my Korean panic attack.
Hey, everybody. Good morning, good afternoon, good evening, and hello again from 30 seconds ago on my other stream. This is the fastest turnaround stream ever. I literally just signed off my other stream 30 seconds ago. I'm going to bring this window up right now because the court has just started. We've got the Law and Cuck stream going here. Where are we? Whoops. Let's catch up.
I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court. I will remind you once again of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I checked, I verified. It is
accepted and returned.
Mr. Brooks, that's yet another interruption. Let me get through this, please.
I just want...
You will have an opportunity when I give you an opportunity.
My blood pressure is already going up.
No one else is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62. That's another interruption.
I intend to follow.
That was super smooth.
This court comes with a history of Mr. Brooks interrupting now. This is day 4. And every day, Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware.
I'll give you some comments as soon as possible.
I'm well aware. Stop talking.
Which I have the right to do.
I'm well aware, Mr. Brooks, that you object to the name that has identified on the information and all documents in this case. Your objection is noted. It does not need to be repeated. I will make a record right now. The court notes a continuing objection by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously related to that. Those documents are of record. There's another document that's filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio means to participate.
Removed from the courtroom.
That's another interruption.
You haven't shown me any lawful case law that I can be removed from the court proceedings in a trial and forced under coercion and
coercion
to appear in the trial that I am needed, that I've tried to express that I have the right.
Mr. Brooks, there's a proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility. You interrupt. You don't wait for anyone to finish. And it will result with you being removed from the courtroom. So you are once again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple of things, the first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts around each one of the tables. I'm aware of the feet shackles. That's yet another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly, all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again,
okay, she's trying to be fair.
Have been made for you to
trying not to prejudice them by seeing some guy in cuffs and shackles.
Clothes. I would like you to appear in street clothes. And the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks,
that's a good
I've
point.
had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in. I'm in custody. It's virtually impossible for anybody to not.
Look at me, I'm a boomer. I actually muted it because the dogs were playing with this ball back here and barking a lot. Yes, the sound is here. Just hang on. I figured it out. So anyway, what I was saying is I was bringing this down, bring the volume down so I can explain to you what's going on. I'm going to try not to talk over this too much. Let it play because it's insane. But I just wanted to let you know that I'll bring the volume down or something when I want to talk, when I think there's something that needs to be said, or just talk over it. Otherwise, we'll just kind of let it go. We'll get to as many of your comments as possible. Do the like and the subscribe thing. And when the super chats come up, just like Lancelot, I'll read the super chats. I don't want to talk too much, or yes, this is live. Yeah, Native American Indian dog. Yes, this is live. That's why I don't want to talk over the trial too much. But we'll make the comments as necessary and see how it goes from here. And I'm going to go put the dogs out in the hall. So we'll bring the volume back up and go at it.
As a non-response, but he came to court here today. That's another interruption. I will take that because he's come to court here today in his jail attire. That is a choice that he has made freely, voluntarily and intelligently. No one has forced him to come to jail in those clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jury?
No, you may not, sir. You need to file a motion in order to do that.
So
Mr. Brooks,
I filed haven't even been responded to. I gave
Mr. Brooks, you're interrupting me yet again.
You just weren't speaking.
All right, Mr. Brooks, you are now going to be removed to the other court.
Oh God!
I have had a dozen or more interruptions. We'll be off the record while we do that. Thank you,
I don't agree to a stop. Well, I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to.
That's not a thing. Yeah, that's their volume, not mine.
Right to be present for trial.
Now, this is actually an interesting thing. If he's removed into the other room, how is he going to make objections? I'm actually curious about this. I can see them taking him off to another room during the jury selection and preliminary hearings and things. But right now, I mean, if they're going to move him off to another room, he still, as his own lawyer, needs to be able to make objections, to interrupt anything that's interrupt properly the things that are going on in trial. And I don't know how that would work with him in another room. But there's a couple, let me catch up on a couple of comments here. Yeah, he has the sign. He can hold up his the video link in a sign. He can hold up his objection sign. God. Well, we got 10 minutes into it before he got booted out. I think that's a record for him. Silverleaf says, can you tell me why she lets him get away with this? She's not letting him get away with it. She's trying to be reasonable with him. I feel for this poor woman. I really do. Lumber Lady says, that's just how the sound is. Nick was messing with it for 4 hours yesterday and couldn't figure it out. The sound is kind of weird. It kind of comes in and out and goes up and goes down, and it's kind of that way. Snowflakes Nightmare says, legal advice, I'm confused. Why with this man on video running over these people? What's this court for? This court is because if the government, if the prosecution, if the state, if the people, if they are going to seek to take, if he gets convicted, which, I mean, he's going to get convicted, they are going to put him in jail for the rest of his life without the possibility of parole. He's going to jail for the rest of his life. And if the government is going to take away your right as a human being to ever see the light of day again, you have to go through the due process. The prosecution has to put him to proof. They have to prove beyond a reasonable doubt that he was legally responsible for committing this crime, which resulted in 6 deaths and over 60 other people being injured. And in doing so, they have to present their evidence in a proper and lawful manner. We do this for guilty people so that when they come for an innocent person, they're held to the same standard. And also, the Constitution gives us the right to face our accusers. It gives us the right to stand up and look the people that are accusing you in their eyes and question them. So it's it may seem mechanical and unnecessary and a waste of time and money, but by protecting and preserving his rights and by putting the judge and the jury and the prosecution to their standards of duty, their respective standards of duty for a man who is clearly guilty, means that they can still be held to that same standard when an innocent person is accused. And God forbid that innocent person is ever you. And someone thinks you did it and says, why are we doing this? We know they did it. When will she rule him incompetent? My understanding is when she was doing the examination to see if he was fit to testify, to act as his own lawyer, that he underwent 4 evaluations. Is he incompetent, or is he just being an asshole? Is he just being a dick? That's what we don't know. We just did that. And Lancelot 652, I was just watching the other stream, and now you're still up for this trial. I'm shocked. We'll keep doing this as long as I can stay awake here. Or until they call it quits for the day. The jury hasn't even got into the courtroom, it looks like, at this point. Thank you so much for the super chat. The Pants Maestro. Pants are prison. Thanks for streaming this, Vices. Was looking forward to watching it on the Pope's channel, so thanks for picking up the slack. I'm sure there's other people picking up the slack too, but hey, I'm the king slacker, so yeah. Hey, that's what I'm here for. I'm just doing it. If somebody's got a grift here on YouTube, hey, may as well be me. So why not? The Redneck Ram says, thank you for the super chat, by the way. Cool avatar there. This just needs to stop. For as funny as it is, we need an ironclad conviction, so they need to just appoint him some lawyers. I almost clicked the end broadcast button. Why the hell would I do that? That's the problem. And again here, 2012 Jameson, thank you so much for just appoint an attorney already. That's the problem. And we talked about this on my stream the other day. The legal standard for being able to represent yourself in court is remarkably low. You just have to be able to prove that you can coherently make an argument, at least a semi-plausible argument in your own defense. That's a low standard. should he be allowed to represent himself? Clearly not. Does he meet the legal threshold for someone who is competent to act as their own attorney? Unfortunately, it seems that he does. And he has the right to do that. And the other problem is when she went through this the other day with him, he's not necessarily exercising his right to act as his own attorney. He waives his right. He waives his right to have other representation. So basically, he's waived his right to have, and he can't now come back and say, I want a lawyer. Something has to happen in that court. This is my understanding. Something has to happen in that court that forces her to say, all right, I clearly don't think you're competent enough, and this has got to happen. We need to appoint someone for you. And even if they do, the guy still doesn't have to listen to his appointed lawyer. This is a shit show of a case, and he knows it. He's pulling all this sovereign citizen crap. I don't think for a single minute he buys the sovereign citizen Kool-Aid. He is just using it as a means of interrupting the trial. I don't think he's mentally ill. I think he's crazy like a fox. I mean, that's just my gut feeling. I have zero basis in fact or reality for having that. He just seems a little bit too smart, and he's using what he knows to game the system. And this judge, God bless her, she is not going to let a mistrial happen. She's going to plow through this if it kills her. Oh, God, snowflake nightmare. That's a question. What does sovereign citizen mean even? How do we sovereign citizen easily here? Sovereign citizens are a bunch of misinformed people. It goes way back in history, where the amendments to the Constitution weren't properly adopted, so tax doesn't happen. They see themselves as their own individual countries. They've got weird. I mean, just. It is so hard to summarize what this sovereign citizen BS is all about. And the more deeply you explain it, the crazier it sounds. I mean, the whole idea is that we are part of a corporation. The government assigns us a corporate entity. That's why our birth certificate and our social security numbers are all printed in capital letters. It's part of some corporate thing. And the courtrooms will have flags. Let's see if the Law and Crime took off the flag picture, but the flags will have yellow fringe borders on them. And a couple of 100 years ago, the admiralty courts and vessels would have flags with the yellow fringe to identify themselves as admiralty courts. And so the idea is, if the judge, if she has a flag with a fringe on it, is this an admiralty court? They're nuts. I can't explain the movement cohesively, coherently, because it's not. Yeah, well, and Gino Man is saying, as stupid as it all sounds, there is actual basis in the argument. It's just been overplayed by too many stupid people. There's still no realistic basis. I mean, the things that they rely on are outdated hundreds of years ago. Yeah, you're born in the United States, your property, the corporation of the United States. That's why he's doing all this. She calls him his name. He says, well, that's not my name. Don't go down the sovereign citizen, rabbit hole. If you want some fun, just go to YouTube and Google sovereign citizens. Like their ideas, they'll tell the police that, the police has no authority to pull them over because they're a sovereign entity. They are their own country. They don't have to abide by the laws. There's something way back in the statutes, in the Universal Commercial Code in the UCC, and that allows them to travel freely on the land. I'm not driving. I'm a free man traveling on the land. And pretty much any YouTube video where you search for sovereign citizen and police, it ends with a taser being deployed. I'm sounding stupid talking about this. Yeah, I wasn't driving. I was traveling. They don't need driver's licenses. Yeah, but my Black's Law Dictionary is not law. It's a dictionary. Black's Law literally has no legal authority whatsoever. But yeah, soft sits are a riot when they don't have a license. Not so funny when it's a multiple murder case. Exactly. They're funny, witty, wacky things to put up with on YouTube videos. But when it's a serious thing like this, and that's why I think this guy does not believe the whole sovereign citizen bullshit. He's just using it to disrupt the proceedings. Yeah, the police have no authority to pull them over, but they'd stop every time. Well, there's one case that I saw on YouTube where the guy, he pulls this sovereign citizen stuff. That's not my name. I'm not part of the, the corp. That's my corporate name. Blah, blah, blah. And the judge says, well, if you don't think I have jurisdiction over this, why are you here now? If I thought that the court didn't have jurisdiction over me, I wouldn't be anywhere near the court, but you have presented yourself here before the court. So clearly you think I have jurisdiction. Let's go. Okay. And this is the other thing here. Johnny Osprey mentions the more sovereign citizens are really hilarious. There's sovereign citizens, and then there's like the level below them is the more sovereign citizens. It's a group of black sovereign citizens. They're subject to like ancient Moorish laws, and they're sort of like sovereign citizens on steroids. It's a scary, creepy thing that it's sort of equivalent to like flat earthers, where just the arguments are insane, and the more you hear them talk, the angrier you get, and the more you try to explain what their beliefs are, the crazier you sound. So the best way to deal with a sovereign citizen is, no matter what they say, go, oh, absolutely, you're absolutely correct. Have a nice day, and walk away. Well, it looks like it's taking a while for looks like we're taking a while here. The court is still out. We're still shut down, waiting for something to happen in court here. We're still live. And we'll bring that back up when something happens. Oh yeah, this guy, he wants to see copies of her oath of office, and the cops, they have to show all this. Oh, God. What makes you think he's a sovereign citizen? He said he is, and he's making the sovereign citizen arguments. His name is not his government name is not his name. He doesn't consent to this. And the one thing is, when she was reading the indictments and stuff, one thing they will always say is, when you're asked about your rights, do you understand you have the right to remain silent? A sovereign citizen will never say, yes, I understand. Their solid answer is always, I do not understand. I have been informed. I have the right to. So they don't want to. For some reason, they don't want to say that they understand that anything the court tells them. So yeah, he said he's a sovereign citizen. He uses the sovereign citizen language. I don't understand my rights. I've been informed of my rights. He asks for her oath of office. It's just bullshit. And it's so frustrating. Well, Live and Cuck just changed their screen. Not really exciting live coverage, but I guess this was to be expected. I kind of wanted it to go a little bit more today, but oh yeah, they don't consent to a suit. And again, they have this deal where they think that they don't have to talk to any law enforcement officers or anything without some sort of a contract. And that's it. I do not consent to joinder. Like I said, just Google videos of sovereign citizens and police, and they always end in tasers all the time. Always. Oh, we are back in court. We're still muted though. Let's plow through these here. Legal advice. Did he waive his right to speedy trial? Yeah, this happened last November. So pretty much, I think he had to have waived his right to a speedy trial. Otherwise, this would be taking a long time. Carlos Estrada, thank you so much. Please talk a lot. Law and Cucks is AZ's whole. Transform this into a lesson on sovereign citizen and self-representation. Point all this disruptions out. Yeah, like I said, if you talk about sovereign citizens, you're the one that ends up sounding crazy because it's so ridiculous. Yep, see, it's got the fringe on the flag. There you go. 200 years ago, this would signify like a maritime law court or a maritime vessel. Yeah, so he's probably all got his knickers in a twist about all of that. His panties are all wadded up. A-Train, if he gets booted to the other courtroom during the actual trial, this is the actual trial here. The next step is to bring the jury in and to start the opening statements. Wouldn't that be a slam dunk appeal by just arguing it prejudiced the jury? I don't see any way this ends well for the court. Well, I mean, it's not like she just put him there at the beginning. He's had plenty of opportunity to behave and do things. And when he's being disruptive, you know, the proceedings still have to commence. But like I said, my problem I have with this is that he has the right to make objections and to speak on his own behalf. And, you know, he's got the sign he can hold up for objection, but I don't know if that's enough. But what do? You got to do something. And I think she's doing the right thing. She could, I mean, she can't just say, I'm getting rid of you and you can't come into the court because he has the right to be there. It's a tough situation for her, and she's doing the right thing. I think of the best she can do. And she's got to go through with it. She can't let it go to a mistrial because that's what he wants. That's what he's trying to get here. He's trying to get a mistrial, clearly. R. Fulmer says, you know, it's really scary. This dude probably has women writing him love letters to the jail. Scary. Oh, you know he does. The close up on the empty chair. Ugh. So frustrating. A-Train. Oh, we just read that one. Yeah. I just don't know what you can do here. She's doing the best she can. Like, she can't let him stay in the courtroom if he's just going to keep interrupting. Otherwise, you'll get nowhere. And he can still hold up his stupid little sign and make his objections, I guess. Her lips look like extra filled today. Wow. Lancelot 652. Hello again. How are you? The judge went to crack open a 12-pack just to make it through court. Speaking of which, I'm locked and loaded here.
Screen, is that right? Okay.
And 2012 Jameson, if he's not in the room, is it not effective attorney? Oh, good
right, we
God.
are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the
Just wanted to pop on and thank the Vice Squad for showing the future conflict guys so much yesterday. So much love.
Court.
Hey, Stormy.
This, of
Thanks.
course, comes on the recent history with
2012
Mr.
Jameson,
Brooks.
Family Guy.
Every day that we have been in court.
Peter Topia is sovereign citizen
Monday.
example.
He has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court.
She's just putting this on the record, not telling it to the jury.
I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see
great, assaulting a police officer.
Seated with his back to the court or to the camera. Back. He took his shirt off as well. I'm also told that he is threatening to throw and break items I want to give him headphones since he has claimed in the past to be hard of hearing in one ear.
Will he represent himself as an orc?
His statement that he would throw and
Nice.
break things, unless he can pledge to this court that he will not do that. I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system.
She does this weird breathing thing with her voice.
We're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera, since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present. I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom.
I think she's just talking in really long sentences and needs to take a deep breath.
Illinois versus Allen. I've read portions
Listen
of
to her
that
sentences.
Case into
They're
the
really
record.
long.
I don't intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant.
Okay, now here she's going to talk about putting him in the other room. This should be interesting.
Has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt. I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that.
Okay, we still have to do some other shit before the jury gets in here.
If at any point in time he wants to come back and he is willing to promise, she's not
binding and gagging him because it looks bad for the jury.
Courtesy and decorum.
It can prejudice him to the jury, and she's being generous by putting him in the other courtroom.
Proceedings for all individuals in this courtroom, including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the preliminary stage prior to the
All right, we'll pull her down here a little bit. And you guys are pouring in the super chats fast and furious.
I would note it's,
thank you for all that. Pinochet's helicopter tours. I think Mommy Judge Lewinsky is rubbing off on me. She's attractive. I've seen before and after work pictures. Her before all of the face work. She looks kind of rough. She's got her lips a little bit too big for me though. She's pumped up the lips, but yeah.
I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no.
Flux, thank you. He's going to get convicted. It will go to appeal. He will get reconvicted, and this will go on. Ultimately, we all saw him plow over those people. With as much as he tries to stall, he'll be convicted. Well, that's his argument. He was kidnapped by his truck. The accelerator stuck, or the cruise control stuck, or something. Brandon Lesko, time to get hammered. As a matter of fact, it is. I need a drink.
I will further advise Mr. Brooks that his continued behavior, whether it be appearing
we need a drink.
Court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take
Kyle Mitchell. So you yeeted Nick to steal his trial coverage. You crafty SOB. That's my plan all along. And fuck YouTube for blocking Nick. Seriously.
Received a note. We need to reset the Polycom system. So I'm not sure what that means. I'll find out, and if appropriate.
Now they have to reset the communication system. Great. But yeah, someone made the joke that. Finally, I have more subscribers than Nick does.
Off the bench, we're going to take a short
too soon
recess for that.
But no, Nick, we love you. Fuck YouTube for YouTube banning Nick. And if you want to help Nick, go over to YouTube and keep the tweets alive on Twitter. Go to Twitter. Keep the while they reset their sound system. We'll bring us back up again here to show your support for Nick. Go over to Twitter and tweet at YouTube creators and at Team YouTube. Just let them know that Nick is the victim of a false flagging, that he's being targeted, that he's the innocent one, hasn't done anything wrong. Just keep the tweets alive. That's the best thing. And to make sure you're subscribed to his Rumble, that's where he's going to be at for the next few days. It sucks. We've been going through it all day today here. Just showing the support and love for Nick, because I personally wouldn't be here at all if it wasn't for Nick. I mean, Andrew at Legal Mindset was the one that got me on YouTube. He was the one that convinced me to start the channel. And for some reason, just a few days after I started this YouTube thing, Nick invited me to be on during the Johnny Depp Amber Heard trial. And then I blew up in my own little way, and literally everything I have here, I owe to Nick. And so I got his back. This is what friends do. Friends just support friends. There's, it's my pleasure to donate a little bit of my time to cancel the regularly scheduled programs, focus on Nick, show him some love and respect. He's the OG. And like I said, he's just what I have is what I owe him. God, you guys, you're just like coming way fast with the super chats. And please we've got 1,124 of you viewing now and only 380 likes. Like 1,000 of you could go down right there and hit that like button right now. Let's get to 1,000 likes here right now. Everybody just go down there and hit the like button. It takes zero time. It literally takes nothing to get this thing to 1,000 likes. And that'll put us on the YouTube radar. That'll let us know we're here. What are the Brandon Lesko says, what are the two YouTube Twitter handles? There's three you want to tweet to at YouTube, at Team YouTube, and at YouTube Creators. Keep those three in your tweets about Nick. So get down there. Let's get up to 1,000 likes. If you don't see 1,000 likes, you need to do your job and click that. And if you want to subscribe to me. I mean, I would deeply appreciate it. This is what we do. We support our friends. We cover trials. We cover legal things. Tomorrow, we're going to be having my 25,000 subscriber blowout extravaganza, where it's going to be a Nick Rekieta style grift stream. start to finish. Just going to be grifting like a madman for $100 shots. And we're just going to be having a fun time. Lots of people from YouTube I've invited to come on, from LawTube, especially LawTube adjacent, to come on and say hi. And let me thank them personally for helping me get to 25,000 subscribers in 4.5 months, which is unheard of. It takes people years to do that. So I just want to say thanks to them while I grift and get drunk. Monday, we'll be doing Maritime Monday again. And Tuesday, I'm thinking Tuesday, part of the Alec Baldwin case. We've been following the Alec Baldwin shooting case on my thing. He has settled the lawsuit with Helena Hutchins, the cinematographer's family. Some really interesting things there. So we'll get into that settlement as much as we know. It's a confidential settlement, so we don't have a lot of information. But we'll talk about that settlement and get into some of the other lawsuits that have been filed in relation to the Alec Baldwin shooting on Tuesday. So stand by on Tuesday for more of that. And Saturday, this Saturday, so the day after tomorrow, be having a special Saturday stream with Steph, the Alter Nerd. Lovely, hilarious woman. I enjoy watching her stuff. We'll be talking pop culture things. I'm sure we'll be talking more Ricada. We'll be doing a lot of things. So that's just kind of what's coming on in the next few days. So like and subscribe. Let's get the word out there to YouTube that this is kind of a fun channel to be part of. Let them know you're interested. Hit the like button, hit the subscribe, hit the notifications. You can join the members if you want to. You get all the emojis, and that's just about it. Ashton, thank you so much for your super chat. Yesterday, the judge said he will forfeit his right to objections if he doesn't cooperate. Nick didn't know how legit that was. She stated case law. Yeah, I don't know either, because he has the right to make objections. She can't just shut down his right to make objections, as far as I understand. I mean, I don't know how that would be possible. I don't know the state law. I mean, there might be something, but wow, that seems really, really dodgy. He has this right to face the accusers and to object to improper things in court. Melanie says Steph is funny. I love Steph. I know a lot of people don't like Steph, think she's too brash, but that's why I like her, because she's brash. She's fun. Yeah, Steph is great. So I'll have Steph on here. It'll be Saturday morning, really. I guess it'll be early Saturday morning for US. It'll be 8 p.m. my time. No, 9 p.m. my time, 1 p.m. Saturday London time. And so that'll be 8 a.m. Eastern time in the States is when she'll be here. Close, Vicky. Yay, love Steph. Hope it's not going to be 3 a.m. Pacific time. It'll be 9, 8, 7, 8, 7, 6. It'll be 5 a.m. Eastern time. So it's close to 3 a.m. Eastern time. Crystal says, I love Steph. Piss off, you cow bag. She's brash. And I know she rubs a lot of people the wrong way, but hey, she's great. I was gonna say she rubs me the right way, but that sounds really weird. Still waiting on the court. They're still rebooting their sound system. I'm gonna plow through 13 super chats here right now, and then probably take my second drink. Ashton, we already did this. I just don't know. Ryan, thank you so much. Yesterday, the judge explained that she had several methods of making him cooperate with the court, such as tying and gagging. Yeah, she just went through that. And to her, this is the least restrictive one. It gives him the right to participate. It gives him the right to be heard when he holds up his stupid little objection sign. But yeah, so she can do more, but she doesn't want to at this point. Flux, he's about to whip it out to the judge. He's got to turn around and face the camera to do that. Thanks, Flux. Always appreciated. Darrell Smith, at least he's wearing his mask. You got to give him that. He's conscientious. Brandon Lesko, Mr. Brooks, can you show the court if you are a shower or a grower? Solid take. Your Honor, I can't see the jury behind me, says Carlos Estrada, $2. Thank you so much for the super chat. Exactly. Screw YouTube for making Nick miss this clown show. Exactly. Screw YouTube for making Nick miss this clown show. I'll tell you my Nick story here in just a second. Some of you may have heard it on my other channel. I'm not on my other channel, my other stream I did just before I came on here. Pinochet's helicopter tours, Hannibal Lecter mask, and dolly setup available. Oh, that'd be awesome. Just strap him in, push him in on a dolly with the Lecter mask. Nice. Lamo, German sovereign citizens are called Reichsbürgers. I believe the German Empire is legit, and the 1918 revolution and governments are illegal. Oh, so you have them too. Congratulations. Ugh, they seem to be everywhere. I see they've infiltrated Australia now. And Carlos Estrada again. Thank you. Willie cosplay as the Dark Knight's Bane. Bane. Judge, it won't happen, Judge. I object. I do not consent to joinder, Judge. Sorry, that's my really bad Bane impression. I do a much better Chewbacca impression. How will / can he question himself? Oh, that should be fun. There are people that literally ask questions and answer questions to themselves. That should be fun to see. Again, this is a really freaking serious case. And there's a certain amount of levity and ludicrousness about it. But then there's the point when it becomes so funny, it's not funny anymore. And I think we're already bordering on that. And she has blocked out an entire month for this. 68 SPC, thank you so much. Can Nick sue for lost revenue from not being able to grift for his trial? Get the names of who flagged him and go after them. Very possibly. Because, see, I mean, that's the thing. If you sue someone for defamation, you have to be able to prove damages. Or if you sue them for interference with your business, you have to be able to prove damages. He has a proven track record of what he makes in an average month. And when it stops making that, he has at least subjectively provable information that how much income he has lost as a result of these actions. So yeah, he doesn't want to go to trial. Nobody wants to go to court. He just wants you to do the right thing. But yeah, if he had to bring claims against people responsible and it ultimately turned out he won, I think he has a very good chance at proving losses. So yeah. I can't find you on Rumble. Are you going to set up over there? I have set up nothing on Rumble. I'll look into it. I don't have time to do I have my full-time job and I have this thing. I don't have time to look into a lot of other things, but I'll try to do it on a weekend or something. Good morning from Utah, Benjamin Carrington. Sweet. Where are you at from Utah?
System has been reset. The information I received was that all of a sudden the audio was only going through 2 speakers and not all of them. A simple reboot of the Polycom system over there.
He's still talking to himself.
And I've confirmed that it's working properly.
Have you? So now he can hear.
Before I turn to you, Attorney Opper, because I'm not sure.
Will he try to seduce the jury?
At the very end,
hey, jury, I'm talking to you.
I wanted to make
me and my adult depends diapers.
That the record is very clear.
Look at my physique,
I will note a continuing objection.
I don't think so.
To the
Brandon, let's go.
Regarding his name and other things.
Shouldn't she eventually treat him like counsel instead of a child to prevent some skullduggery and chances of on appeals? Shot.
Do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Well, for her to treat him like a lawyer, he at least has to try to act like one.
I did want to address a
Thank you, Brendan, for the shot.
Not been raised
Always
in
appreciated.
The courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks.
Okay, she's raising the issue.
The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself.
She looks like a chain smoker.
If it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14.
Do Russians and Chinese soft sit exist? I'm sure Russians do. I don't know about Chinese.
At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case, and you made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense.
I mean, that's the problem. The bar is so low.
Went through his waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I would also add to.
That's not me. Whoa.
He is coherent. He is
all right.
intelligent. He knows
what the hell was that all about?
The issues in the courtroom.
We are buffering like a madman. Huh. All right.
Discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed.
Benjamin Carrington lived near Hill Air Force Base in Utah. Roy Perchance. I'm from Logan.
Otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written.
Your Honor, it's cold. I can't breathe and it's too cold here.
It's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency.
Oh, wow. I didn't expect that.
100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated. And the court has seen this since August 25th.
Bye, Vicky. So,
as the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks.
I didn't expect her to do this. I expected her to argue that he
at all times
has problems and that counsel should be appointed so that they can go ahead with the trial.
What happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions.
I really did think she was going to argue that he is incompetent to represent himself and needs a lawyer to represent him so that the trial would go smoothly.
To derail these proceedings.
She's just going hard on him.
Avoid the inevitable. And I want to make that record. I tell this court as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record.
Why?
That I base that on.
I don't know them. Why would I do that?
I also wanted to add
Hey, Stephen Carshay, Eagle Mountain, Utah here, where the wind was born.
As to the need to proceed with this trial, we concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get justice for the crime victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opper, and I do appreciate you raising that with the court because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit.
Even if he's mentally competent, so that, if he intends to keep impeding and disrupting, isn't that a form of incompetence?
Well. I would also add to what you have just stated.
It's getting weird, but
not two.
MD said it best.
But 4 evaluations related to the
he's just an asshole. He's not crazy. Withdrawn. He's not incompetent. He's just being an unadulterated douchebag.
Evaluations where the examiners met face to face in the jail or in a appropriate visitation.
Wisconsin doesn't have the death penalty.
Either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process.
His shirt is on the table.
And I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding. We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things, frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions.
Oh God, we don't even have the jury instructions yet.
Mr. Brooks did not file anything in writing regarding a proposed jury instruction, as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence.
Yeah, we have people watching Crowder. Nick said Nick's running a little late.
I don't have anything from him this morning.
Just wanted to say thanks for covering this, Jeff. You're a blast to listen to. Keep up the great work, brother. Free the nose. # free the nose. Absolutely. Thank you, G-Vuk.
The preliminary jury instructions with all the changes that were made yesterday.
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted. Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second. Where is the microphone? It looks like it's in front of the monitor. Mr. Brooks? Try again.
Am I on the record?
You are on the record.
There you
That's
go,
low
buddy.
now. We'll turn ours down. Mr. Brooks, do you, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday?
I didn't read them. Oh, it's a little bit of feedback.
ahead,
Harden the
answer, please.
fuck up, dude.
All right, your objection is noted for the record, and I'm just putting the mute back on. He provided that objection without any legal basis.
Yeah, you can't just say objection. You have to say the legal basis for your
I'll
objection.
be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, it's the volume is not
God
being
dang it.
appropriate at the moment.
Feedback.
There needs. Try it again, sir. I apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately working.
Yeah, exactly. I'm exasperated too, dude. They should have this thing. They should have known you're going to be sent to the next room. They should have had this shit worked out.
Take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there.
This is like amateur hour in this court. They should have known he was going to be booted out of the courtroom and had the audio ready to go. But all right, let's plow through these super chats here. We got some things to talk about. We'll do this one first here. Cherry and Max, thank you so much. Was Brooks ordered to stay at Forensic Center for competency, or was it done on appointment basis? It seems like it was done on an appointment basis from what she was just saying. It was done over the summer. And everybody that evaluated him came up with the answer that he was competent and just being a dick. Carlos Estrada, do you think his cell BF is a soft citizen? I hope they consent to joinder with each other. He's going to be there for a while. Flux, she is pissed. Everybody that has anything to do with this is pissed at this point. MD, he's just an asshole, not crazy, not incompetent, just an unadulterated douchebag. Exactly. As we said, but yeah, I know we read that before, but it flowed better that way. Tin Man, thank you so much. Just woke up, so I'm catching up with the stream. Thanks for covering this sovtard since Cucktube yeeted Nick. The fact that means something. We're part of a cult. The fact that thanks for covering the sovtard since Cucktube yeeted Nick. That means something. Congratulations there. The cameraman. Legal vices. So they have the defendant and the defendant's counsel in another courtroom as they proceed. Seems like a violation of process. No, it doesn't. First of all, he is his own lawyer. He gave up his right to have other counsel, so he is representing himself. He's being disruptive, and she explained that they have three options: binding and gagging them in court. Two was, I think it was postponing the hearings or something, and the other one is to put them in another room like this. He has the full rights. He can hold up his little objection sign whenever he needs to object. So it's not, I mean, she's doing the best. She's doing the least disruptive and the least presidential, the least prejudicial thing she can do, which is put him in another courtroom. If they bind him and gag him and you do the Hannibal Lecter mask and the straitjacket and a dolly thing, that could potentially prejudice him to the jury, give them a bad impression of them if they don't already have one. But yeah, they're just kind of basically doing the least intrusive thing they can do. Bologna Bong. Sorry, I've been missing most of your solo streams. Off topic. Do you have a good meerschaum? For those of you that aren't not pipe smokers, meerschaum is a type of stone. It's like it's a stone. It's basically stone from Turkey that's made out of sea foam. It's like sea foam solidifies into a foam. I have several meerschaum pipes. I guess we can pull this up here. That's right back there. That's my pipe rack. I've got like 19 pipes over there, and then I got a bunch more pipes up over there. So I keep my custom pipes over here. But this is the meerschaum pipe I have right next to me. This was made by a Turkish pipe carver. He's like a pipe carving master guy. I love this pipe. This is a pretty sweet little pipe. But yeah, it's actually a stone pipe made from this sea foam stone called meerschaum that comes in Turkey. Hope that answered your question. I've got lots of pretty cool. I love meerschaum pipes. They're great. Anyway, that was the answer to that, Bologna Bong. Beautiful. Thank you very much. I don't know. I'm thinking in a little bit here, I might just have to light up a cigar or a pipe or something. Scroll back up here, see what we missed. Best way to get competent mailing or to stop the BS is 6 months vacation at Forensic Institute. Yeah, that might be a commit him for a little bit. Then he'll just have to decide if he really wants to continue to be crazy or not. The judge, the prosecutor, all of the people that have evaluated him say he's just fucking around, basically. All right. I think that catches us up with the super chats. That is cool. All right. And I guess we can just, can you pop into Louder and Shouter while the trial is in recess? Nothing's happening there right now. I mean, what are they talking about right now? I'm watching it here. Oh, they're talking about the Alec Baldwin thing. I don't want to like snipe someone else's stream here, but if Nick comes on, we definitely will during the breaks. They're just kind of talking about the Alec Baldwin case. No spoilers. I want to talk about it on Tuesday. Oh God, this is a piece of work. I mean, no Nick yet, late and gay. Yeah, he's even late and gay for other people's streams, but I hope it's for a good reason. I love Nick, but Crowder annoys me. I've actually never watched their show. Maybe I'm just not cool. I've never watched the stream. So what was the story with Nick? No, I feel bad because this is kind of like a funeral with Nick's channel being yeeted. And I feel like the guy, I mentioned this on my other stream earlier. I just feel like the guy who, he fights with his wife and then she dies in a car accident. And then it's like, the last thing that he did was I called her a bitch, or, the guy, or somebody else like goes away or dies or something. And then the last thing they had was a fight, something like that, because I was burning the candle at both ends for 2 days. I didn't get a lot of sleep. I worked an entire day. Then I did my own stream. And then I had to stay up and do some things. I didn't get enough sleep. Then I woke up the next day, did the same thing, a whole day at work. My 2-hour stream went 6 hours. And then I went on Nick's stream until 6:00 a.m. my time. And then I was so tired. I woke up 2 hours late for work. And then I got to work. And then I worked a full day again. And I was talking to Legal Mindset. And I was saying, God, I'm just tired. I'm worn out. But, Pope Ricada summoned me, so I had to respond. And Legal Mindset's like, oh, come on. Your sleep is important. Nick's important, but sometimes you just got to tell Nick, no, you need to take care of yourself, take care of your sleep. And so then last night, again, I do my stream. And then I'm going to go to sleep early because I'm dead. But then I realized, I didn't watch House of Dragons. So I watched House of Dragons. Then I played with the dogs. And I finally somehow got to be 3:00 in the morning. I laid down on my bed at 3:16. And the second my head hit the pillow, Nick sends me a text and says, hey, do you want to come out and do the trial watch with me? And I sat there for a couple of minutes and went, Oh God. Yes, I want to. I don't want to say no to Nick. That'd be fun. I want to hang with Nick, but then I'm thinking Andrew said sleep is important. What do I do? What do I do? What do I do? So Nick texted me. What time did he text me? He texted me at 3:16 a.m. Says if you want to hang out for Darrell Brooks hearing, here's the link. And it took me 4 minutes, and like 4 minutes later, I'm like, okay, I should do the responsible thing. Just sleep. Just go to sleep, and then I can do it tomorrow. So I said, hey, can I take a rain check today and join up with you tomorrow? Nick says, of course. And so I went to sleep at like 4 o'clock in the morning. And I woke up a couple times just because of noise outside or the dogs or something. And I had left the trial on my phone next to my head. And I kept hearing Nick talking, and then I go to sleep. And then my alarm went off at 8 o'clock in the morning. I hit the snooze button about 4 times like you always do. But then I heard Kurt from Uncivil Law's voice. And I said, oh, I guess Nick finished his stream. I guess the hearing's over for the day. And then I remembered he said it was okay if I took a rain check, and I didn't thank him. And so I sent him a message and I did not know he had been yeeted at that point. He'd been yeeted about 45 minutes before I sent him this message. I said, oh my God, I forgot to thank Nick. And so at 9:13 a.m. my time, I sent this message that said much appreciated. And I didn't know he'd been yeeted like 30 minutes before that. I just thought his stream had ended, and then YouTube had automatically rolled me into one of Kurt's videos. And so I'm just like, yeah, much appreciated. And then I said, okay, I guess I better go back and look and see what happened on the trial. I wanted to see the trial. So I flipped back, and then suddenly I got the video's not available because the channel has been deleted. And then I just felt like utter shit. I just felt like garbage because like Nick's inviting me on. I'm like, I gotta do my thing. I'm blowing Nick off. And then I wake up and I find out he's gone. Plus I sent him this, oh, no problem. I'll hang out with you tomorrow, 30 minutes after his channel got yeeted. And I didn't know that. And I'm like, oh, fuck. So I feel like really bad. That's like, I feel like one of those deals where you fight with someone and then they die in a car crash, and the last memory you have is blowing them off or calling them a bitch or something. So I do feel really, really bad about that. But just one of those things. Now I really regret not having got out of my dumbass bed at 3 o'clock in the morning and not got any sleep. That's my story of how I found out that Nick had been deleted from YouTube. Okay, Jillian N., thank you so much. Grateful to you for the entertaining and informative coverage during President Pope's absence. Vice President C. Captain is competent, unlike other VPs. Well, that was hard to read. That was kind of tricky. And also Debbie O., you might want to call Nick and see if he's awake. They mentioned something about him just running late. He's probably doing other things, and there's more people than me to tell him to wake up. So he'll get there. Yeah, he's only 45 minutes late. That's still early for him. He'll get there. Is Nick not continuing on? He's continuing on Rumble for the time being. At least that's what he said. He'll continue to be there, and he's got his links out there in the wild. I don't have them real handy right at this second, but if you go search on Twitter for Ricada links, they'll come up with his Rumble, his locals, other things. But he said that he'll continue on Rumble for the time being until he gets things worked out. All right, just so you know, we've still got this big nothing going on here while they take their stupid recess. This is the most amateur court thing I've ever seen in my life. They're not doing anything. They should have had all this shit worked out long time ago. Crowder starts late every day. Yeah, he's on Odyssey too, but I guess his main deal is going to be on Rumble, but he'll still stream to locals and Odyssey and whatnot. Okay, Rose. Thank you so much, Rose. You're an awesome mod. She's just posted the link tree for Nick. Crowder's going to be an interview. They always do the interviews towards the end of the show. Yeah, what's that? Nick is still late and gay. Yep. Can they force the defendant to get a lawyer? I would need someone who was much more of an expert in criminal law than I am, but I'm saying generally, like in this instance, he has waived his right to a lawyer. He's waived his right to have the assistance of a lawyer, so he can't appoint one. But if they figure he's incompetent and can no longer meet the very, very basic minimum level of defending himself, they can appoint a lawyer for him. So essentially, yes. They would appoint someone to be either be on standby or to actively take over, but he still has to cooperate with that person. Otherwise you get nowhere. It's really a no-win situation. I mean, it really, the judge is in a really bad spot, and I think she is handling this remarkably well. Hey, wow. Thank you so much. Currently hyper fixated. Hashtag free the nose is trending on Twitter news, as well it should. Get those hashtags out there. Free Nick Rekieta, free Rekieta law, free the nose. Get those out there. What about, because you can be disruptive. Oh, that was the other. Yeah, that was the second one. You can either bind them and gag them so they can't be disruptive. You can, which she said, it was just kind of too prejudicial. It just looks too bad. Or you can hold them in contempt of court. Which basically is like, sentencing them to more jail. What the fuck does he care? He's going to be in jail for the rest of his life. What's another 90 days going to matter to him? Nothing. So that's not really an effective deterrent. And the third way is to do something like she's doing now. Just because you're disruptive, you can't be forced to have a lawyer if you're competent to do it yourself. See, this is a problem. These are the basic constitutional rights that we have to face our accusers, to question our accusers, to represent ourselves. But it's when you find some douche nozzle like this guy that finds a way to game the system. And to be frank, this guy's got nothing to lose. What's his worst case scenario? He's in jail for the rest of his life without parole. I mean, in his head, he's probably thinking, I may as well just have fun with it and drag this out as long as I can. Voting gag. Yeah. I mean, it can be done. I don't have a problem with it. And it would certainly solve the audio problems we're having here. This is just ridiculous. Why would they not have this already worked up? Hang him, then try him in absentia. Well, okay. It's a little harsh. I think we need to at least try him first. Wow. I got to find a way to be entertaining while the court unfucks themselves. I don't know how to do that. I was entertaining as long as I could possibly be before I started this. I was looking forward just to kicking back and chilling with you guys and reading your chats and things. Now I've got to be extra entertaining. He will be a hero in jail for this. Probably. I mean, he's got the stories to tell.
Appear to have a technical issue resolved. That issue solely concerned the audio from the microphones in front of Mr. Brooks and the two room systems cooperating, and we were having difficulty in this courtroom hearing Mr. Brooks. I believe that issue has now been resolved. All
right, I'm going to swap out my headphones.
Break for the audio issue. I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting a small cut to a finger as a result of when he was removed from this courtroom and taken to the other courtroom.
Oh, for God's
I
sake.
was further advised that there are no
He
signs
heard his
of
poor widow
blood,
Pingar.
and that when asked, he refused to show his hands. At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done. I
Hello,
also
I'm
want to
back.
make a record that Mr. Brooks has put his shirt back on. He continues.
Well, we
to
can
sit
see that. You
with
don't have
his
to make a
back
record
the
of that.
camera. Mr. Brooks, I want you to be advised that I believe it's important that you face the camera so that you are facing the court. You can see and hear. It's my understanding you were not willing to cooperate with being shackled, and for the moment, you are not. But at this point, given your conduct from before, I'm going to require, after we take the next break, that the Sheriff's Department
Boo.
put you in the chair face forward and with shackles on your ankle, as you are in custody, and that is appropriate. Now, I want to turn back to the issue with the jury instructions, Mr. Brooks. You indicated you had an objection. My
Spit
next
in that
question to you
butt.
is, what is the legal basis?
Yeah, now he's starting
for
to
the
freak out
objection? I'm
in my
going to
home, in my,
unmute so you can
laughing
answer.
my ass
Go
off.
ahead, sir.
Okay, probably.
You need to turn around so I can hear you.
The
Part of
Stalingrad
the issue is he's also
defense.
not facing the microphone, and so I need to hear him, and he needs to turn around.
God. You can do the
Mr. Brooks,
Chewbacca
I'll ask
defense.
you once again, what is the legal basis for your objection to the jury instructions?
Okay, overrule him.
Final time, sir. What is the legal
Just
basis
overrule
for
him and
your
move on.
objection to the jury instructions?
Don't play into this shit.
I can't even hear what she's saying all the way.
Bullshit.
It's too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed. There is the headset available to use should you wish to use it. If you can't hear, I would ask that you put them on. I was able to hear, he said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions.
Okay, good. We don't have to argue about the jury instructions.
That are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies.
What if any? What, if any, jury instructions do you object to?
Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity to review this document.
What if we went straight to the sentencing phase?
Based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about
disclosures. She just went full Wisconsin there.
Relief from the court. Certainly no legal statutes or constitutional provisions.
What do you think his opening statement is going to be? Oh God, hell if I know.
It just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney,
I'm sure it's going to be insane.
Anything you would want to add to the record on this? Any position you are taking?
No, I also viewed this as because he labeled it objection by affidavit. I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
Yeah, I think the judge
Then we'll
is
move on to the
explaining
motion
way
for
too much.
reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently.
Opening statement,
when
I object.
necessary. I will unmute him if the court has questions. All right, Attorney Opera, I have read through the motion. Is there anything you want to add to what you have put in your filing?
Who are you
Only
arguing
one other
with, bruh?
observation, Your Honor, that since I filed that, the events of the last couple of days, I think further support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify. And so not having their faces displayed, I think, would help ease some of that tension.
I could not
for
with
those
this guy.
individuals.
My patients are just about out here too. I'm running
Mr.
out
Brooks,
of
my
patience.
first question to you is, do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer.
He doesn't know
I'll
what you're
unmute
talking
and
about.
Provide that to me. Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed and you were provided a copy of that yesterday. We took a recess yesterday so it could be served upon you. If you haven't read it, that's your choice.
It's your
What I'm
problem.
asking you is, do you have any position on their request for this court to reconsider
What are we
the
reconsidering?
denial of the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces while they testify?
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document.
Yeah, think about it
that was
again.
provided to you yesterday. I'm asking if you have any
Oh God.
position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial.
We're getting close.
I don't understand why there would be even the need to reconsider what you already ruled on at this point, as far as to that.
Because they
To
can
that
ask to
particular
reconsider,
issue.
and they did. And now she's asking you to
take your
comment.
Public trial.
Say no
It's a
comment
public
and move
trial.
on, bitch. Space baby. He
Anybody
is
can
his own lawyer.
Essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name, that in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given,
They should
it's
just
pretty easy.
beat
for
him
them
up
to
with a
be
bunch of
found and
lawyers.
to be seen. So I mean, that's just
Dude,
the
shut
age
up.
we're in anyway, as far as with social media and Google and all these different things. We got all this technology basically at our fingertips. So I don't understand how it needs to be changed at this point when it was already ruled that this is a public trial.
Because they can ask for it
There's
to be
gonna a lot of
reconsidered, and they
things that are
did.
going to be shown. Why not keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it, made that on a record, let's keep it the way it is.
All right,
All right, thank you,
then
Mr.
just say
Brooks.
no
I
objections.
appreciate your legal analysis of that and your factual analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. There is a mechanism in the law for a party to bring a motion for reconsideration. Essentially,
What?
It requires that the party bringing the motion provide some new information or rely
The shit
on
was
an argument that the court erred as a matter of law in its prior ruling. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case. The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's SD
somebody's trying to slip into the judges.
Into the judges. 532, but I would note it's from 1965.
That wasn't me.
In 1965, I would say even in the 1980s here in Waukesha County, there was really a presumption.
The judge has got somebody on the
cameras
side.
not be allowed in courtrooms at all.
The hell was
We
that?
have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I am certainly mindful of the potential stress that it may cause for victims and other witnesses to come into court.
Do we want to pop
and
over and see
testify
Nick
and to
on
have their
Crowder, or do we want to
images
hang here?
broadcast as this trial is broadcast, not just locally, but nationally, and frankly, anywhere in the world.
Yeah, it wasn't my Skype call. I don't have Skype on this computer.
I would note, though, that prior to the point in time when this case came to trial, this court took significant efforts to keep victims' names private.
All right, this is kind of a boring thing. If you came here for
this court signed an order.
I'm sorry, but let's pop over to
Mr. Brooks
to Crowder and to watch Nick here just for a second.
That was one of the conditions set when bond was initially set.
They're just talking about whether or not to show the.
That's still a ruling that this court adopts. In addition,
they're just talking about whether or not to show the faces of the witnesses and things. Let's pop on over here for a quick second and see what's going on with Nick. Where are we?
All of the meth dealers,
Right.
Then it's really easy.
Yeah.
But if you only know like one or two and they dry up, or you get arrested too much, you have to do something else. So what I would do is
we'll just watch him for a few minutes here.
That way. Right.
I don't want to get caught
business
sniping a stream.
entity formation. I would draft contracts, review contracts, go through commercial lease agreements and all of those fun things, along with a little estate planning. So anything, any kind of, really though, it was called paycheck law, because there's anything that paid you at all. That was
Is that Johnny Depp behind you?
Yeah, that's a Johnny Depp painting by a friend of mine named Eric Waugh. He's a fantastic artist.
And Michael Myers, same dude.
Yeah, we've got no, this is a guy who has passed away. His name is Robert Hurst.
Oh, I'm sorry. I feel
well, that's awkward.
It's okay. He's great. He mostly painted sports figures, but he had this one horror painting. You can't see it all, but it's Michael Myers, it's Jason, Freddy Krueger, Pinhead, and Leatherface.
Oh, dude, that's awesome.
Yeah.
Sorry, I completely went off. I thought that was so cool behind you, so I apologize. No, that's very cool.
How dare you?
I know, right? Yeah, you enjoy my stuff, you son of a bitch. So what? So how did this band come about?
Oh well, it all started back in July.
Let's see if he knows anything now.
With my first of the 3 YouTube strikes, which was completely bogus. So if people don't know,
we've been there, yeah,
as they usually are. Gerald knows about that.
Yes.
Giving facts.
YouTube they have a policy against graphic content, and that policy states very specifically that you can't post certain content intended to shock or disgust your audience. And so I got tagged with that because I don't know if you guys remember, there was a knife fight in an Australian mall where this clip circulated a lot. These guys were kind of going back and forth, and this one guy just swipes, and the one guy, he like stands there for a minute, kind of bleeds on the ground, and then he just dies out of nowhere.
Yeah. Mm-hmm.
And so I have a 5-hour live stream, and about 4 hours and 20 minutes into it, I play this 40-second long video clip, and then I go on to comments about how senseless this violence is and how young men's pride get them into situations. that get them killed, and it's a complete devaluation of life, and it's a waste of potential. And that was deemed in violation.
I don't know. All right, we got a buffering going on here of some sort. It's being rough. I don't know how many viewers did they have right now. I can't even tell because it's buffering. Jesus, they've got 40,000 people, 39,000 people watching them. Yeah. Well, shoot, there we go. That one's buffered out. Nick just broke the internet. It'll be back. We'll pop in here again in a second. We'll keep monitoring it just for the good of society. Let's go back to this. He's talking again. Where are we?
I want to keep this trial going, and that's what we will do. So the request is denied. All right, I believe, let me just get back to my first note that I had.
I'm reopening the window here.
All of the outstanding issues.
But I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I'm
not trying to interrupt
on what I may have missed.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit to the state's response and the court's opinion and order and defendant's disclosure statement by affidavit. It's an affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record. It has been accepted. It has been filed. And that your objection is noted.
Just bring the jury in already.
Specific action as it relates to it. I further indicated that, again, no relief was requested, but also there's no statutory.
Yeah, she's talking way too much. She's trying really, really hard to make sure there's no room for appeal, but she's going extra.
I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork. I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
I don't know what 12.4 is.
All right, I'll note that for the record, sir, but it was not in your filing.
Yeah, if you're going to rely on that rule, you need to put that rule in your paper.
I believe I had one other thing. Oh, I did want to put on the record, and that is when we were testing the audio, I did advise the sheriff's department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks.
The reason,
Mr. Brooks.
I would just want to.
Hold on, I'm going to mute you for a second unless you stop and listen to me.
I just heard what you said, but I'm
not asking for a response, sir. Mr. Brooks? Okay, you're interrupting.
Mute him. Just mute him and move the fuck on.
Sir, I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being.
You have not been.
I will ask you, sir, do you want to come back into this courtroom? You've been unmuted.
I'm to that point right now. She's enabling.
Not until I can receive medical treatment for the bruise that I have.
You don't get medical treatment. That's nice.
The cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants, and you can still see the blood in the cut and a big bruise right here on my arm.
How do you treat a bruise?
The nurse would be coming in to see me And then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess. But
I want to know why he doesn't sit down.
At least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to
Keep moving.
adjournment, or I'm sorry, to take a break at this time.
I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess,
the booty goon got to him yesterday. That's why he's not sitting down.
I was told that a nurse was coming in at that time.
Probably.
But then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was,
Mr. Brooks, you made your record, okay? I don't need you to go further with that.
Both of these people like to talk a lot.
I want you to be aware, sir, I was advised regarding the cut, the bruises, new information. I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is
I'm going to try. I'm going to do as much as I can.
You are seen,
I'll try to stream as much as I can.
So I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform.
Why is everybody coddling him? If he wants to wear his orange, let him wear his orange.
To do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to.
Yeah, it is.
Just like I should be awarded the right to be present for every proceedings in this trial.
You are present.
All right. I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian.
You don't have to
repeat
it, Judge. He said it.
Right to dress in the jail attire. All right. Then with that, I am going to just take a short recess just to have the jurors brought in.
I think Mr. Brooks needs his objection sign.
We'll make sure he has it.
Mr. Brooks needs his objection sign. He's gonna hold. I need an objection sign. Oh, why don't I have an objection sign when I need one?
For a second, Mr. Brooks, when the jury comes in, I am going to read through the preliminary jury instructions. Since those have been approved by the court, if you happen to raise your sign, I'll note it for the record, but I'm not going to ask you for any type of argument on that because we've already had that opportunity to do so. It will take me some time to read through the instructions. I don't know if that will take us to the lunch hour or not. The state should be potentially prepared to go through its opening.
So did Nick finish, or is Nick coming back after the break here? Or they're done?
And you have an objection.
We'll go back and watch Nick here. That was really short.
The objection, in addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down the basis for the objection and what you're objecting to, in addition to holding up your sign. That's the procedure that we will follow.
Well, that answered that question, because just saying objection isn't enough. You have to give your grounds for objection. So he's objecting to the method for objecting. That's great. There's nothing to object to here, pal. It's over. It's a break time. I don't even know how the camera's focused on you. You're done. Stay Stina G, the judge reminds me of my mother-in-law, also from Wisconsin. Doesn't know when to shut it. Wish she just came with a mute button. Yeah, she's explaining a lot. We'll bump him out and we'll bring back up the end of the next stream here while he just rages at literally nothing. So yeah, we'll stop sharing that. We'll bring up the end of Rick's interview. Rick Nikita, my friend, Nick Ricada's interview. All right. Why is
behind you? So I apologize.
No,
that's very cool.
How
man.
dare you?
I know,
Dave.
right? Yeah, you enjoy my stuff, you son of a bitch. So what? So how did this band come about?
Oh well, it all started back in July with my first of the 3 YouTube strikes, which was completely bogus. So if people don't know,
We've been there, yeah,
as they usually are. Gerald knows about that.
Yes.
YouTube has they have a policy against graphic content, and that policy states very specifically that you can't post certain content intended to shock or disgust your audience. And 20 minutes into it, I play this 40-second long video clip, and then I go on to comments about how senseless this violence is and how young men's pride get them into situations.
No, you're not the only one.
They get them killed, and it's a complete devaluation of life, and it's a waste of potential. And that was deemed in violation of the rules.
Yeah, those are some serious headphones.
To be incorrect, because I've covered police shootings, I've covered stabbings and stuff like that on the channel plenty of times. I've never had a problem, but that was my first strike.
Wow. And yeah, then, we had that where it was a girl who stabbed, or a cop who shot a girl, preventing stabbing another girl.
Micaiah Bryant.
Yeah. Correct. Yep. Exactly. Yeah. Yep.
Yeah. And see, and I covered that one and didn't get a strike.
Yeah, so it's arbitrary.
Well, yeah, and what we were saying was, we're like, hey, I'm glad that the cop acted to save the life of another individual. We weren't celebrating that somebody died. We were just saying, like, I'm glad the police officer was there. Otherwise, that person was getting stabbed. She was in the process of stabbing.
Yeah.
Right. So, and I think that's what got us a strike.
It was it's crazy because you cover something like that. It's very clear, like, well, we don't want this person shot, but yay, good job, cop, because you saved someone's life. And I tend to do like legal analysis, or I'll bring on another guest and we'll talk about use of force and stuff like that. And so I covered that case. I probably showed that video 10 times. No issues, never. And I never had any issues with strikes around graphic violence doing that before. But it was like, okay. And so I've been working to this day on trying to get that strike removed. But I had until October 22nd. The next strike is where things get a little interesting for me. And that's I was critical of this weirdo on the internet called Keffels. Have you ever met a weirdo on the internet? I mean, they're rare.
I mean, I've only heard stories around the campfire, but I guess they exist.
Yeah. So there's this weird person named Keffels, and a strange website called Kiwi Farms, which this is such like deep internet, but Kiwi Farms is where a bunch of people with problems go and whine about like online celebrities, to sum it up in a pithy way. But people go talk about e-celebrities and have gossip, but they also collect a lot of information about them. And this particular person had a history of boasting about how they would get hormone replacement therapy, this is their words, to kids as young as 12 years old without their parents' consent. They would either help them find it from various like third world factories that would supply it without a prescription, or sponsoring a website that allegedly had a step-by-step do-it-yourself estrogen kit.
Oh, so a crime.
Yeah, I mean,
yeah. All right, I'm just stopping this here just so we can interject some other things into it, sort of break it up. So if someone does come back and start looking at the stream, this is all fair use, by the way. I'm not doing the whole thing. I'm just providing it here for commentary. This is my commentary. Let's get back into it. Again, that was just a safety pause.
Yeah, you'd say one.
Yeah, right. If you were guessing.
Right. So I very politely and very calmly on a live stream once suggested that was something that was abhorrent to society. And I used a euphemism to suggest that maybe people who harm children and do this without their parents' consent don't belong in polite society.
Right.
That was spun into, I called for the murder or execution of this person. That was the lie that got perpetuated on Twitter.
Wow.
Something I do not and have not done at all. But that is right. And so this person, part of their thing, like I guess their content creation is to get their Twitter mob to go after people who go against their agenda. And so I got billed as like this anti-trans thing, which is interesting because in the same video clip, just 10 seconds later, I said, I don't care about trans people like at all. If you're 18, you want to do whatever to your body, go ahead. Like, it's not my business. Just stay the hell away from kids, please. Like that's that's
the trial's back on.
A reasonable
She's
request.
Reading the jury instructions.
I also don't think you should be able to order by mail any kind of surgical or hormone treatment kit.
Yeah, it's like a different aside there. That's an interesting.
I don't think you should have a chemistry set when you're like 7.
Yeah, you should have to wait till 21 to drink booze, but hormone replacement therapy, whenever.
Go ahead. Here's a syringe and you guess.
And you can pick them up at the Scholastic Book Fair now.
Right
next to.
All right, we'll pop out of this and we can come back here during a break. They're not going to get into any serious details. But let's pull this back up. All right, here we go.
Lawyers and witnesses will not contact or speak with the jurors.
Okay, so
do not listen to any
so she's just basically been saying, you know,
research.
Don't make any decisions until you've heard all the evidence. Don't talk to each other. Don't talk to anybody else about it. Standard instructions.
Or visit the scene, either in person or by
don't
any
go visit the
electronic
scene.
means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any.
I've never seen Crowder, so I don't know.
Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair.
Yes, the jury can see him in the other courtroom.
To refute,
everything's linked up,
or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer,
probably better than it should be,
other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone.
Crowder is not orange.
Email, text message, instant
orange
message,
man bad,
social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter.
Yes, she's reading to the jury right now. The jury is there.
Or by other means. If anyone does so despite you telling them not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case.
The jury should be a neighbor. They should be from that area of the county, at least.
With anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report it to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant.
Yeah, don't do that. Don't do anything to give us a mistrial, jury, please.
You are to decide the case solely on the evidence offered and received at trial. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments.
That's weird, huh?
The court will provide you with the materials. In making notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations.
Yeah, see, that's the interesting thing. When the jury's deliberating, they have to rely on their memories, and they can't see that.
Primarily on your memory of the evidence and testimony introduced at trial.
Yeah.
During the course
they don't
of
get
the trial,
the
parties may refer
the
to or use
transcripts.
police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. The defendant has a constitutional right to represent himself.
This should be interesting.
I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that
the orderly administration isn't working out well.
Making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance, are expected to conduct themselves appropriately and in a manner that avoids creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. At the moment, Mr. Brooks is appearing from another courtroom. This must not influence your verdict in any manner.
Okay.
Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience.
You're welcome.
Circumstantial evidence is
yes,
not necessarily
she is reading
better
to
or
the
worse
jury
than direct evidence.
This is for the jury.
Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offenses before you may find the defendant guilty. In reaching your verdict, examine the evidence with care.
Is he just going to be placed in that other room? I think that's the best practice.
Reason and prudence.
I don't know why he's trying to figure that out, but he's welcome to come back in the courtroom if he behaves.
Every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable
Thank you for supporting Nick. Thank you.
The defendant is guilty.
Hey, he's a friend. That's what you do for friends.
If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate.
Yeah, these jury
when
instructions are
called
just
upon to
long.
act
They
in
just
the
are.
most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence.
He picked the wrong
which
day
they
to stop
believe is
sniffing
not
glue. Nice
properly
airplane reference
admissible.
there.
You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of a party, the court is not
Oh, it's very
indicating
disrespectful
any opinion
to the family.
about
He has the
the
right to do
evidence.
it. He has the legal right to represent himself.
You
But the way he's doing it is
jurors
very
are the
disrespectful.
judges
But
of the credibility of
unfortunately,
the witnesses and of the
that's not
weight
really a
of the
crime.
evidence.
But that's kind of why he's off in the other
An
room,
exhibit
because
becomes
he's being
evidence
disrespectful.
only when received
So she can
by
mute
the
him
court.
and solve a lot
An
of that.
exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges.
What are you
of the
watching? You should
credibility.
be watching me.
That
It's the
is
same thing as
the
everybody else, but I'm
believability
better.
Of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial. The witness's conduct,
This is like the most boring part
appearance,
of the
and
trial
demeanor on the witness
is
stand.
reading these things.
The clearness or lack of
So while she's
clearness of
doing
the
that,
witness's
I'm going to take this opportunity to do a little
The
midstream
opportunity the
grift here.
witness had for
We've got
observing
1,285 of you here
and
now and
witness
914
testified
likes.
about.
Get on there,
The
smash that like
reasonableness
button,
of
and
the
we can get up to
witness's
easily
testimony,
1,200
the
likes.
apparent
I know I wanted
intelligence
1,000
of the
likes, but I'm a
witness,
greedy motherfucker, and I
bias
want to get
or
up to
prejudice,
1,200
if
likes right
any
now.
has been shown.
And we've got
Possible motive for falsifying testimony.
25,876
In all other
subscriptions.
facts and
So
circumstances during
hit
the
that,
trial,
let's get to
which can either support or to
25,900
discredit the
subscribers.
testimony.
We need 24 of you just to get down there and hit that subscribe button to put us over the edge.
It should receive.
So we can have some
In your
entertainment here
determination of
during this
credibility, you
60-page
must
reading
avoid any and
of
all
the jury
bias based on
instructions.
the witness's race, national origin, religion.
We got 982 likes. We need 12 more
gender
likes.
identity,
12,
sexual
18 more likes to get us up to
orientation,
1,000.
education, level,
And we
or
need
any
24 more
other
likes to
characteristic.
subscribers to get us up to
There's no method way for you to
25,900
evaluate
subscribers.
the testimony.
Let's see how we can do. Oh,
You should
Steve.
use your common sense
Steve is our
and
newest
experience.
member.
In everyday
Steve,
life,
welcome to the
determine for
clean and
yourself the
sober tier
reliability
of
things people
legal
say to you.
vices.
You should do
Great
the
to
same
have
thing
you.
here.
Deeply appreciated. Oh, we've got 20 more subscribers, and we're up to 900. And we're well over 1,000 likes already. You guys frickin' rock. You're the best.
The
Well, now that we're at
defendant was charged
1,000,
with
our
6
next goal is
separate counts of
1,200.
first
1,200
degree
likes is the next
intentional
goal.
homicide.
We've got
Use of a
887
dangerous
subscriptions,
weapon.
25,887.
The
We
first
need
count of the
13 more to get up to
information in this case
25,900.
Darrell E. Brooks, on or
Oh,
about
you guys are the
Sunday,
best.
November
Thanks for helping
21
out.
of 2021,
Do it for the
on Main
children.
Street
I don't know what that
in the
means, but
city
do it
of
for the children
Waukesha,
anyway.
Waukesha County, Wisconsin, did cause the death of Virginia Sorensen with intent to kill that person and while using a dangerous weapon.
All right, now's the charges. This is the important part.
Contrary to sections 940.01 sub 1 sub
You can't
A,
object to the... Oh, fuck off.
939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin.
Yeah, I need to get a
statutes.
Rumble set up.
The second count of the information in this case.
Okay, this is the
charges
second
that
charge.
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin.
I need an
did
objection
cause the
sign.
death of Leanna Owen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.6
Objection, I don't
sub
consent
1
to this.
sub b of the Wisconsin statutes.
Don't be sorry for
third
swearing
count
much.
of the
We've just hit
information in this
25,900
case
subscribers. You guys are
Darrell
awesome.
E. Brooks, on or about
Thank you
Sunday,
so much.
November 21,
Next up,
2021,
26,000.
on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Tamara Durand with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The fourth count of the information in this case charges that Darrell
There's so many
Brooks,
charges.
on or about Sunday, November 21 of 2021.
All right, I can't. I'm
on
gonna.
Main Street in
I'm
the
gonna let
city
this
of
play.
Waukesha,
I have to make
Waukesha
myself a little
County,
objection
Wisconsin,
thing. This is
did
driving me
cause the
crazy.
death of
I'll be
Jane
back in 1
Coolidge
minute.
with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Hospel with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a,
Okay,
and
two can play this game.
939.63 sub 1 sub b of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with
Damn it, I
intent
wrote
to
too
kill that person and while using a dangerous weapon, contrary to section 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The defendant has entered a plea of not guilty to each one of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First degree intentional homicide,
There we go.
as defined in
Two can play that
section
game.
940.01 of the Criminal Code of Wisconsin.
Now I feel like I'm
committed by
part
one
of it.
who causes the death of another human being.
I'll make up a
with
really
the
good
intent
one
to
for
kill that
tomorrow.
person or another. Before you may find the defendant guilty of any count of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following
I'll make some
two
different
elements were
signs.
present with
This
respect
will be fun.
to that count. One, as to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's act was a substantial
It's just
factor in producing the death.
I'm bored.
Two, as to each count, the
I believe
defendant
this is what we
acted
call
with
a
the intent
standing
to kill the
objection.
victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct
Erection,
was
Your
practically
Honor. I
certain to
detest
cause
your
the death
robe. Please
of another
remove
human
it.
being.
Nice.
While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected
Brooded?
upon for
Are
a
we
week,
brooding
a
over
day,
orders?
an hour,
That's a
or
cool
for
word. We
even a
need to use
minute.
the word brooding more.
There need not be any appreciable time between the formation of the intent.
Don't understand why the
and
jury
the
can't
act.
see the transcript.
The
Why would you
intent
want
to
them to make a
kill may be
decision based on
formed at
fact
any
and not
time
memory?
before the
But you
act,
want them to use their
including the
memory.
instant
That's the
before
thing.
the
If they
act,
read
and
the
must
testimony, if they
continue to
read the
exist at
transcript,
the
it's like
time
they're
of the
getting
act.
to hear the testimony twice.
You cannot look into
So
a
it's just a
person's
thing.
mind to
It
find
is.
intent. Intent to kill must be found.
And young Luigi,
If
hey
found
there.
at
I've been
all
watching your
from the
commentary streams. Just
defendant's
wanted to say you're
acts,
awesome. Love your
words,
content. Keep up the
and
good work. Thank you
statements,
so much.
if
Thank you
any,
so much for the
and
good
from
words
all
and the
the
super
facts
chat.
and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as
Is
a
hearsay on the
circumstance
opposite side of that
to
card?
aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional
We need a what if any
homicide,
stream there.
you must answer the following question, yes or no.
Okay.
Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied,
Artard is
you
objecting
must
to
answer
jury
the
instructions.
question, no.
He's objecting to jury instructions that he said at the
If you are
beginning of the
satisfied
trial
beyond a
today. He had
reasonable
no
doubt that
objections
both
to.
elements of first-degree intentional homicide have been proved as to count one, you should find the defendant guilty of first-degree intentional
I don't know of any
homicide
time limits
as
for opening
charged in
statements.
count one. If you are not so satisfied, you must find the defendant not guilty as to count one. If you find the defendant guilty of count one, you must answer the following question, yes or
Thank
no.
you.
Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count two, you should find the defendant guilty of first-degree intentional homicide as charged in count two. If you are not so satisfied, you must find the defendant not guilty as to count
Dave, they
two.
picked the jury. This is the beginning of
find
the
the
trial.
defendant
She is
guilty of
reading
count
these
two, you
instructions
must
to the
answer
jury.
following
When she
question,
finishes,
yes
they'll
or
probably
no.
break for lunch.
Did
Then
the
they'll have
defendant
opening
commit
statements.
crime
The
of
trial is
first-degree
on.
intentional homicide while using a dangerous weapon.
She's lost her place. She has to start over again.
If
Oh,
you are
God, no.
satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count three, you should find the defendant guilty of first-degree intentional homicide as charged in count three. If you are not so satisfied, you must find the defendant not guilty as to count three. If you find the defendant guilty of count three, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count four, you should find the defendant guilty of first-degree intentional homicide as charged in count four.
Now he's in the other
If you are
courtroom.
not
He's
so
he's
satisfied, you
he's
must
still-
find the defendant not guilty as to count
he's
four.
still objecting
If you
and
find the
being
defendant
all
guilty
around
of count
annoying.
four, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide?
Answer
while
me
using a
these
dangerous
questions
weapon?
3. What
If
is
you
your
are satisfied
name?
beyond a reasonable doubt that both elements of first-degree intentional
What
homicide
is your
have been
quest?
proved as to count five, you should find the
What is your
defendant
favorite
guilty
color?
of first-degree intentional homicide as charged in count five. If you are not so satisfied,
Jennifer Foley, I want to
you
run
must find
myself
the
over now.
defendant not
Seriously.
guilty as to count five.
Be like that guy that played Chekhov in the
If
Star
you
Trek
find the
movies and
defendant
kind of
guilty of
accidentally run
count
over
five,
himself.
you must answer the following question, yes or no. Did the defendant commit the crime of first degree?
I sent you the email with the Mouse
homicide
Utopia
while using a
research stuff. Oh
dangerous
yeah,
weapon?
cool. Thanks. That's weird.
If you are
Also, these
satisfied beyond a
people.
reasonable doubt
Also,
that
there are
both
people on
elements
Twitter
of
saying they're going to
first-degree
try and
intentional
find the
homicide
jurors for
have
this
been
trial.
proved
Don't
as to
do
count
that.
6.
Fucking
You
leave
should
the
find
jurors
defendant
alone, people.
guilty of first-degree intentional homicide as charged in count 6. If you are not so satisfied, you must find the defendant not guilty as to count 6.
No,
If you find
they
the
read
defendant guilty of
they
count
read
6,
these
you must
preliminary
answer the
jury
following
instructions to
question,
tell the
yes
jury
or
how
no.
they have to act
Did the-
during the
Did the
trial.
defendant commit the crime of
And then at the
first-degree
end, they
intentional
really
homicide
they
while
do the
using a
final
dangerous weapon?
the final. These are the preliminary jury instructions. Then they do the final jury instructions at the end.
The defendant is charged with 61 separate counts of first-degree recklessly endangering safety, use of a dangerous weapon. The 7th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Nicole White under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 8th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eleanor Anders under circumstances which show utter disregard.
I just texted Nick and asked if he was able to come on the stream
life
after Crowder. He said that
using a
he can't
dangerous
because he
weapon,
has to teach.
Contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 9th count of the information in this case charges that
He's getting all, I want to see the
Darrell E.
manager
Brooks,
hands on the
on
hips
or
thing
about
here.
Sunday, November 21.
Yeah,
of
61 counts.
2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger
61
the
counts and we're
safety
on
of
count 8.
Sasha Catalan Castillo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 10th count.
What the fuck is he doing?
Oh
my God.
Charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of
awesome.
Waukesha,
gotta
Waukesha County,
do-
Wisconsin, did recklessly
Oh
endanger the
God,
safety
that's
of
beautiful.
Laura Gilchrist
I have to take a picture of
under
that.
circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30
Oh Christ, he's
sub 1,
insane.
939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes.
Oh
The
Lord.
11th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Justin Gullickson under circumstances which show utter disregard for human life and while using a
Check this
dangerous
dick,
weapon,
Your Honor.
contrary to section 941.30 sub 1,
This can't be serious.
939.50 sub 3
Flux,
sub
Flux.
F,
This is
and
why I'm watching it, for these little
939.63 sub
moments.
1 sub B
I'm
of the
not expecting
Wisconsin
any Perry
statutes.
Mason moments, any great
12th
moments
count
in
of the
legal history. I'm just
information
watching
in
it for
this
those
case
little bits of
charges
silliness.
that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Harry Guilfoyle under circumstances which show utter disregard for human life and while using a dangerous weapon.
Dangerous
Contrary
weapon.
to section 941.30 sub 1, 939.50
Are we sure this isn't just a massive punk? Thanks, Fluck. Yeah, like was it Ashton Kutcher? Was that who did the punk show? It's going to run out. You've been punked.
In this case, charges that Darrell E. Brooks, on or about Sunday, November 21.
Oh yeah, position that. Just rest it on your dick root.
In the city of Waukesha.
Just rest the sign on your dick root so it stays centered.
The safety of Aiden Loughran under circumstances which show utter disregard for human life and while using a dangerous weapon. Contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 14th count of the information in
we're up to 14 now, only like 40 something to go.
E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Theo Maza under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
Your Honor, I erect.
Of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main
Crystal $1.99. Thanks so much for the super chat. Hashtag Panzer Objections.
Did recklessly endanger the
objection, Dick Cheese. No.
Circumstances which show utter disregard for human life and while using a dangerous weapon. Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 16th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Connor Tank under circumstances which show utter disregard for human life and while using a dangerous
He's got crazy
weapon,
pants.
contrary to sections 941.30 sub 1,
He's not even listening to anything she's saying. Neither am I to be. I'm not either.
939.63 sub 1 sub B of the Wisconsin statute.
It's going to be a long haul. For any of you that are sticking around for all of this, God bless you. This is the roughest part of trial.
Sunday, November 21.
This is really and this is absurdly long because there are just so many charges she has to read through. There is literally nothing we can do other than sit here and
show utter disregard for human life,
talk and make fun of things and jam signs down our pants or whatever.
Section 941.
Brian Dawkins, he ran over the dancing grandmas
939
and ruined Christmas. He's worse than Satan.
And 939.63 sub 1 sub B of the Wisconsin statutes.
He didn't do it. The car did it. The car was possessed. He was trapped and he was a prisoner in the car.
Darrell E. Brooks,
ass clown,
on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adelia
Schwanzwurzel
under circumstances which show utter disregard for human life and while using a dangerous weapon.
What is his defense? It seems to be that the car kept him captive. The car just did it.
The 19th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street.
Exactly. It's the Christine defense.
Waukesha County, Wisconsin, did recklessly endanger the safety of Kelly Graybow.
Get fire shooting out of the car.
Circumstances which show utter disregard for life and while using a dangerous weapon. Contrary to sections 941.30 sub 1.
He's done. He's checking out.
50 sub 3 sub F and 939.63 sub 1 sub B of the Wisconsin statutes. The 20th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Josh Craner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 21st count of the information and charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street.
Are the chairs allowed snacks? They should for this. Yeah, give him like some of the Johnny Depp gummy bears or whatever the hell he was eating.
Rogers under circumstances which show utter
Ooh,
disregard for
the Bruce
human
Jenner
life
defense.
and
Yeah, the
using a
runaway
dangerous weapon.
vehicle defense.
Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
I think I'm texting Nick. I think I'm tempting him. I said, everybody's calling for it. He said, the people are demanding the Pope. He's like, I really wish I could. I said, well, I sent him a picture and said, well, he's just jammed the objection sign down his pants. And Nick's asking me, well, how long are you going?
21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Caden Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F,
He just said, send
and
me the link.
939.63 sub 1 sub B of the Wisconsin statutes. The 23rd count of the information in this case charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, should recklessly endanger the safety of Tucker Sparks under circumstances which show utter disregard for human life and while using a dangerous
He said he might
weapon.
try to pop in, but it'll be later because he's got things to do.
939.50 sub 3 sub F, and
Just send a picture of the
939.63 sub 1
defendant
sub B
jamming
of
a
the
sign
Wisconsin
down his pants.
statute.
That'll get people
The
here.
24th count of the information in this case charges that
The jury
Darrell
can't
E.
find him
Brooks,
insane.
on or
That is
about
not one of the
Sunday,
charges. He is not.
November 21,
His original
2021,
plea
on
was
Main
guilty
Street
by
in the city of
reason of
Waukesha,
insane. Was guilty, but
Waukesha County,
but
Wisconsin,
by
did recklessly
I'm not
endanger
sure.
the safety of
I'm not
Isabella
sure what it is in
Bartell
Wisconsin.
under
It's either
circumstances which
not
show
guilty
utter
by reason of
disregard for human
insanity or
life
guilty but
and while
insane.
using a
Whatever that was. He was
dangerous
pleading
weapon.
insanity
Contrary to
until about a
section
month ago. Then he changed his
941.30
plea to
sub 1,
sane. So the jury can't find him insane
939.50
at this
sub
point.
3
That
sub
that
F,
train has
and
left the insane building.
939.63 sub 1 sub B of the Wisconsin statutes. The 25th count of the information
Oh,
in
yeah.
this case
We're making a new
charges that
thumbnail.
Darrell E. Brooks on or about Sunday, November 21 of 2021.
We'll make a new thumbnail of him
on Main
jamming the
Street
objection
in the
sign
city
down
of
his trow.
Waukesha County, Wisconsin, did recklessly endanger the safety of Yuritsa Sarah Montez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1.
It's boring for us to listen to, but can you imagine being this poor judge and having to read all 60 whatever the hell pages are of all this repeated information? She can't, she can't just shoot the shit and jackjaw like we're doing here.
Of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin.
Isn't it very difficult to get off on insanity? Hey, I get off on
Samantha
insanity all the time.
under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 9.
She's probably way more bored than we are.
939.5.
She needs some water. Get the judge some water.
939.63 sub 1 sub B of the Wisconsin statutes. The 27th count of the information in this case.
Never mind, too
charges
easy.
that
Move along.
Darrell
I'm not
Brooks
even
on
going to
or
say
about Sunday,
that.
November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Madison.
If we're being honest,
under
had to use the sign because he forgot his Baldo.
Using a dangerous weapon, contrary to
Wait, where'd it go?
sections 941.
Oh, can't find the comment. Something's like, oh yeah, here we are. Let's be honest. She loves the sound of her own. She does talk a lot. She loves the sound of her own voice.
0.63 sub 1 sub B of the Wisconsin statutes.
Oh, Kira Veer, check DM for possible thumbnail. Sweet. All right.
Charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mackenzie Hollingford.
I'll find a use for that. Thanks. That's pretty good.
Which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1.
What are you writing, dude?
939.50 sub 3 sub F and 939.63 sub 1 sub B of the Wisconsin statutes. The 29th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mitchell Lampine under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F.
Oh God.
939.63 sub 1 sub B of the Wisconsin.
He's working on a tell-all book called If I Had Done It.
The 30th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main
Frack
Street
says, I got to
in
be
the city of
honest,
Waukesha,
the Midwest
Waukesha
mommy
County,
vibes. I'm
Wisconsin,
starting to.
did
I'm
recklessly
liking this.
endanger
I'm
the safety
yeah.
of Kathleen.
She's smashable. I'd
Hillmeyer
smash.
under circumstances which show utter disregard for human life and while using a
Greedy
dangerous
bloke
weapon,
halfway through.
contrary to sections 941.30.
Yeah, the car was
sub
carry.
1,
We've talked about that. It's the
939.50
carry
sub
defense.
3 sub F and 939.63 sub 1 sub B.
Summary of what's going on. She is reading 60 pages of jury instructions. She's setting out what he's charged with, which is basically 6 cases of first-degree homicide and about 60 cases of hurting people with a car. And she's just got to she's got to slog through this. There's nothing. She's just got to do it.
Of Julia Shulicow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
Oh, we're going to be on jury instructions for a
The
while.
32nd count of the information.
32nd count. There's 61 counts in there. They're on 32, so there's a while to go here. Strap yourself on, and if you haven't done so, hit that like button. I wanted to get up to 1,200, and we're already at 1,184, so that is awesome.
Endanger the safety of Olivia Stover.
I guess we need 16 more, and that'll get me up to 1,200. And as far as subscriptions, all right, we can do this. Right now, I have 25,923 subscribers. I need 77 more to get up to 26,000. Hit that like button. Let's get 77 more subscriptions. Let's see if we can get me up to 26,000 subscriptions before she finishes these jury instructions. That would be awesome.
Of 2021 on Main Street.
Bill Nice, thank you so much. The past 24 hours have been crazy, but my 86-year grandmother was just wheeled off in an ambulance. Oh no. I would have asked Nick to have a drink for her at Free Ricada. Well, I will do that for you with the Elijah Craig small batch.
939.50 sub 3 sub F and 939.63 sub 1 sub B of the Wisconsin
Bill Nice.
statutes.
Your grandmother has been a major part of your life, clearly and obviously. My father is 87 years old. I know the older generation, they're living on borrowed time, but that is exactly what borrowed time is borrowed. May your grandmother have much more borrowed time. May the Maker continue to give her that additional time to enjoy the remainder of her life. May she enjoy your company, your pleasure. May her health improve, and may you enjoy your time together. Do not take a minute for granted. Do not take a second for granted. Love, peace, harmony, and blessings to grandmother.
941.30 sub 1, 939.50
Thank you, Billy Nice.
sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 35th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Alice Euro under circumstances which show utter disregard for
She
human
takes a
life
drink.
and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
That was my first cheers I've ever done on
count
stream.
Of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did
He's writing, "That's
endanger
not
the
my
safety
name."
of Charlotte Urell under circumstances which show utter disregard for human
The
life
problem with
and
Mommy
while
Judge
using
is
a
that she
dangerous weapon.
has a
Contrary to
ton of
sections
makeup. How will you react when you wake up in the
941.30
morning and
sub
find a
1,
different person in bed with you?
939.50
Oh, I don't plan on
sub
sticking
3
around
sub
till morning.
F,
That's a smash and dash.
939.63 sub 1 sub B of the Wisconsin statutes.
Bill Nice, thank you,
The
everyone.
37th count
I'll let her
of
know
the
that you're sending
information
her
in
love
this
and
case
cheers.
charges that
Love
Darrell
and
E.
cheers to her,
Brooks,
and
on or about
love and cheers and
Sunday,
peace to you
November
too, Billy
21
Nice.
of 2021, on Main Street in the city of Waukesha,
Brian
County,
Dawkins.
Wisconsin, did
Has he been to
recklessly
trial for the
endanger
other
safety
things he
of
did
Vivian
that day
Darrell
that week?
under
What else
circumstances which show
did he
utter
do that day
disregard
that
for
week?
human life and while using a dangerous
Isn't like
weapon,
killing 6
contrary
people and
to
hurting 60 others
section
enough?
941.30 sub 1, 939.50
No one will ever pronounce
sub 3 sub
Waukesha
F,
wrong ever
and
again. Yeah.
939.63 sub 1 sub B of the Wisconsin statutes. The 38th count of
Yeah,
the information
I'm the
this
interim
case
president here
charges that
until
Darrell E.
he comes
Brooks,
back.
on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha.
She's a little
Waukesha
bit
County,
past the
Wisconsin,
halfway mark,
did
Kiki.
recklessly endanger the safety of Grayson Urell under circumstances
Maud
which
Allen,
show utter disregard for
26K
human
for
life
Fuck It
and while
Friday.
using a dangerous weapon.
Yeah,
Contrary to sections
congrats to my Maud
941.30
Allen,
sub
who's been a
1,
member for 2 months.
939.50 sub 3 sub F, and 939.
Statuesque miss. Seriously, damn, why can't people just act right?
Wisconsin
Seriously, if you just
statutes.
acted right, we wouldn't be here
The
today.
39th count.
Yeah,
of the
pump and dump,
information
smash and
in
dash,
this case
ejaculate and
charges that
evacuate.
Darrell E. Brooks, on or about Sunday, November
That wasn't
21 of
exactly the words I
2021,
used.
on Main Street in the city of Waukesha, County, Wisconsin, did recklessly endanger the safety of Lola Hospital under circumstances which show utter disregard for human life and while using a dangerous weapon. Contrary to sections 941.30.
also a member for 2 months. Completely off topic. Videos emerged online of a Chinese drone acting as a mini dropship for a robot dog armed with a machine gun. What the
40th count of the information in this case.
Please send me that video.
On or about Sunday, November 21,
A Chinese drone acting as a mini dropship for a robot dog armed with a machine gun?
Waukesha County, Wisconsin, did recklessly endanger the safety of Tamara Rosentretter under circumstances which show utter disregard for human life.
No.
And while using a dangerous
Don't
weapon.
need to evacuate first. I have blown the tracks.
941.30 sub 1, 939.5.
Hey, Floppy X Turtle for 2 months. Hey, 2 months. Let's go.
0.63 sub 1 sub B of the Wisconsin statutes. The 41st count of the
20 more to go.
In this case charges that Darrell E. Brooks.
Yeah, just give him some Amica cream for those life-threatening bruises he was suffering as he was being drug out of court for being a dick.
Waukesha County, Wisconsin, did recklessly
that's actually my favorite episode of Black Mirror with those damn dogs.
Disregard for human life and while using a dangerous weapon. Contrary to sections 941.30 sub 1, 939.50
the sign is tilting. It must be cold in the other
sub 1 sub B of the Wisconsin statutes.
Nice.
That
was a good one.
The information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main
that was
Street
good.
in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maria Alvarez Dominguez under circumstances
funny.
which show utter disregard for human life and while using a dangerous weapon. Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 43rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Georgia Romelia Perez under circumstances
We're getting there.
which show
We're
utter
getting
disregard
through.
for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 44th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Elliot Hallmark under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.6
American Dreamer.
sub B of the Wisconsin.
Will you be our cardinal
statutes.
bishop? Nah,
The
I'm
45th
already
count
the
of the
interim
information
law
in
tube
this
president
case
apparently
charges
for
that
some fucking
Darrell
reason.
E. Brooks,
I don't need to
on or
bring
about
real.
Sunday,
I'm an ordained
November
minister
21
though,
of
so I can
2021
like
on
you know
Main
be
Street
like the
in city
minister
of
level.
Waukesha, Waukesha County,
Don't know if I
Wisconsin,
want to be a
did
cardinal or
recklessly
that sounds
endanger the
that's too
safety of
that's too
Benjamin
much
Hallmark
responsibility, and
under
you have to like
circumstances
children
which
a
show
lot.
utter disregard for human life and while using a dangerous weapon, contrary to
Hey, Judge, I got your dangerous weapon right here.
30 sub 1,
Hope Strickland, thank you so much for being the newest
939.50
member.
sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
The
The
Wisconsin
46th
statutes.
count of the information in this
Oh,
case charges
wow, and
that
Hope Strickland has
Darrell
joined
E.
the
Brooks, on
the
or about
bent
Sunday,
halos and
November
broken
21,
wings mid-tier
2021,
level. Thank
on
you
Main
so
Street
much.
in the
Ooh,
city of Waukesha,
that gets you
Waukesha County,
access to
Wisconsin, did recklessly
certain
endanger the
high-level
safety
only
of
streams. Now I just have to
Patrick
start doing
Pepe
high-level
under
only streams.
circumstances which show utter disregard for human life
Thank you so
and
much,
while
Hope.
using a dangerous weapon, contrary
50
to
more subscriptions
sections
to get me to
941.30
26,000.
sub 1,
I'm at 25,950
sub 3
as
sub
we
F, and
speak.
939.63
Let's get me up to 26,000 because
sub 1
why
sub B of
not?
the Wisconsin statutes. The 47th count
Members
of
get
the
Snapchat.
information in this
Snapchat gets
case
my
charges
member.
that Darrell E. Brooks,
Just saying.
on or about Sunday, November 21 of 2021,
We got 1,300
Main
likes
Street,
going. We
in
can
the
get to
city of
1,500
Waukesha,
likes and
Waukesha
26,000
County,
members, and I'll
Wisconsin,
shut up.
did
I swear to
recklessly
God, I'll shut up
endanger
for the rest of the night.
safety of Lori Loken under circumstances
MM,
which
you sent
show
the video
utter
to my email.
disregard for human
Cool.
life and while using a dangerous weapon.
We'll definitely watch that
contrary to
tomorrow.
Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63
No, that doesn't help, Southstar.
sub 1 sub B of the Wisconsin statutes. For a moment, I just want everyone to stand.
What? What the fuck? What are you doing? This is weird. What is she doing? What? I don't understand. Why is a judge telling people to stand? 40 more and we get to 26,000. You guys rock. I know she's trying to wake them up, but it's like, I want everyone to stand. It's like she was doing some weird cult. She should just say, like, take a few minute break, shake it out, you know, just stand up for 30 seconds. We'll, you know, we'll sit back. Like, I want everyone to stand. It's kind of creepy. Oh, she's got mommy's special medicine going there. Pop those meth tablets. Jason Gould, you are now the newest member. You have replaced our newest member. Welcome to the clean and sober tier. Glad to have you here. All right. Go away, Darrell Brooks. Holy crap. Whew. Well, I'll be curious to see if she takes a lunch break. I'm assuming she's finished with the preliminary instructions. Yeah.
The eighth count of the information in this case charges that Darrell E. Brooks, on or about Sunday,
Never mind, we're back.
November 21 of 2021 on
That was
Main
weird.
Street in In the city of
Yeah, I was
Waukesha,
expecting him to
Waukesha
sit down
County,
when she said
Wisconsin,
stand up
did
too.
recklessly endanger the safety of Marisol.
Oh,
Lopez
unfortunately,
Gutierrez
Wisconsin doesn't
under
have the death
circumstances which
penalty.
show utter disregard for human life and while using a dangerous weapon, contrary to
32 away
Sections
from
941.30
26,000 subscribers.
sub
Get down there, hit that subscribe button.
939.50 sub
And
3 sub F,
160 away
and
from 1,500 likes.
939.63 sub 1 sub B of the Wisconsin
Hit that like
statutes.
button, hit the subscribe
The
button. Let's
49th
do it.
count of the information in this
Don't do it
case
for Nick, do it
charges
for
that
me.
Darrell E. Brooks, on or
Just
about
grifting.
Sunday, November 21 of 2021 on Main Street in the city of Waukesha.
How do you
Waukesha
pronounce that
County,
again?
Wisconsin, did recklessly endanger the safety of Attire Lopez Rabolar under circumstances
29.
which
We're
show
29
utter
away.
disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1.
She's getting tired.
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 50th count of the information in
I
this
hope so.
case charges that Darrell E. Brooks, on or about
No death
Sunday,
penalty, but they have
November
Chandler
21,
Halderson. Yeah.
2021
And they'll have
on
Taylor
Main Street
Business
in the
coming
city
up
of
soon.
Waukesha County, Wisconsin, did recklessly endanger the safety of Juan Marquez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 51st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21, 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin,
I just like
did
saying
recklessly
Waukesha.
endanger the safety of David
It's
Marquez.
like this kung
under
fu noises you used to
circumstances
make when you're a
which
kid.
show Utter disregard for
Waukesha!
human life and while using a dangerous weapon,
Just saying.
contrary to
22 away from
sections
26,000 members.
941.30 sub 1, 939.50 sub 3 sub F, and
21.
939.63 sub 1 sub B of the Wisconsin statutes. The 52nd count of the information.
Oh, she's
in this
standing too.
case
It's a
charges that
standoff. Get it?
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County,
I
Wisconsin.
didn't know. I know she's
did
been standing the whole time, but
recklessly
it just kind
endanger
of
the
registered. They're
safety
both
of
standing.
Mitchell under
What the fuck is he
circumstances which
objecting to?
show utter
Everything.
Disregard for human life and while using a dangerous weapon, contrary to sections 9.
We're just objecting to everything.
Sub 1.
Why not?
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 53rd.
Kyle Mitchell,
count
no
of the
death penalty, but
information in
Dahmer
this
is
case
gone. We
charges
have
that
Vase.
Darrell E. Brooks,
Yeah.
on or about Sunday.
Dahmer could munch on him, but maybe Taylor, Chandler Halderson can get to him.
Waukesha County, Wisconsin, did recklessly endanger the
This is what
safety of
narcolepsy feels like.
Jason Ketchloff under circumstances which show utter
Crystal,
disregard for
are you
human
real?
life and while using a dangerous weapon, contrary to section 941.
One of my peeps has narcolepsy. Is that you?
939.50.
I keep forgetting. I know Nick does.
939.63
But yeah.
sub 1 sub B of the Wisconsin statutes. The 54th count of the information in this
54th.
case charges that Darrell E. Brooks,
Only 7
on
more.
Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Margaret Pachulis under circumstances which show utter disregard.
Oh yeah,
for
it
human
was
life
you, Chris.
and while using a
So this is
dangerous
what it's
weapon,
like, huh?
contrary to
Well, that
sections
sucks.
941.30 sub 1, 939.50 sub 3 sub F, and 939.
Ooh, we'll talk about the Baldwin. We'll talk about the Baldwin
statutes.
incident on
The
Tuesday of
55th
next
count of
week.
The information in this case
It's
charges
interesting.
that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger. the
Did you hear
safety
yesterday the
of
judge is
Yamilet
willing to remove his
Peralta
ability to
Alvarez
cross-examine
under
if he doesn't comply with the
circumstances which
rules?
show
Do
utter disregard for
you think
human
there will be a
life and while
mistrial and
using a
redone with a
dangerous weapon.
lawyer? I don't think there will be a
Contrary
mistrial.
to
I think she is going to see this through. She is determined not to have a mistrial. But I don't I don't like this idea of removing his ability to cross-examine people. That is such a fundamental right to confront your accusers. That I don't. I know yesterday she quoted state law and things that said she could do that, but it still seems really, really odd to me because that is such a fundamental right.
Of Alin Perales Alvarez.
So it's weird to me. It's something doesn't sit right. But again, I'm not a criminal lawyer and I'm not a Wisconsin lawyer. So, I mean, maybe it's a thing. 985. We are 15 subscriptions away from 26,000. Grift. Go. And 1370 likes. So we're what, 130 away from 1,500.
Darrell E. Brooks, on or about Sunday, November 21 of 2021. On Main Street in the city.
Yeah, this is excruciating.
County, Wisconsin,
yeah, we're all here with you, Jeff. Loyal masochists, probably.
Yeah. Alvarez. Under circumstances,
we're coming to the end. So God, God bless her for that.
And while using a dangerous weapon.
What if he just refuses to? He doesn't have to confront them. I mean, he can say, "Yeah, I have no questions for them," or he can go off the damn rails and question him for 60 years.
The Wisconsin statutes. The 58th count of the information in this case.
Yes, this is just weird. You can't.
Sunday, November 21 of 2021 on Main Street.
It's a weird thing.
Waukesha County, Wisconsin, did recklessly endanger the safety.
No, he said he will try to pop on later, but if he does, it will be later.
And while using a dangerous weapon. Contrary to sections 941.
During lunch, I've got a couple of videos of sovereign citizens being tased by police officers. Maybe we'll watch some sovereign citizen videos during the lunch hour.
This case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of
Hollywood, Wisconsin. Here, I wish we had firing squads. Utah has firing squads
under circumstances which show utter disregard.
I think Utah is one of either the only or one of the only 2 or 3 states that still have a firing squad.
939.50 sub 3 sub F and 939.63 sub 1 sub B of the Wisconsin statutes. The 60th count of the information in this case charges that Darrell E. Brooks.
Yeah, Utah has lethal injection and firing squad.
On Main Street in the city of Waukesha.
If I remember,
County,
like,
Wisconsin,
the state of Washington has hanging still.
Of Camila Perez Gonzalez under circumstances which show utter disregard for human life and while using a dangerous weapon. Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63.
We are at 989. We are 11 subscribers away from 26,000 subscribers, which is funny as shit because we're also about 17 hours away from my 25,000 subscriber celebration, but I'll have 26,000 subscribers before we celebrate 25,000. That's funny.
Using a dangerous weapon. Contrary to sections 941.30 sub 1.
9 left. We're at 991.
Sub 3 sub F,
and 1394. We got like 100. We need 100 more likes and 9 more subscribers. Then I'll shut the fuck up.
This case charges that.
Well, I won't shut the fuck up. I'll just shut the fuck up about that.
21 of 2021.
Nice.
In the city of Waukesha,
Garrett Pace is old. You are old, brah. Awesome caveman reference there. By snoo.
And while using a dangerous weapon. Contrary to sections 941.
Solid reference there, brah. That is great.
939.50 sub 3 sub F and 939.63 sub 1 sub B of the Wisconsin statutes. The 63rd count.
Ringo Starr.
In this
awesome
case
movie.
Charges that Darrell E. Brooks, on or about Sunday, November 21.
Charles Argo, number 2.
Well,
thank you very much. Hi from South Africa.
Waukesha County, Wisconsin.
I have just had a game of golf when she started and have finished. Oh my God, I hope it was only 8 holes. Nick's nose looks like a revolver butt. Just kidding. 26,001 subscribers. Thank you so much, everybody.
The 64th count of the information in this case charges that Darrell E. Brooks,
you guys are awesome. Thank you so much for that milestone.
Main Street,
now I'll shut up about subscribers because
County,
I'm happy.
Did recklessly endanger the safety of Lily Green under circumstances which show utter disregard for human life and while using a dangerous weapon. Contrary
Yeah,
to
unfortunately, Snoo Snoo is an
941.30
old
sub 1,
reference. We're old.
939.50 sub 3 sub F, 939.63 sub 1 sub B of the Wisconsin statutes. The 65th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Brindley Harris under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50.
Oh, never mind. Wow.
939.63 sub 1 sub B of the
That's that
Wisconsin
Nelson
statutes.
Mandela thing. Snoo Snoo is from
66th
Futurama.
count of the information in this case,
The old
charges
movie
that
Caveman.
Darrell E.
The
Brooks,
old movie
on or about
Caveman
Sunday,
was
November
apparently
21
Zug
of
Zug,
2021,
not Snoo
on
Snoo.
Main Street in the city of Waukesha, Waukesha County, Wisconsin, did
Yeah,
recklessly endanger the safety
Click out
of
was-
Kelsey Knapp under circumstances which show utter disregard
Yeah,
for human
yeah,
life and while
oh.
using a dangerous weapon.
Yeah,
Contrary to
okay.
Sections 941.
Snoo Snoo is not that old. It's still fairly young. But yeah, there was an old movie with Ringo Starr, like Caveman, and they referred to it as Zug Zug. Snoo Snoo was from Futurama. Sorry.
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Owen.
You're right. I corrected myself. Zug Zug was from Caveman. Snoo Snoo is from Futurama.
For human life and while using a dangerous
Flux
weapon,
got called into a matter.
Sections 941.
What did I miss? Oh, nothing. She's still reading the damn comments. But we have got up to 26,003 subscribers because all of you are freaking awesome. Thank you so much for that.
The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First degree recklessly endangering safety as defined in section 941.30 sub 1 of the Wisconsin statutes is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of any count of first degree recklessly endangering
Wait, is she still talking?
The state must prove by evidence which satisfies you beyond a reasonable doubt that the following.
I swear to God, I won't be talking this much when the actual trial gets underway. I'm just trying to stop myself from self-deleting here.
Of another human being. 2, as to each count, the defendant endangered the safety of another by criminally
Zog with Sean Connery. Don't forget General Zod from the original Superman.
Means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable.
I have double the viewers of Legal Bites,
and
the
defendant was aware.
I didn't know she was streaming.
Created.
I feel special.
The unreasonable and substantial
Legal Vices for the win.
Risk of death.
What you gonna do when Legal Vices runs wild on you?
Great bodily harm means injury which creates a substantial risk of death.
I don't have a Rumble yet. People are clamoring for it. I should get one.
Disfigurement, or which causes a permanent or protracted loss of impairment of the function of any bodily member.
I don't personally have anything against Legal Bites. She hasn't done anything wrong to me, but she'll probably be on my stream for a little bit tomorrow, just so I can say thanks to her, because in my early days, she had me on her stream for a bit, so I want to say thanks to her. Charles the Hammer, thank you so much. Congratulations, Legal Vices, on the subscribes. You deserve the success. Oh, I don't deserve anything, but I'll take
Consider
it.
these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was.
I think driving your car into traffic, into people, is pretty dangerous.
And all other facts and circumstances.
I was hoping to buy you and Legal Minds a drink when I was in Korea.
The information
hit me up if you're ever
not
here.
Only that the defendant committed the crime.
Anybody in Korea gets a free drink or two from me.
Safety, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which.
That last part, I don't remember that in the movie.
Intended to be used is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of
Hyperion,
a
which is
crime
also a
of first degree,
fantastic book.
recklessly endangering
Hyperion is one of my
safety,
favorite books.
you must
Hyperion became a
answer the following
YouTube member.
questions, yes.
Welcome,
or no.
Hyperion, to the Halos and
Section
Broken
1
Wings
question
level.
per count. Did the defendant commit the crime of first degree, recklessly endangering
What about a Korean
safety
hooker?
while
Can we get
using
one
a
of them?
dangerous
Oh my
weapon?
gosh.
Before you may answer this
Oh no, he's
question,
claiming he
yes,
wouldn't be claiming he
you
wasn't
must
driving
be
the vehicle.
satisfied beyond
I guess he'll just probably just
doubt
he's
that the
probably just
defendant
stick to his
committed the
claim that
crime
he
of
just
first degree.
magically ran into the people.
Recklessly endangering safety.
I just got a message saying that my stream was restricted on Opera server. I have no idea what that means. Oh well, whatever Opera server is. I literally have no idea what that
While
means.
using a dangerous weapon. If you are not so satisfied, you must answer the question no. Let me just read that one more time. Before you may answer this question, yes, you must be
Well, Lady
satisfied
Adam's guy,
beyond a
you should come.
reasonable doubt that the defendant committed the crime of first degree, recklessly endangering safety.
She said that she just woke up and doesn't have any idea what's going on, and she needs to look at it. That's the last I heard. Oh, great! I've apparently been restricted on a web browser I've never heard of. I feel so saddened. But hey, at least I'm getting blocked by something. It's a browser owned by the Chinese. Not sure if that's it. All right. All I know is Opera is a browser that the CCP has their fingers in. Ew, I don't want any Chinese with their fingers in me. That's gross. I'm sorry, Judge. Can you please repeat that?
Tell you what, I'm gonna let you all stand while I figure out if there's a typo in my instructions because I want to make sure I read them correctly. So go ahead and stand while I do that.
See that weird? That's just weird to say. Go ahead and stand. I can just say like if you want to stand up for a bit. If you want, this weird. You must stand. It's kind of weird. I use Opera to watch my porn. Says execution. Okay. Opera is the bastard child of Firefox. That sounds really bad. Firefox sucks. Please. Yeah, she's Catholic. That's why I could never like really become Catholic. I mean, I went to a lot of Catholic church services, masses, and things, but it was the stand up, sit down, kneel down, sit down, stand up, talk to this person you don't want to talk to the other person you don't want to talk to, stand up, sit down, kneel down. It was like exercise, but good stuff. Actually, the Catholic Church in Logan, Utah, the St. Thomas Aquinas Parish, was the one that got me drinking. They introduced this young innocent Mormon boy to the glories of alcohol, because every Christmas, like every winter quarter, we were on a quarter system back in the university there. Like every winter quarter, the St. Thomas Aquinas Student Center would have hot buttered rum during the study weeks, and I would just go there with my friends and they're like, here, try this. I'm like, ooh. And that hot buttered rum was so good. I got like so liquored up the entire study week. Well, Jorison, thank you. I'm putting this $10 on a forehead tattoo of objection written backwards tomorrow. Nice. That's solid. So yeah, thanks to the Catholic Church for introducing me to alcohol. Can you write objection in Korean too? Oh yeah. We should make the Korean signs, like English and Korean signs.
Start over with the use
Jesus
of
juice.
Weapon.
Nice Michael Jackson reference there. Jesus juice. Oh my God, yes, that is the Catholic Church. I had no idea as a kid that every church was like that.
Safety, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means.
Thank you for
serious
picking up the
bodily
slack of that
injury.
shyster lawyer. That
If you find
shyster
the
lawyer.
defendant guilty of a
Will you be
count
doing the
of
whole? I'm going to be doing
first-degree
as much of this as I
recklessly
can.
endangering safety,
I mean, I still have my other
you
job,
must
my other
answer the
stream.
following question, yes
I mean,
or no.
I still want to do my other stream, but I
Did
don't
the
want to do like
defendant commit
2
the crime
gigantic
of
streams in a
first-degree
day. So
reckless
I've
endangering
got to kind of
safety while
figure out what I
using a
want to
dangerous
do.
weapon?
I just hope Nick comes
Before
back
you may
soon so he
find-
can do this and I don't have to.
Before you may answer the
But,
question,
I mean,
yes.
I may just
You must
suspend
be
my normal
satisfied
streams.
beyond
I
a
don't know. I
reasonable
literally
doubt
just need some time
that
to
the
think what's
defendant
going on.
committed the crime of first
I didn't
degree
ask for this. I just
recklessly
stepped.
endangering
I just stepped into
safety
it.
while using a dangerous weapon. If you are not so satisfied, you must answer the question no. If you are satisfied,
My sister lives
beyond a
in
reasonable
Heber
doubt
City
that
and
all
teaches
three
in Park
elements of
City in
first-degree
Heber. I'm assuming you mean
recklessly
Heber.
endangering safety have been proved as
Yeah, I was
to
just in
count
Park
7,
City a couple
you
months
should
ago.
find the defendant guilty.
This isn't Catholic
of
Church. It's a
first-degree
courtroom.
recklessly endangering safety as charged in
Oh,
count 7.
never forget about hot
If you
buttered
are
rum.
not so
Yeah, St. Thomas
satisfied,
Aquinas there, the
you
student
must find
center,
the
that hot
defendant
buttered
not
rum back in
guilty
college.
as to count
That was
7.
good.
If you find the defendant guilty of count 7, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon?
I got your dangerous
If
weapon
you are
right here.
satisfied beyond a reasonable
I fully
doubt
support
that
this
all
judge
three
annoying
elements
him
of
at
first-degree
all the
recklessly
time.
endangering safety have been proved as to
Brandon
count
Lesko, what
8,
is the meaning of
you should
life,
find the
Jeff?
defendant guilty
Life, the
of
universe, and
first-degree
everything is
recklessly endangering
42.
safety as charged in count 8. If you are not so satisfied, you must find the defendant not guilty as to count 8.
Yeah, OJ is going to be
If
at
you
least
find
next
the
week.
defendant guilty of count 8, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering
Exactly.
safety while using a dangerous weapon?
Smart people.
If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 9, you should find the defendant guilty of first-degree recklessly endangering safety.
We're done
as
with the
charged in
charges.
count
Now
9.
we're going. I don't know
If
what
you
the
are
hell we're
not
doing
so
now.
satisfied, you must find the defendant not guilty as to count 9. If you find the defendant guilty of count 9, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a
Oh,
dangerous
Christ. She's not
weapon?
going to do this for all 61 people,
If
is
you are
she?
satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering
Oh,
safety
no.
have been proved as to count 10, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 10.
Oh, my God.
If you are not so satisfied, you must find the defendant not guilty as to count 10.
I quit. I'm not
If
doing
you find
this.
the defendant guilty of count 10, you must answer the following question, yes or no. Did the defendant commit the crime
Thankfully,
of
I don't
first-degree
sleep a lot.
recklessly
I'm good for
endangering
4 or 5
safety while
hours a
using
night.
a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 11, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 11. If you are not so satisfied, you must find that the defendant not guilty.
She's read the
as to count
charges. Now she's
11.
going through and dealing the,
If you find the
how you
defendant guilty
determine
of count 11,
whether.
you must answer the following question, yes or no.
Oh, God.
Did the defendant commit the crime of
This
first-degree
is never
recklessly
gonna
endangering
end.
safety while
Christ.
using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety
What is
have been
6 times
proved as to
7?
count 12, you should find the defendant guilty of first-degree
Yeah,
recklessly
this is the
endangering
jury. The
safety
jury
as
is sitting
charged
there
in
listening to
count
this
12.
going, oh,
If you are
God.
not so satisfied, you
Yep,
must
she
find
is
the
reading this to
defendant
the
not
jury.
guilty as to count
No,
12.
the first time she was telling you
If
what
you
the
find the
charges
defendant
were.
guilty of count
Now she's
12,
telling
must
you
answer
how
the
to
following
determine.
question, yes or no.
Yeah, you have to answer
Did
this
the
question.
defendant commit the crime of first-degree recklessly endangering
So then she's going through the
safety
questions
while
you have to
using a
ask for
dangerous
each one of the
weapon?
charges. Oh, God.
If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 13, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 13. If you are not so satisfied, you must find the defendant not guilty as to count 13. If you find the defendant guilty of count 13, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 14, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 14.
The highest I saw, he had 26,000. The highest that I saw.
Defendant not guilty as to count 14. If you find the defendant guilty of count 14,
oh Christ, this is the absolute. I mean, this she has to do this.
Did the defendant commit the crime?
I mean, she has to do this. This is just the problem that happens when you have 61 different charges. You just have to go through all of
doubt that all three elements of first degree recklessly endangering safety have been proved as to count 15. You should find the defendant guilty of first degree recklessly endangering safety as charged in count 15. If you are not so satisfied, you must find the defendant not guilty as to count 15. If you find the defendant guilty of count 15, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using
I'm just going to take a nap
weapon?
here. Wake me up. Somebody wake me up when she finishes. I just want to get a little bit of rest here while I can.
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as 16,
boy, I actually made myself tired there for a second.
Guilty of first degree recklessly endangering safety as charged in count 16. If you are not so satisfied, you must find the defendant not guilty as to count 16. If you find the defendant guilty of count 16, you must answer the following question, yes or no. Did the defendant
have this memorized before she finishes?
First degree recklessly endangering safety while using a dangerous weapon?
Why do I want to jump out of a moving vehicle? Why do we all want to jump out of a moving vehicle?
All three elements of first degree recklessly endangering safety have been proved as to count 17. You should find the defendant guilty of first degree recklessly endangering safety as charged in count 17. If you are not so satisfied, you must find the defendant not guilty as to count
Objection.
17.
Reading through all the charges is prejudicial to my case.
Count 17, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 18, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 18.
Wow.
If you are not so satisfied, you must find the defendant not guilty as to count 18.
This is not making work go by faster.
Find the defendant guilty of count 18,
Seriously.
You must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon?
This is one of those never-ending stories.
Beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 19, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 19. If you are not so satisfied,
he's looking at a little boo-boo on his finger.
As to count 19. If you find the defendant guilty of count 19, you must answer the following question, yes or no. Did the defendant
need a baloney bong? Baloney bong is a good name, isn't it?
Endangering safety while using a dangerous weapon. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering
I'm going to say my finger is starting, my hand is starting to hurt from just resting on my mouse for the last 8 hours.
Endangering safety as charged in count 20. If you are
There's
not
44
so
more charges to go.
Find the defendant not guilty as to count 20. If you find the defendant guilty of count 20, you must answer the following question, yes
Can a
or
juror
no.
ask her to repeat what she just said at the end and
see
if DB will just do permanent sleep by cop?
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 21, you should find the defendant guilty of first degree recklessly endangering safety.
It's the song that never ends. It goes on and on, my friend.
If you are not so satisfied, you must find the defendant not guilty as to count 21. If you find the defendant guilty of count 21, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 22, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 22. If you are not
pretty
so
much is the song that
satisfied,
never ends,
you
isn't it?
must find the defendant not guilty as to count 22.
Well, there's bologna
If you
and a
find the defendant
bologna.
guilty
You know, it's
of
a,
count 22, you must answer the
it
following
depends on who
question,
I'm
yes or
talking
no.
to. We
Did
say
the
bologna
defendant
back
commit
in
the
Utah,
crime of
bologna
first-degree
everywhere else.
recklessly endangering safety while using
This
a
is how
dangerous
fucking
weapon?
bored we are. This is how
If you are
fucking
satisfied
torturous
beyond a
this is.
reasonable
We're
doubt that all
discussing the
three elements of
pronunciation of
first-degree recklessly
bologna or
endangering
bologna.
safety
Because
have
remember
been
the
proved
Oscar
as to
Mayer
count
song,
22,
My Bologna
you should
has a
find the
first name.
defendant
It's
guilty of first-degree
OSCAR.
recklessly endangering safety as charged
My
in count
bologna has
23.
a second name.
If you
It's
are not so satisfied,
MEYER.
you must find the defendant not
So,
guilty
you know, there's the
as to count
bologna
23.
argument, which is shockingly
If you
more
find the
interesting than what
defendant
she's
guilty of
talking
count
about right
23,
now.
you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that
I'm
all three
about to
elements
shoot
of
black
first
tar
degree
heroin
recklessly
lady.
endangering
Come on.
safety have been
She's
proved
got to
as
do it.
count
Okay.
24, you
Yeah, we
should
have
find the
bologna
defendant
here. So
guilty
we have
of
bologna and
first-degree
bologna. Ah,
recklessly
see, here we go.
endangering
We're going to
safety
start a
as
war.
charged in count 24.
See, that's what I always
If
called
you
it
are
too
not
when I
so
was a kid.
satisfied, you must
I was just
find
called
the
it
defendant
bologna.
not guilty as to count 24.
See, we have bologna,
If you
bologna.
find the defendant guilty
Fuck
of
you, it's
count
bologna.
24, you must answer the following question, yes or no. Did the defendant
It's
commit
spelled
the crime
bologna,
of
but it's
first-degree
pronounced
recklessly
bologna.
endangering safety while using a dangerous weapon?
Yeah, see, that's the camp I'm in, but everyone else can be Mimi's smart. Oh.
If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 25,
She's wearing out.
you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 25. If you are not so satisfied, you must find the defendant not guilty as to count 25.
I'm bored, so I'll do this.
If you find the defendant guilty of count 25,
red
you
hair?
must answer
Who's got
the
red
following
hair?
question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied
wear
beyond a
her out?
reasonable doubt that all three elements of first-degree recklessly
See, she needs to
endangering
get on
safety
with this.
have
We're
been
just
proved as to count
degenerating slowly
26,
but surely
you
here.
should find the defendant guilty of count 26. If you are not so satisfied, you must find the defendant not guilty as to count 26. If you find the defendant guilty of count 26, you must answer the following question,
What,
yes
if any,
or no.
jurors
Did
are
the
going to fall
defendant
asleep?
commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 27, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 27. If you are not so satisfied, you must find the defendant not guilty as to count 27. If you find
Oh my
the
God,
defendant
we're only on
guilty of
27?
count 27, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 28, you should find the defendant guilty of first-degree
All right, we put up
recklessly endangering safety
we put
as
up
charged in count 28.
the poll. Bologna, how is it pronounced? Bologna or bologna?
If you find the defendant guilty of count 28, you must answer the following question, yes or no.
Then what?
Did the defendant commit the crime of first-degree
Then what is the proper
recklessly
pronunciation of
endangering safety while
champagne?
using a dangerous weapon?
So is it?
If
Is
you
it
are
pronounced
satisfied beyond a
Bolane?
reasonable doubt that all three elements of first-degree
See,
recklessly
champagne,
endangering safety
bologna.
have been proved as to count 29, you should find the defendant guilty of first-degree recklessly endangering safety.
Ricaita's interview is behind a paywall.
If you are not so satisfied,
Hopefully,
you
we'll
must
be able to
find
get the
defendant
Ricaita
not
himself
guilty
here
as to count
later.
29.
later.
If you find the defendant guilty of count 29, you must answer the following question, yes or no. Did the defendant commit the crime of first degree?
Champagne. I don't think champagne is the way to do it.
Weapon. If you are satisfied beyond a reasonable doubt that all three elements of first degree
fuck the defendant. What crime did I commit? And why is this my
you
punishment?
should find the defendant guilty of first degree recklessly endangering safety as charged in count 30. If you are not so satisfied, you must find the defendant not guilty as to count 30. If you find the defendant guilty of count 30, you must answer the following question, yes or
Cognac.
no. Did the defendant commit
Please
the
return to
crime of
school and
first
study basic
degree
English for
recklessly
pronunciation
endangering
assistance?
safety while using
I don't
a
think
dangerous
bologna is English.
weapon?
I think it's Italian.
If you are satisfied beyond a reasonable
Brandon
doubt
Lesko
that
in the
all three
house,
elements of first
dropping the
degree
shot
recklessly
break.
endangering safety
This shot
have been
break is.
proved as to count
All
31,
right,
you
we need
should
to do it
find
in
the
our
defendant
radio
guilty
announcer
of
commercial
first-degree
voice.
recklessly endangering safety
This
as
shot break
charged
is
in
brought
count
to you by the
31.
Brandon Collective. Throw
If
up a
you are
good
not so
toast before we
satisfied,
all fall
you
asleep.
must find the defendant not guilty.
To Brandon
as to
Lesko.
count 31.
Another
If you find the
$100
defendant
towards my
guilty of
liver
count
replacement
31,
fund.
you must answer the
Thank you so
following
much.
question, yes or
I'm
no.
expecting a great
Did the
Brandon Lesko
defendant
Collective
commit the
show up
crime of
tomorrow
first-degree
on
recklessly
my Fuck It
endangering
Friday
safety
drunken
while using a
grifty
dangerous
25,000 subscriber stream.
If you are satisfied
Cheers.
beyond a reasonable
We'll see
doubt
you all
that
there
all three elements of first
at
degree recklessly
8
endangering
a.m.
safety
Eastern,
have been proved as to count 30,
1 p.m. London, and 9 p.m. Korea for my 25,000 subscriber drunken griftathon, even though I already have over 26,000 subscribers. So that's the ultimate Fuck It Friday when we're not even celebrating anything that's real anymore. Cheers.
Guilty as to count 32. If you find the defendant guilty of count 32, you must answer the following question, yes or no.
Worcestershire
Did the
sauce.
defendant commit the
Or
crime
Worcestershire
of first-degree
sauce.
reckless endangering safety while using a dangerous weapon?
I've got your dangerous weapon right here.
If you are satisfied beyond a reasonable doubt that all three elements
Replay
of
crew,
first-degree
how do you fix a
recklessly
bruise?
endangering
Amica cream.
safety
Yeah,
have
we
been
made that
proved
joke
as
like
to
3
count
hours ago, but you
33,
won't know that until you
you
go
should
ahead
find
for
the
3 hours and
defendant
20
guilty
minutes.
of first-degree recklessly
So
endangering
check back
safety
in
as
3
charged
hours
in
and
count
20 minutes,
33.
Hunter, when you can see
If
that
you
we've
are
already
not
made that
so
joke.
satisfied, you must find the defendant not guilty as to count 33.
All right.
If you find
According
the
to our
defendant
poll,
guilty of count 33,
300
you
and
must
oh, we're still
answer the
going. I'll let it
following
run for a
question,
while. Why the
yes
hell not?
or no.
I don't care.
Did the defendant commit the crime of
Worcestershire
first-degree
sauce.
recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three
Leicester.
elements of first-degree recklessly endangering safety
I said
have been
Leicester.
proved as to count 34,
I left for 10 minutes,
you
came
should
back
find
on
the
count
defendant
32.
guilty
Gee, yeah, we're
of
halfway
first-degree
through.
recklessly endangering safety as charged in count 34. If you are not so satisfied, you
I'd
must
rather
find
die
the
by
defendant
PowerPoint.
not guilty as to count 34. If you find the defendant guilty of count 34, you must answer the following question, yes
Now the
or
jury's
no.
like, what the fuck
Did
did
the
we get
defendant
into?
commit the
Oh my
crime of
God.
first-degree recklessly endangering safety while using
The
a
jury
dangerous
deliberations
weapon?
should probably take about 6
If you are
seconds.
satisfied beyond a reasonable doubt,
But
that
it's
all
going to take
three
him like
elements of first-degree recklessly
584,000
endangering
hours to
safety
go
have been
through and
proved
answer
as to
all these
count
questions,
35, you should
talk
find
about
the
all
defendant
61 of
guilty
these charges,
first-degree recklessly
sign
endangering
all,
safety as
answer all of the
charged in count
questions on
35.
all of the jury sheets
If
and
you are
sign
not
their
so
names on.
satisfied,
How do you have to sign your
must
name
find the
61
defendant not
times?
guilty as to count 35. If you find the defendant
Rosie said you
guilty
clipped
of
that
count
part and put
35,
it
you
on
must
Twitter.
answer
What
the
part?
following question, yes or no.
What part did you put on
Did the
Twitter?
defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable
I'm not satisfied
doubt
with
that all
anything
three
that's going on in
elements
this trial so
of
far.
first-degree recklessly endangering safety have been proved as to count 36, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 36. If you are
Pretty
not
much.
so
That's what I'm waiting
satisfied,
for
you
tomorrow.
must find the defendant not guilty as to count 36. If you find the defendant guilty of count 36, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly
There you go.
endangering
Brittany's
safety
got it.
while
Just give me the
using a
W
dangerous
sauce.
weapon? If you are satisfied beyond a reasonable doubt that all three
Well, see, now this
elements
is the
of
idea. Like
first-degree
bologna,
recklessly
bologna. You have like the
endangering safety have been
lasagna,
proved
but
as
you
to
do have
count
the
37,
bologna.
you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 37. If you are not so satisfied,
seriously,
you must find the defendant.
Brandon, let's go. Can't you just ask if he ran over a bunch of people?
If you find the defendant guilty of count 37, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? Ladies and gentlemen of the jury, I still have many pages of my jury instructions yet to read to you. However, it's 11:54, and I would like to break, at least for the jurors, to have lunch. I have some legal issues I do need to take up with the parties, but when you come back, the court will continue where we left off with the jury instructions.
How much do we have left?
The jurors are excused for lunch. At least an hour for them. It might be more. I'm not sure. It depends on when we break.
At least an hour? Oh my God. So what time is your show tomorrow in American Legal Vices? It'll be 8 a.m. Eastern time. So 5 a.m. Pacific. Oh my Lord. Oh yeah, Irish names. You just don't screw around with Irish names. The Irish and Welsh, just don't even try. Oh, yeah, he took the sign out of his pants. That's no fun.
All right, thank you. Be seated.
She needs to do her OnlyFans stream. All right, let's see if something interesting is going to happen here. I doubt it, but let's see.
As I indicated prior to bringing the jury in, because of the process that was utilized for this court to approve of the jury instructions, and Mr. Brooks was provided with opportunities to object and provide input, I would not be taking a break or acknowledging, at least at that point on the record, any objection to those. Nonetheless, he held up his objection sign for much of the reading of the preliminary instructions.
You're waist deep in this, Jeff. Nobody likes a quitter.
I received a note. I don't consent to that name. It is not me. It is
90
not
pages.
my name.
I thought it was 60.
Oh,
fuck me.
As it is my right. His objection is noted. I'm not going to take any further argument on that for the reasons I've already stated. At 10:48 a.m., he sent another note. Are you going to acknowledge my objection? What law are you citing when you cite
Siobhan. I know
intent?
Siobhan. Yeah.
How do I know it's what the law
That's a normal one.
says?
That's a normal spelling. That's a normal
Again,
Irish name, Siobhan.
Mr. Brooks to document number 244, the waiver of right to attorney form. This court is under no obligation, and in fact,
she wears just like
give him legal advice,
just like delicate crotchless panties.
Oh
fuck, dude! What are you objecting to?
He was provided with a couple of different copies of the jury instructions. There was an original set, and then there was the set with the modifications. All of the instruction numbers are left in the jury instructions. There was a discussion on the record yesterday about access to jury instructions, even though this court is under no obligation, and explained that to him during the colloquy regarding the waiver of counsel, that I could not make any assurances about access to legal materials. I note he has his objection sign up. His objection is noted. But at this point, I'm still reading through these objections. I don't plan on having the parties make any additional comments regarding the jury, the preliminary jury instructions.
Are you sure this judge is not a guy? This judge is hot.
Opportunity.
She's like Judge Mommy. I like her.
Discussion prior to the court's approval. Mr. Brooks, I will once again advise you that you are welcome back into this courtroom.
The judge is trying so hard.
If you are able to conform your conduct,
maybe too hard,
to the rules of courtesy and decorum, that you have been previously.
Well, she's doing what she has to do. She
advised
cannot do anything else.
Once again, direct your attention to SCR Chapter 62, Standards of Courtesy and Decorum.
Hot lips, hot lips Houlihan. This is Judge Hot Lips Houlihan.
Also direct you to Illinois versus Allen. That's the case I've been relying upon for the procedures that have been employed.
She's wearing a green mankini. No. Stop it.
Mr. Brooks is holding up the objection sign. I don't have anything in writing, which is the procedure that I told him he needed to follow in terms
objection.
of
not enough liquor.
Objections. So if he wants to write down what his objection is, and we'll file that.
I'm lucky because speaking of Irish names,
if appropriate, I'll take that up after the break, but at this point I will be breaking for
Judges a Smoke Show,
the noon hour.
Yeah,
for the lunch hour. It's 12 noon. Let's be back here at 1 p.m.
And he also have the opportunity to change into his street clothes if he wants during the lunch break.
Absolutely, during the lunch break, I'm told, will be seen by jail medical staff for the concerns that he's raised. He
for his little
boo-boo. Given
the
opportunity to change into his street clothing, should he choose. And
She-Hulk. It's like Judge She-Hulk.
Back once again, invited back into this courtroom should he choose.
Oh, she does. She has nice hair. And she just put a little too much filler in, like pre-trial filler in the lips.
Jury instructions. Mr. Brooks did not appear to be in any physical pain or medical distress. He's been moving around freely.
Shut up and go to lunch.
Reading his documents. Actually behaving quite appropriately, standing quietly, oftentimes with his hands folded, and at times listening to the court, and at times it appears he's working or looking at materials on his table.
All right, thank you. I appreciate that. We are in recess.
Thank you.
He's playing Sudoku. What does it matter to you? You got a paper cut on his crank or something? That's wrong. Stop it. All right, Brandon Lesko and his not enough booze objection. Whew. They're becoming harder to swallow. That's what she said. Ooh. Yeah, thankful. Oh, God, we got another hour here. Ugh. So what time is it in the rest of the world? I guess it's 1 p.m. Eastern time. It's a noon Central, so she's going to lunch. All right. Oh my God, we've got an hour to kill here. What the fuck are we going to do for an hour? I need people here. Where is everybody? Everybody must be having like a normal day at work or something. I've sent messages out. Nobody's answering me. Oh, that's funny. Wow. All right. Well, we're getting our way through these jury instructions, and that's just one of the things you've got to do. Nice thing there you got in your head. It's just one of those things you got to do. And unfortunately, there was 61 charges in this case. So she's got to go through this for everybody. Every single charge has to be gone through. There is literally nothing that can be done about this. And how many people are here right now? Jesus, there's 1,400 of you that are still. We got way over 1,500 likes. That's awesome. All right. How are we doing on our Bologna and bologna thing? 17% say Bologna. 83% say bologna. So I guess bologna wins. Congratulations. Bologna for the win. I pronounce it wash your sister sauce. Nikki Taylor, shame on you. Shame on you. Tin Man, thank you so much here for the super chat. If the judge was next to Andrew, he would look like Attorney Tom. She makes Andre the Giant look average size. Now, I will tell you, I met Andre the Giant. How weird is that? I was in middle school, and me and my friend, we were huge into wrestling back when I was in middle school. And when I say huge, I mean huge. We wanted to start an illegal high school professional wrestling thing. That's how into professional wrestling we were. And we'd actually stage professional wrestling matches in the locker rooms in the afternoon. But we got some free tickets to an amazing wrestling match in Salt Lake City. And his mom took us to it. And we were right on the corner where the guys came out of the locker rooms to go into the dressing room, from out of the locker rooms to go into the ring and then back into the dressing rooms. And for some reason we got tagged to do like a meet and greet. And this was middle school, so I would have been 13, 14, and got to meet Andre the Giant. And there was a lot of people there. Andre the Giant, Hulk Hogan, Adrian Adonis, King Kong Bundy, Bob Backlund, Tommy Wildfire Rich, the Freebirds. It was a fucking epic. There was a big battle royal night. But I will tell you, as a 13-year-old kid, standing, Andre the Giant is the fucking largest piece of human flesh I have ever set eyes on in my entire life. I mean, you literally can't describe how big Andre the Giant was to me. I mean, he was just a fucking huge mountain of a human being. But that was like way cool. And I'll never forget the Von Erichs. Yeah, the Von Erichs were always. Are we going to go into like wrestling for an hour? Oh, we'll definitely pull up some Sovereign Citizen videos. I'm sure there's nothing monetized about this channel right now. So yeah, we'll do that. You met him with Hulk Hogan and Kamala the Ugandan giant at the Tacoma Dome in the early 80s. See, mad scientist, you're old as shit too. The one that Adrian Adonis was kind of sick that night, so he kind of wussed out. But the one I wanted to meet that didn't show up, there was just a no-show, was the Great Kabuki. They like breathe the green shit in people's eyes. There is nothing better than like 80s wrestling. Kamala the Ugandan giant. And I think like the Kamala the Ugandan giant, he was like from Detroit or someplace like that. Godzilla wins easy. Oh, wait a minute. Oh, what was that? The law and crime just went down. All right. That was wild. I just got buzzed. I'm 2 shots down. Stop it, Brandon. Oh, all right. Definitely. We got all the Brandon. Definitely not Brandon. Certainly not Brandon. Never will be Brandon. We've got that one. Oh, I have an idea. Oh, that was your idea? Oh, fuck off. Don't do that. Save this for tomorrow, please. Please save this for tomorrow. Don't do this to me. All right. We have to talk about wrestling here first. Then I'll do these drinks. Then we'll get back into because I know literally nobody gives a shit about wrestling, like 1980s wrestling, but it was fun for me when I was a kid. Godzilla wins. Okay, there we go. There's the other thing here. The judge's level is a couple of steps above ground floor, so it makes her look taller. Yeah, we know that, but still, it's kind of good to think of her. She's like a giant She-Hulk. How many of the 6 bottles are left? Care to elaborate what brands they are? 6 bottles. Which 6 bottles are these? I brought 5 bottles back from the States. I bought 6 recently. If you're talking about the 6 I bought recently, God, I can't remember what there was like some Wild Turkey, Buffalo Trace, Elijah Craig, I think. Some rum, maybe Ardbeg, Wee Beastie, and I can't remember what number 6 was, but yeah. Tomorrow for the we'll get to here. Vice's backyard. No, I wasn't a backyard wrestler. I was it was like me and my friend Wade. We would just do like fake wrestling matches in the locker room after actual real wrestling practice. Ric Flair, woo! Inconceivable. Andre was apparently really nice. I mean, but he was just like the biggest mass of human flesh. Like Seriously, it was just favorite pro wrestling finisher. Oh, Jimmy Superfly Snuka, hands down, man. Just doing the big top of the rope, top of the cage, just the big dive, doing the Superfly, boom. Oh, hell yeah. Or Mr. Wrestling 2 would always like do the sleeper hold and yeah. Andre the Giant was like, he was like 7'4", 7'6", weighed like 500 pounds, but he was just fucking huge. Just ungodly big. I didn't have a wrestling name. Lucha Libre. Dude was legit massive as fuck. Yeah, no, seriously. He was legit a giant. He was 7'2". The 9th wonder of the world with Gordon Soley on Georgia Championship Wrestling. Yeah, we got cable in my hometown when I was 8 years old. And it was Georgia Championship Wrestling. Yes, King Kong Bundy was in Time Bandits. Don't touch it. It's evil. He'll be too drunk and late for the show tomorrow. No, I'm doing pretty good. I'm going to stick with this as long as I can. As long as I get a few hours sleep, then I can take a nap at lunchtime, and then we'll be good for the Fuck It Friday stream, and we'll see what happened. Junkyard Dog. Yeah, Junkyard Dog was the shit. Kamala Harris. She was the best wrestler ever. Hulk Hogan on Twin Towers clip. I do not know that clip. The Iron Sheik is like, he was awesome. Iron Sheik, they always needed the baddie. He was from Iran. Wasn't he like a chef in like real life? And Abdullah the Butcher was like actually a butcher. Andre picked up Arnold like a little girly doll. Kamala was just really fat. Yeah. Well, and then he had like the racist bone through his nose. I remember Jello wrestling. Yeah. I'm trying to catch up with chat so we can stop talking about this here. King Kamehameha. No, I don't think he was a wrestler. I think he was like an actual. But the Mulkey brothers were the goats. Yeah. Oh, fuck. George the Animal Steel. That would like go around and eat turnbuckles. Apparently, George the Animal Steel was like a high school history teacher or somebody. All right. Everybody's begging us to stop talking about wrestling. The Bushwhackers. Yeah, I got the Bushwhackers. All our Australian people out there. Weren't they like terminal alcoholic? I remember the Bushwhackers walking in with their little thing. Yeah. Okay. Let's stop talking about this. Rowdy Roddy Piper is a god. Rowdy Roddy Piper was my favorite wrestler of all time. Rest in peace. Seriously, that's where we should just end it. We should just end it with Rowdy Roddy Piper, because Roddy Piper was the fucking bomb. All right. I'm down 2 shots. We are Paul Orndorff. Yeah. Oh God. Nobody here wants to hear us talk about wrestling. Yeah. Snuka was a hero. Snuka also a Mormon, but Benoit headbutt. And my favorite tag team, hands down, was the Fabulous Freebirds with Michael Hayes and Terry Gordy and Buddy Rich. And like when the opening scenes of the movie Highlander, when they're in Madison Square Garden and the Freebirds were wrestling, I went out of my fucking mind in the theater when I was watching Highlander, and it's like, oh my God, it's the Freebirds. How the fuck many chats are you guys just throwing at me? The Road Warriors? Yeah, unfortunately, they were alcoholics. Big Boss Man. Oh, now you're getting like the 90s wrestling. God. The Hart Foundation. Hacksaw Jim Reed or Hacksaw Jim Duggan. Ultimate Warrior was genuinely psycho. Oh, the British Bulldogs. Haha, the end. Yeah, we got the British Bulldogs here. Jimmy was a legend. Everyone feared him. Jake the Snake. There's good guys like lots of problems. All right. Everyone in the 80s and 90s wrestling scene was alcoholics. All righty. Okay, we only lost 200 people talking about wrestling. That's pretty cool. Whatevs. Von Erichs versus Freebirds. Thank you, Isaac Baruch's wholesome gabagool art. Von Erichs versus the Freebirds is one of the greatest angles of all time. Ripped to most of them. Drugs are a hell of a drug. Yeah, I mean, Terry Gordy was the man. He was just big. But Michael Hayes is still around. He's, you know, just that golden mane of hair. But that was a long ass feud. Why do I know this shit? God, I was just a kid. Sigh. Yeah, WWE is gay AF now. Yeah, it's just yeah, it is. How long is lunch? Lunch is an hour. There's still 45 minutes of lunch. We only killed 15 minutes talking about wrestling. And I could talk about 80s and 90s wrestling for pretty much ever. 80s because I was in high school and it was cool as fuck. But then when I moved to Korea, there was almost no English language programming on television at all. Just none. And anytime you saw anything, it didn't matter what it was. Anytime you saw anything in English on TV, you just watched it. And then Sky Sports came, and every Thursday night they would show wrestling. And I swear to God, every single foreigner that I personally knew in Korea at that time in the early 90s watched wrestling because it was legit the only English language program on TV. Oh, Japanese wrestling. God, that's some brutal shit. That's where Mankind, Dude Love, got his start. You know, what was it, Cactus Jack and the Terry Funk. Just shit. As always, the Japanese have to be just fucking extra about everything. Blood, fire, thumbtacks, and things. The stuff that the Japanese would do, especially with the, you know, Cactus Jack and Terry Terry Funk. All right, I swear to God, y'all just talk about this here. I'm going to bring up I got to find my topics list here and bring up some sovereign citizen videos. Why not? We are literally just killing. Yeah, Mick Foley was a god. Mick Foley's biography was the first wrestling biography I ever read, and it was really good. I mean, the guy, dude's legit smart. Where are we at here? Some Japanese wrestler just died a couple of days ago. I mean, one of the big old guys, like big, tall, and like big guys. Can't remember who it was. Where's I'm saving these for Fuck It Friday, but it's just like, fuck it, I'm bored on this Thursday ridiculous stream we're watching here. All right, Fuck It Friday. Racist judges, Meghan Markle faking racism, stabbings. I was a slut. Dumpster video, the dumpster video guys. Yeah. Queen of Canada. Karen's in court. Soft sits in court. All right. Antonio Inoki fought Muhammad Ali. That is correct. It was Antonio Inoki that just died a couple of days ago. All righty. Yeah. Thank you guys for putting up with that silliness. But all right. Have they ever made a movie about sovereign citizens? Oh God, nobody would watch that. That'd be like that Bro movie or whatever the hell that just tanked like a mother in the box office. Michael Turner, I'm behind. Don't they have to reread jury instructions at the end of the trial too? Oh yeah. Yeah, they do. Oh, yeah, I forgot. I keep forgetting I'm 2 shots behind. Sorry. I've only got like 1 shot left, so that's kind of it. And everything else is across the room. Legal Vices. Remember heard of Giant Haystacks and Big Daddy. Big Daddy rings a bell. But I like the earliest films. It was like Tommy Wildfire Rich, The guy from the big guy from Stone Mountain, Georgia, Blackwell, George Blackwell, was that his name? Bob Backlund, the Funks, Mr. Wrestling number 2. Anywho, thank you so much for whichever the fuck Brandon gave me this one. This is from definitely not Brandon. We'll watch a little bit of the video and then get to the it's not Brandon Lesko's shot. Got to kind of pace myself here. I'm not walking across the room. Jerry Blackwell, that's who it was. That's right, Jerry Blackwell. England 99. Hello from Logan, Utah. We got a homie in the house. What you doing in Logan, Utah? That's my hometown. That's where the peeps are. That's where dad, sister, son, cousins, nephews, everybody lives in Logan, Utah. That's my hometown. Not a lot. And we've got, I'm sure she's still not here, but Black Swan Lady is just from over the hill in Brigham City. We've got a couple of Salt Lakers here, but anybody that's repping from Logan, Utah, hey, you're in my heart, man. England 99 from the home. Bruiser Brody. Holy Christ. I used to love, I'm sorry, I told you we'd stop talking about wrestling, but it's not my fault. Saltstorm brought up Bruiser Brody. Yeah, he'd wear those big muckluck boots and he had the big hair and he got fucking murdered. Like seriously murdered. Oh, Bruiser Brody and Roddy Piper, they used to have a big feud thing going, and that's why I loved both of them. Bruiser Brody was like my favorite crazy guy walking around the ring, hatch, and he would just fuck you up. And he was like one of those guys that was just crazy enough that he sort of drank the Kool-Aid and went full wrestling mode. We should do that for one of the legal shows. The Bruiser Brody's things. Yeah. Bruiser Brody was the man. He was a big buff dude. Yeah. But yeah, like the Bruiser Brody was just kind of like murdered. Because like the Mexican wrestlers and the Puerto Rican wrestlers or things, they were like taking this shit too seriously, and he insulted one of them and ended up like getting murdered basically by him. It's kind of weird. Yeah, all right. We've really got to stop talking about wrestling. We've bled another 100 listeners just that quick. Christina Brigham is in Orem, Utah. Swan Lake Lady. Yep, England High. Swan Lake Lady from Brigham City, just over the hill from Logan. They were our rivals, the Bucks Elder Bees. We were the Mountain Crest Mustangs and they were the Bees. Sandy, Utah, years ago. Oh, sweet. All right. Well, yes, Snooko's the man, dude. All right. We got a porn bot in the house. Yeah, he's kind of murdered. Yeah, he wanted to get in. Dutch Mantel. Yeah, he was part of the Bruiser Brody saga. Why are we talking about this shit? Yeah, I thought we were done. Exactly. I thought we were done with wrestling too, but I keep scrolling down and people keep talking about it. All right, that's it. Seriously, wrestling fucking done. Stop talking about wrestling. Let me bring this up. I hope this doesn't get yeeted. This is A&E, so it's like a toss up. I'm just gonna I gotta pay attention to the stream to see if we get a warning out of this. We could. We're at 26,045 subscribers. Holy Christ, we might get up to 26,100 before this is done. How are we doing on likes? Almost 1,600 likes. You guys are awesome. This is funny. I'm having a good time here. I'm glad you're here. Let's just get this set up to watch some Sovereign Citizens. Yeah, Sovereign Citizens are fun. Isn't most of Utah sandy? That's funny. All right. Stop the court cam stream. Bring up the what? Present. Present. It used to say share. Now it says present. That's weird. Present screen. Darrell Brooks, Waukesha Parade, Court Cam, top 5 sovereign citizen moments from A&E. Oh God, here we go. Let me see if we gotta boost up the frame rate here, so it's not we don't see potato cam film. All right, here we go. Let's watch some sovereign citizens again. Soft sits are just like they're just degenerate human beings that just talk out their ass. Yeah, taser time. Seriously. Whoops. Ugh. Here we go.
We're in Placerville, California, for the arraignment of 39-year-old Asher Edwards.
Hello, Judge.
Hello, Judge.
Sir.
Edwards' demeanor may seem pleasant, but just a few days earlier, his alleged behavior was anything but. He was charged with making terrorist threats, assault with a deadly weapon, and obstructing peace officers after a domestic disturbance escalated into a 2-day police standoff.
All around lovely guy. Sounds nice.
Mr. Edwards, this is the time and place set for your arraignment. Do you consent to have an arraignment by video conference? Sir, is this an Maritime Admiralty Law courtroom? Seeing me through? No, it's not.
Edwards considers himself a sovereign citizen who lives as a free man, as they like to say, under common law as established by the Founding Fathers. Maritime Admiralty Law that he's referencing is the law of the sea and international commerce, a body of law that sovereign citizens believe to be the foundation of the country's modern legal system, which they reject.
This is not a Maritime Admiralty Law courtroom. I believe so.
No.
Absolutely, it is. All courtrooms in this country are Maritime Admiralty Law courtrooms that process people, aren't they?
This is the shit that these soft sits do. Oh God, they trigger me like you've never. Soft sits trigger me like mofos. Oh God, this is what they do. This is what they do. This whole not a Marilty current is getting all right. Leilu, thank you so much. Oh, thank you for the entertainment. Been a crazy day, and I'll thank you for the super chat. All right. Yeah, I flat earthers and sovereign citizens. Those are just like the two that I can't do. Let's watch.
No, sir. That's false information. Well, either way, this courtroom is trying to process me as state property. See this fictitious name statement? Asher Edwards, spelled in all capital letters.
See, this is a weird thing. They say that these all capital letters on your birth certificate and your social security is the government's way of signing you up to the United States corporation when you're born. And he's saying that he's not part of a corporation. Oh, God.
It's not my name.
Edwards is referring to another sovereign belief that beginning at birth, one is issued a government identity, meaning one's name is spelled in all capital letters, such as on a birth certificate or social security card, and that doesn't represent one's true or free self.
This name was issued to me without my consent, and you cannot legally process me through this courtroom with this without this name in all capital letters that was issued without my consent. My name is spelled Asher Edwards, first capital, all lowercase, Edwards, first capital, all lowercase. And this is the birth name given to me by my parents, protected by the Constitution of the United States.
Even as Edwards grows louder and more animated, the judge appears to take it all in stride and even allows the defendant to finish his rant.
Therefore, it is illegal for you to process me through this courtroom, so you guys have to figure out something else to do with it.
But this judge is all business, so figuring out something else to do with Edwards is not in his plans.
The court will enter a not guilty plea on your behalf. Will show time is not waived. We'll set this matter for pre-preliminary hearing within the statutory period.
And I would like to see the gun. It said I had a gun. I've never had a gun.
As Edwards continues his rant about the alleged gun, the judge reaches for his own weapon of choice, the mute button.
Just shut the fuck up.
Do not speak speak while I am speaking, sir.
Edwards continues to plead his case, but to no avail.
Court will set bail in the amount of $72,500.
That's a good, healthy bail.
Next matter.
And that's how you deal with these people. You just go, all right, shut up. Next. It's time to catch up with the last super chat and the last bit of we've just killed a bottle of Elijah Craig. With sadness, we say goodbye to Elijah Craig. Small batch. Courtesy of It's Not Brandon Lesko. Thank you so much. Cheers. Let's get on with the next sovereign citizen.
Asher Edwards would later be found guilty of all the charges and sentenced to 1 year in prison. Next, we go to a bond hearing in Broward County. Judge John Hurley presiding. The defendant is David Hall, a sovereign citizen who basically believes that certain laws don't apply to him.
Mr. Hall has declined the services of the public defender.
Your objections don't work unless it's in your crazy pants. I'm not wearing pants. I never wear pants when I stream.
Mr. Hall, DUI, expired driver's license.
Good morning, Judge.
As soon as the judge attempts to read the charges, Hall begins interrupting.
Sir, I haven't said to the court how I'm appearing today,
well,
sir.
I'm not asking you yet. Just give me a moment, all right? I need to look at your record.
See, that's the thing. Am I appearing as the person or am I appearing as the corporation?
Turns out Hall is currently out on bond for 2 previous charges of driving with a suspended license. But that's not going to stop him from trying to make his case.
Sir, today I'm appearing as the agent and settler for David Hall.
Okay. Could you get Mr. Hall for me then, sir? Where is he?
Oh, I've seen this one. This judge is great. I like this judge.
I go by that name, sir. My name sounds exactly like the defendant's, and I'm here to settle that matter today.
So are you and David Hall one and the same person?
I'm not a person, I'm an individual. David Hall is a person. I am a private individual.
Hall's legalese is unconventional, to say the least, but the judge allows him to continue.
May I say something else for the record, sir?
Go ahead, sir.
I appear here today as the settler, agent, not the person, but the individual. And I don't think I should have you understand the difference between a person and an individual.
And you're the individual, but you're not the person. Is that correct?
Correct.
Hang tight. Just waiting. Got to wait it out. Hey, hello. Welcome back, everybody. What? Yeah. Hello. Says the stream is unavailable, but I'm still here. Well, that was wild, wasn't it? Wow. What's up, everybody? Just kind of waiting for everything to catch up. Hey, we're back. All right. We've still got a few minutes. We've still got a few minutes to go here. What are we looking at? Oh, we're supposed to come back in 1 minute. Yeah. What if? Hang on here. Let's see. Mindset should be sleeping. Well, It's 3 a.m. here in Korea. We should be starting here in just a second. Hopefully. Hang on, yeah. All right. Hey, Kurt, just sent you a link there. Legal Mindset should be sleeping. It's 3 o'clock here. I don't know. Is he here? You here? Are you here, Andrew? If you are awake, come and play. I said to Andrew. Oh God, my face hurts from soft. We almost got it before we got the up. All righty. No on Civil right now. Civil's having a depressive episode and needs a timeout. All right, well, you take your time out. If you before the end of the day you feel you're feeling a little better, feel free to join. You've got the link. We're just waiting for everybody to come back from lunch. Like I said, we've got the Law and Cuck stream going here. If anybody else cuts back, if there's any other streams, if there's any other places that cut back quicker, let me know and we'll switch over to them. Take the time you need, Kurt. That's the important thing. You do you. Take care of yourself. Hang out there in the chat. You are, as you know, you are always welcome. And tomorrow is my Fuck It Friday 25,000 subscriber stream. You are absolutely invited to that because you're one of the people that got me here today. But weirdly, we're celebrating the 25,000 subscriber mark in what are we at 3? So that's 12 hours. 18 hours from now, we're celebrating the 25,000, but I've already got 26,000 before we celebrate the 25,000. So I hope you'll pop in a little bit later during the 25,000 subscriber streams, Kurt, because I need to say thank you to you personally for everything you've done to help me get here today. Still nothing going on here. We've got the let's I better share this here just in case something miraculously happens in court. Share that. Ooh, we don't share the window. We want to share the Chrome tab. Watch live. There we go. Boom. Still just kind of hanging out here. If there's any other streams that start sooner, just let me know. I know there's a couple of other places. Someone else suggested somewhere else. Looking at your Godzilla poster, what's your favorite kaiju? Godzilla, hands down. That's one of my prized possessions. Actually, that is an actual movie poster from the 1954 Raymond Burr version of Godzilla. And this down here, the road sign, that's an actual legit road sign. Like it's reflective in the dark. It was made by a company that makes actual road signs. They made me a Godzilla road sign. It's got all the mounting, so you could go outside and mount it to a road sign pole any day. It's got the bolt holes and things. It's great. That's my favorite possession. That's like my two things. And back there, that's that's really far away, so it looks small, but it's actually really big. That's a Cthulhu painting, like from it's a painted image from the Call of Cthulhu, where Cthulhu comes out of the ocean and is chasing the ship full of people. So yeah, that's my posters around the room. My movie poster, my movie sign, my Cthulhu poster back there. Well, they're back late from lunch. They were supposed to have been back 5 minutes ago. We're just kind of hanging it here. We got our little our demonetization thing going there because of the I object to YouTube. Exactly. I knew we'd get, but I'm surprised. That was a 20-minute video, and we literally got through 20 minutes of it before they yeeted me. So actually did much better than I thought we would do. People are coming back. We're back up to 1,230 concurrent viewers. People are coming back for the second half of this, but unfortunately, the second half of this ain't coming back for us. And we are still going through the ridiculous reading of the charges and the standards for judgment. Oh God, there's a lot more to go. See, I heard that there was 61 pages, and some of you were saying there's like 90 pages she has to read through. Oh God. XCOM, are you done with shots? Well, are you ever really done with shots? I mean, that's the question you have to ask. I mean, I don't have anything within arm's reach, but there's really nothing stopping me from walking a few feet over there and getting a replacement, but so never say never, but I have a police oh, sweet. Where'd we go? Wait, hang on. We got like a bunch of stuff here. I have a police MP helmet with Godzilla versus Godzuki. At least that's what the Chinese eBay seller told me. What do you mean there are no MPs in that film? Damn it. No, there weren't there? There's always military running around. There has to be something. Yeah. All right, we got some stuff. Fries are for fry sauce. Seriously, the fry sauce is the shit. It's a 1-to-1 mix of mayonnaise and ketchup. Do it, you'll never go back. Who the fuck eats fries with mayo? Smart people, not just mayo. You're just like fries and mayo. That is like European. That's not smart. You got to mix it 1-to-1 with ketchup. Ketchup and mustard, ketchup and mayo 1-to-1 is the best thing you'll ever have in your entire life. If you want to be really old school, throw a little bit of sugar in there. Mayo and fries are sacred. Correct, Jeff, says Barney. Yumum, thank you so much. Tony, Legal Vice says, I don't understand why these soft citizens try this crap. They don't ever seem to get anything out of it and ultimately are charged, convicted, etc. So why? Because they think that they're going to be the ones. They're going to be the ones that pull this off. They've got the magic secret formula that they read somewhere on the internet or paid someone $49.99 to give to them. And it never works. And there is no money back guarantee. They're just dumb. Sorry. As Kurt would say, they've got all the stupid. They've got the stupid. All the stupid. Legal Vices. Could you please steel man the argument for the validity of sovereign citizen ideals? There's zero validity for sovereign citizen ideals. There's none, literally none. If it was possible to have less than zero, it would be less than zero. That's how little validity the sovereign citizen arguments has. It's like less. There's none. It's just non-existent. I've never understood why they think the way they do. Because they just think they're smart. They got it all figured out. You may have all that law shit and all that law school stuff, but I done my research. I know how it works. I know the loopholes. I know how to get around this. It doesn't work. Question for you, says Dion. Do you think the Mormon Brethren are the real reason the Vallow Daybell trial isn't being broadcast? No, I don't think so. I mean, I can't imagine the Mormon hierarchy wanting anything to do with that crazy nut job couple of people. It's a pretty salacious thing. And I know Kurt was really, really planning and was really, really hoping on the Daybell thing to be televised. It's sad that as far as I know, it won't be unless something changes. But yeah, no, I don't think the Mormon hierarchy has anything to do with it. What if you dip the bacon in the ranch? That's my kind of talk. Oh, dear. And of course, we have X-Comer with the Mega Pint. The Mega Pint is in the dishwasher, but we'll have it tomorrow for hydration purposes. Once the court gets back underway, then I'll walk across the room here and grab me another shot to make up for. Wait. Do I still have? Oh, no. Oh, I do. I still have some. The joys of being an alcoholic. you always have a bottle of something within arm's reach. Hang on. We still have the famous grouse. Not much, but we still have some of it left. The preferred and favorited whiskey of Her Royal Highness, Queen Elizabeth II. May she rest in peace. Yeah, well, Nick Ricada interview. Apparently he's busy right now. Someone said he was on Megan's channel. If he wants to get here, he'll get here. He said maybe, possibly, but it would be later if he shows up. Yeah, he's on with Megan Fox for a few on Megan's Rumble apparently. When he gets here, he'll get here. If he doesn't get here, he doesn't get here. It's up to him. No biggie. He was just, like I said, he was just intrigued when I texted him and said that that Brooks was shoving the objection sign down his pants. Who else is streaming this? Are there any other streams that are active right now? I've just been focusing on law and crime. Someone mentioned another stream earlier on. But if there's any other streams that have anything other than this image, please, for the love of God, tell me so I can switch over there. I'm getting tired of looking at this. The judge is late. She's probably talking to someone, which means she's just going to be for fucking ever because this judge likes to talk. I think TMJ4. Okay, that was the other one. Are they showing anything of interest? That's the $1 million question. What was it? TMJ4 to go. TMJ4. TMJ4 News Live. TMJ4 News Live Stream. La, 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 la. There we go. Oh, wait, she's back. How come Lon Cucks aren't back? God dang it. All right. See you, Lon Cucks. We're out of here. Let me bring up the other stream. Nope, not you. There you go.
For the public, from my perspective, there's ample room on the other side of the courtroom. I'll ask the district court administrator to assist me in modifying the
and we're back
administration order. But that was my observation throughout. Ample seating. That does take away a bench from the. From my perspective, they've been from the media room based upon the pool feed, and they no longer need the 2 benches.
Thank you, Your Honor. We greatly appreciate that.
You're welcome. All right, then I'll have the.
The resolution on this is.
I just want to get confirmation from the bailiffs who are with Mr. Brooks that they offered based on my
this is the TMJ4 news stream
Mr. Brooks to come back over here.
Does no one have chairs in this court? Exactly. Why are they all fucking standing up through the whole thing?
Brooks, I'll ask you and advise you, you are welcome to come back.
Okay, he didn't change his clothes. He didn't put his clothes back on.
In that courtroom, at least prior to the break.
He still wants to be in the naughty boys room.
It seemed to me that you were writing notes, perhaps even following along with the written jury instructions. I know you filed 2 objections. Those were addressed earlier. Mr. Brooks.
Oh. I forgot. I forgot.
X-Comer,
Triple Z. Thank you so much. Cheers.
Would you like to come back to the main courtroom?
Just save your shekels for tomorrow.
You're on the record. Would you like to come back to the main courtroom? Now I could just get confirmation from the bailiffs. I know the audio was tested. I was under the impression it was working.
Oh God, this famous grouse is bad. After you go from Elijah Craig single batch to famous grouse, you're going downhill. Nasty.
You know, if anything, what I said was picked up. Okay, thank you.
He's lying. He hears everything.
Looks like Mr. Brooks has put on the headphones and they're testing them to see if they are working. I don't believe he had those on prior to the break.
My notes show he had removed them at about 10:54 a.m. and when we broke for lunch, it was about 11:54. So it was about the last hour of the morning session. He was not wearing the headphones, Your Honor.
Thank you.
Who cares? God, just the shit they put on the record is so weird here.
I believe those headsets do need to be charged on occasion, so there are other headsets that can be provided if that one is not working.
Oh, do we have to go through all this shit again? What are your thoughts on the mayo mustard combo? Mayo mustard combo has a place on chicken sandwiches, ham sandwiches,
so hopefully that works.
barbecue hamburgers, and that's about it.
All right, Mr. Brooks.
Certainly not French
I am
fries.
offering you an opportunity to come back to the main courtroom.
And
Would you
deviled
like to do
eggs,
that?
yes. Deviled eggs, definitely. You need the mustard mayo combo for deviled eggs.
We're not hearing him very loud at the moment, but can you repeat that again?
Did they cut off his hair for lice?
You'd like to come back? All right, we'll have you brought back then.
You sprinkle lye powder all over him.
We'll be in recess until that is accomplished.
Oh, God. Wait, I missed that. What are we accomplishing? Oh, God, what happened? Now what happened? Fuck, what happened? No. Why are we in recess?
You'd like to come back? All right, we'll have you brought back then. Thank you.
He wants to come back in the courtroom. All right. So we're in this is such a shit show. Oh, God. They're going in recess until they can bring him back in. He wants to be a good boy. Is this him actually wanting to be a good boy? Or is this him just wasting time? Is this another delay tactic? He's going to come in, he's going to act like a fucking asshole, and then they're going to have to send him back off again to the other room and waste another 20, 30 minutes. Is that what's going to be happening? I think we should snipe the let me ask Megan if we can snipe her stream. Hang on. I just asked Megan Fox if she minds if I snipe her stream during the break. Let's see if she answers. She's just talking to Nick. No, this judge is really good. The judge is really good here. She's doing the best job she possibly can under the circumstances. I don't know why do you think the judge is a tool? Why do you think she's doing a bad job? Well, I asked Megan. I'm not getting an answer, so we won't snipe her stream without her permission. But all we can do is just kind of sit here and wait for something to happen. You see, she's giving way too much leeway to act like an ass. All right, Megan just gave the okay to snipe her stream during the break here. So let's go to over to Megan. Hang on. Let's see. Stop that. And oh, that wasn't the right thing to do, was it? There we go. Yep, here we are. Yeah, chat on Rumble says Megan won't mind. Yeah, Megan said she won't mind, so that's good. Muted? Is it muted? Okay, I know what the problem is. Hang on. Hang on.
You are yet? I don't. But I have a friend, Doug Tenaple, who he went on a friend's live stream, just hanging out, whatever, and his friend got a strike just for having him on, not because of the subject of what they said. So, if people want me on their show or whatever, I'm issuing a caution on that, and that's up to them to handle that. I noticed you ended the show on YouTube, and that was the right thing to do.
Because I think that I also think for two reasons. One, because I don't want to tempt fate. I also don't. If they're working,
Nick said,
with,
"Be cautious."
Trying to get your channel back. I don't want to make them angry about that.
Right.
But also,
I'm being
I
careful.
don't think that they deserve you right now. I think they owe you an apology, and I don't think that you should be on YouTube in any capacity because they fucking suck. Jay the Legend, thanks for the Rumble rant. He says, "Rum Pirates Patriots, please click the share button. Share this everywhere. The beast bastard leftists haven't cancel cultured you yet. Goal is 1,500. Go. We're at 1,300 watching live right now on Rumble.
See,
You guys
link to the
really
stream.
Oh, good job.
We'll give you a link to the stream here
on YouTube. So whatever.
There's a direct link to the stream.
I hope this is the thing that kills YouTube forever. Please, Jesus.
Well, I see the interesting thing. The hard part about
here. Finally, I have more subscribers than Nick
or Odyssey or anywhere but I have my thing here, right? Like I have my thing on YouTube, and so I would find this even when I would stream exclusively.
I don't know if I should send that or not,
or when I even stream exclusively to locals. People are like, why don't you just do it on YouTube? Like, you always stream on YouTube. Why don't you just go on YouTube? And so it, like, you could get some people to come because they want to watch the show and stuff, but a lot of people who are not like the diehard fans which is a big part of the audience, are not diehard fans, and that is perfectly fine.
Yeah, the TMJ4 stream is still not going.
Who aren't diehard fans would, they just wouldn't get the notification, or they wouldn't come over, and it really takes a lot of work and a lot of time to get people to matriculate onto a different platform.
Law and crime is
except
back.
When you get banned.
Yeah.
And a bunch of people go right away, and it's these jolts and jars and shocks. And so what I hope,
thanks to Megan here, and then we'll head back.
No matter what happens, I hope that a bunch of people who prior to last night
thanks, Nick,
wouldn't have ever gone on Rumble to save their life, now go, hey, there's a whole bunch of content over here I like. The people I watch are coming over here or are over here already.
So get rid of that. Lawn Cuck. Yeah, Lawn Cuck is back. So we'll switch over to Lawn Cuck. Where's the Lawn Cuck?
Objections to strictly jury instructions or the filings that I filed on the 3rd.
I'm not addressing those at this point,
I
sir.
was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
All right, there we go.
I'm talking about objections during this court hearing.
It's Lawn Cuck.
Because
they're big cucks. They're big copyright
the
cucks.
preliminary jury instructions.
Okay,
But hey, they haven't copyright cucked me yet, so I like them
addressing
today.
any of those filings.
All right,
Previously
I'm down
addressed those.
2
It may not be
shots
to your satisfaction,
from
but
Xcomer. So let me
and I'm not going to repeat myself. So
get the video out of the
record
way
speaks
here.
for itself. Your
And I'll go.
objections in
Oh,
those
wait,
filings to the
no, I'm only down one. I
whatever
did
they
this one.
are,
I just can't
noted.
do this
They're part of the record,
famous grouse shit
and they
anymore.
will be available for you at a later point in time.
I'll go get
should
something
you be
better. Be
convicted
right back.
and, on appeal to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
Reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken.
We brought the
We're not
Buffalo
at that stage
Trace,
of the
which is much better
So
than
you will have
the
an opportunity after the state presents
the
their
famous
case
grouse.
in chief, and they rest to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure. But I expect you to not bring that up at this point in time or going forward.
And Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions. I am, just for reference for everyone, I've read through 44 pages of 69. And so I still have a ways to go. My intention would be to finish with the preliminary jury instructions, take a short break for all, including the jurors, and then come back with opening statements.
Oh, fuck, I hope so.
And that's, you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. And then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over there, Your Honor.
You would like to,
he's wasting time.
You're asking that to voluntarily be taken to that courtroom.
I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you
right.
want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction? That's
No, there's no lawful motion before the court. You may not.
It's too late, pal.
Are you making a judicial determination that I cannot?
Yes.
Mr. Brooks, I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
Yeah.
It's not accurate, Your Honor.
Your objection to my characterization of that is noted.
I would like to make a motion for finding the fact then.
Your request is denied.
Thank you.
On what basis?
Because on the basis I
Your
fucking
request is
said
denied,
so.
sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the disadvantages, advised of things, including the.
And that's one of the things. Oh, well, there we go. That was nice. What the fuck? Come on. That's one of the, come on. That's one of the big disadvantages is when you do
all
this.
Of the advantage, Mr. Brooks, don't interrupt me. Okay, now we're that's at least the second time. So don't interrupt me.
When you act as your own counsel, they hold you to the same standard as
tone of voice,
licensed and practicing attorneys. So when it comes time to making objections, making motions, you have to follow the laws of that particular state.
Proceedings.
It is not. It's not my
Mr. Brooks,
and he has no clue what the fuck to do, which is why you do not give up your right to an attorney.
You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want. All right?
Asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks,
liar.
I've already dealt with these. Your
bring up the subject matter.
Mr. Brooks, if you keep interrupting me, then you will forfeit your right to be present because you're showing through
Brooks
your
wants a
conduct
spanking.
that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you.
I'm this close to agreeing with the idea of gagging him and binding him.
That you came back over here.
Just strapping him into the chair.
Right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
so at this point, Mr. Brooks,
I respectfully object
stop
to
interrupting me, please.
I merely
stop
just seek
interrupting me,
understand.
sir.
I'm not.
If you have an objection, write it down.
I thought that applied to me being.
It's applying right now since you keep interrupting me while I'm talking.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not asking for
time and place,
with
pal.
you.
Time and place.
And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there
All right,
a reason
I'm
why?
not giving you advice. I'm not explaining the law. I don't need to do any of that.
Can't
sir.
you rule him insane,
Right.
incompetent,
You
and
filed
therefore
what
get
you
him a
needed to
public
file.
defender again?
I've addressed
It's a long
every single
process.
filing on the record.
He-
It may not be to your satisfaction, but
I don't think he's
have
incompetent.
addressed them.
That's
All right.
inaccurate, Your Honor.
He's
Some
just
of
being an
your filings,
asshole.
sir,
And she
you're
needs
interrupting
to
me
be more
again because you're
authoritative.
not
At this
letting me
point,
finish
she
with
needs to
my
be more
explanation.
authoritative.
Some of your filings do not require a specific line by line response.
It's
by
time
the
for the
court.
gag, I
I've
think.
addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be. But we are continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case.
Your
Madam
Honor,
Clerk, have the jurors brought
Your
in,
Honor, what
please.
You're doing this with judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've merely
He thinks he has
brought up
COVID. Yeah.
subject matter jurisdiction.
That was
because it
yesterday.
has merit. I've merely tried to seek to understand the proceedings that I do not understand.
That's why you have a
You're rushing
lawyer,
me to
you
judgment by
fuckwit.
constantly removing me from the court when I should be present for all proceedings, and I
Because
should
you
be
won't
able
shut
to
up.
understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding.
Time and place, pal.
Purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of,
I don't understand how he keeps saying he doesn't understand, but this is allowed to continue.
I gave the
because
right,
he does understand.
the
He's
waiver
just
back in the
lying.
way
He's just
that I
delaying.
felt that it should be altered, and you said so yourself on the record that.
And he
the
wanted to
word
represent
understanding
himself.
Was taken
So
off of that.
It's incumbent upon
paperwork
him to
that I
understand and follow
sent
the
back to
rules. The fact that he doesn't mean he's incompetent. It just means he doesn't know.
Understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely just clarification. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
Do you understand when I tell you not to interrupt me?
No,
do you understand when I tell you?
See,
need to
that's right
follow the
there.
rules
Do you
of
understand
decorum?
when I tell you not to
believe you
interrupt
do.
me? And he says, no,
Please
I
sit
don't.
down.
That's
The
a
jury's coming in.
sit thing. That's a sovereign citizen thing. They will refuse to say they understand anything the judge is saying.
We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Wow. All right. Here come the jurors.
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity later to raise other issues.
She needs to tighten her control in the courtroom here.
Are issues I've already addressed.
This is getting old.
You have not shown proof.
Mr. Brooks, the jury is in the courtroom.
I understand that.
You continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right
Do you think he appeals because the trial is not speedy, Carlos Estrada? This is, I think he's waived his right. I mean, I think he has not waived his right to a speedy trial. This has only been a year since this happened. A criminal trial like this would normally happen a lot longer than a year later.
If you interrupt
This is a very, very quick
you will
trial.
run the risk of being taken to the courtroom next door.
That's what he wants. He wants to go to the courtroom next door.
Mr. Brooks, final warning.
This is the most patient judge of all effing time. She's too patient. She needs to gain. She needs to retain control of her. She needs to regain control of her courtroom.
Here.
I want to
Stop interrupting me.
You were quiet. I didn't.
You were quiet.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor,
Ladies and gentlemen of the jury, I'm going to continue with the jury instructions. I'm on count 38. If you are satisfied beyond a reasonable doubt that all three elements
Still
of
23
reckless
charges
endangering
left.
Safety have been proved as to count 38, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 38.
Lancelot 652. I
If you
agree.
are
It might
not
be
so
time for the
satisfied, you
gag.
must
On the
find defendant
upside, it can act
not
as a
guilty
COVID
of the
mask
count
for him.
38.
Yeah, I got to protect him
If
from the
you find the
COVID.
defendant guilty of count 38, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first degree reckless endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty as to count 39. If you find the defendant guilty of count 39, you must answer the following question, yes or no.
Well, yes, he could be held in contempt, but what's contempt? It's like, okay, spend 30 days in jail or pay money. He's in jail, he can't pay money.
If you are satisfied,
and he's in jail for technically the rest of his life if he's found guilty, so an extra 90 days isn't going to stop him. That's the problem. Contempt of court doesn't affect his behavior at all at this point.
Endangering safety as charged in count 40. If you are not so satisfied,
well, he could still hold up his objection sign.
Not guilty as to count 40. If you find the defendant guilty of count 40, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 41, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 41. If you are not so satisfied, you must find the defendant not guilty as to count 41.
Do you hear that?
If you find the defendant guilty of count 41, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 42,
check and make sure he's still breathing.
Find the defendant guilty of first degree, recklessly endangering safety as charged in count 42. If you are not so satisfied, you must find the defendant not guilty as to count 42. If you find the defendant guilty of count 42, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 43, you should find the defendant
count 43. Oh
guilty
God.
of first degree, recklessly endangering safety as charged in count 43. If you are not so satisfied, you must find the defendant not guilty as to count 43. If you find the defendant guilty of count 43, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 44, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 44.
We're getting there. We're getting there.
Find the defendant not guilty as to count 44.
Can we just put this through a text to speech?
If you find the defendant guilty of count 44, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 45, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45. If you find the defendant guilty of count 45, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been
blah blah blah.
46.
This is just the problem. You just got to go through the motions.
First degree,
I know this is torture. This is painfulness. This is just dying.
If you are not so satisfied,
you got to go through it.
Find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no.
Oh, thank Christ.
Did the defendant commit the crime of first degree, reckless endangering safety while using?
While she's going through this. Finally. Oh, congratulations on the 26,000 subs, Jeff. Hey, thank you so much. We're almost at 26,100 right now. Thank you, Paul Byrne, but I say thank Christ because we have someone else to help me here.
Yes, hello. Good morning for you. Good afternoon, everybody else.
It's potentially criminal, Sean.
Hey.
If you find the defendant guilty
But yeah,
of
if you put us both on the corner of the screen, that always I always cover up there. There's also a Fox affiliate I have the link for.
So this covers up some of the you have the Fox affiliate?
Yeah, I emailed it to you.
If you are satisfied,
oh, did you? Okay.
Yeah.
That all three elements of first
Everybody say hi to Sean, potentially criminal. Oh, thank God there's another voice to help me through this.
Yeah, guys,
nightmare of
if you guys don't know, if you haven't realized yet, jury instructions are the worst part. I told Nick yesterday, if there was a part of the case I could like go sit out in the hallway and drink coffee and play on my phone, I would so do it. It is so awful.
It didn't come through. I just got your I saw this email and then run your screen.
Oh,
those are the only 2 emails I got.
Oh, okay.
I need to get on Discord again, don't I?
Yes, you do.
I don't know how to
use it. If you are satisfied,
oh, it's easy.
That all three
it's very boomer friendly.
Recklessly endangering safety have been proved as to count.
This is
49.
Have you?
You should find the
please tell me you haven't been wasting your life watching this, have you?
No, I was in court this morning, so
good for you.
Not really. It was worse.
There's 61 charges.
Yeah,
she's reading a 90-page jury instruction here.
Why is she's going through?
49, you must answer.
Well, there was the six deaths.
Yeah, no, I get that, but just going through all this saying if you vote this way, you must then vote no. That part should be read at the end. She should just say the count one of the indictment is on or about this day. You know, Darrell Brooks is accused of blah 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 blah. You know, in Kenosha, in Waukesha, Wisconsin. And then she should do that count 2 in Wisconsin every time. That's how she should be doing it. This is a little different. She's almost reading through the verdict, how to do the verdict before they start. Which
well, she called them preliminary jury instructions.
Yeah, but still, I mean, going through all of that, I would argue that implies you're already asking the jury to think about guilt, and they shouldn't be thinking about that. They should just be apprised of the charges. But Mr. Brooks doesn't have an attorney there, so this is where an attorney would help.
Yeah.
Now, I first thing in the morning I saw he's doing this and he's doing this with his jumpsuit on, which is always a brilliant idea. You know, what better way for the jury to not think you're I sent to you in private chat the link. What better way for the jury to not think you're a bad guy than wearing jail clothes?
Well, what he said
what took so long this morning?
Just him being there was him being disruptive, of course, 2 or 3 times. I mean, 2 or 3 times. Yeah. Then there was an audio problem they had to resolve, and then there were some other things to work out. Then there was a break to take, and then she started reading her 90-page thing.
Did the prosecutor make the motion for his competency this morning?
No, they said that there is nothing to indicate that he is in any way impaired.
Well, there's no.
I expected them to just say, "Please, God, would you find him incompetent so we can reappoint him?" And they said no.
Letting this happen though is how it comes back for a retrial.
Yeah,
that is a little irresponsible. People are asking, is this the judge's first trial? I could talk while you're messing with the stream. If you're gonna switch over.
She's doing a very good. She's
been a judge. She's been a judge for 10 years, and before that, she was elected as a defense attorney, which is not very common for most judges. Most judges are elected as former prosecutors, at least. She was a former prosecutor prior to being a defense attorney, so she is accomplished. She is not doing anything wrong.
If you are not so satisfied,
these cases where they get big like this, she's the first time she's had to deal with sovereign citizen on this scale in a big case like this. So a lot of judges, I think this judge would handle it differently. Maybe not. I don't get too wrapped up in the idea of like, I wouldn't let him do this. It's like, yeah, you would, because you're worried about the professional rules of conduct. You're worried about your judicial canons, but you're also worried if I let this get a little sideways, I've protected the record and I don't have to retry this because I don't want it coming back.
Well, that's the thing. I mean, she's definitely, come hell or high water, not going to let a mistrial happen. She's being overly cautious. I mean, overly cautious to the point.
Yeah.
Like I said, what she's doing now is unnecessary, as you were saying.
Yeah.
It took forever to get through the charges. Now to go back for the standards of judgment is just just driving a nail into the coffin of everybody's conscience.
This is weird. Like this one,
it is
in Ohio. I've not seen this in Ohio, but there's some leeway in how you proceed a case. Also, hi to everybody in the chat. And somebody asked, "How do I know this information?" My Google Fu would be very, very strong. You literally just like her name's right there, Jennifer Ardoro, and you just Google like, what about her? Like Ballotpedia is a good place to look up politicians, and then you can just Google things about her. So
find the defendant guilty.
Just slip into her DMs there, Sean.
Yeah, sure, I will.
Question, yes or no.
Yeah. Oh,
like I'm telling everybody, I don't plan on talking this.
So nice, so nice. Yeah. Ooh, would you like some casserole? Although the DA has the worst Wisconsin accent.
Well, yeah.
Good old Sue. District Attorney Sue.
Have been proved as to count 57.
I mean, I'm telling people I don't plan on talking this much once they get going, but I'm just trying to keep people sane here. And holy Christ, I'm just thankful there's someone else to do it here with me.
It's horrible. And when I'm sitting there, because I have the copy of the jury instructions, I draw on them. I do all like, you think I'm writing and I'm taking notes? Nope.
Did the defendant commit the crime of first degree, recklessly endangering safety?
I've already given a closing argument, and I was done. And like we've already read through them. I'm just staring at the paper blankly, just like, God, let's get over with. Are we almost done?
Oh, and the jurors are just going through hell right now.
Yeah, well, for them it's hell, but it's a new experience for them. On top of that, there's cameras, and then it's hell. So it's for them, this actually might fly by quickly. Has he made has he lashed out during this in front of the jury yet?
He's been a little bit obstreperous at times in front of the jury, but he's mostly been in his separate room.
Yeah.
While she's I'm gonna bring up a stream here. Yeah, we're not gonna miss anything.
Yes,
I'm going to bring up a
screen. The prosecutor's dying right now. Everybody in that courtroom who does this for a living is dying.
I'm digging for a picture here.
Yeah,
this was the funnest thing he did. I can't remember where I downloaded.
I heard he took his shirt off or something.
Oh, he did that. He took his shirt off.
Do some push-ups or something.
See. Oh, I'm probably just gonna have to download this again. Dang it. Because I can't remember where I downloaded it to.
Joe Camel, you're saying she was appointed by Scott Walker, so there's a presumption she leans conservative. That's not always the case because when it comes to appointments, that there's politics involved, and sometimes, I mean, I've seen in Ohio the Republican governors appoint Democrat or left-leaning people in certain areas. It's part of that's keeping the peace because it's also give a guy a position that you have for 2 years and they lose the election isn't good for them either. So it all depends.
Yeah.
But I would assume in Wisconsin, it's like I don't know which way she leans. I didn't check that part. That's irrelevant to this case.
Ah, dang it. I can't find out where I put this picture. Anyway, well, at one point he has his little objection sign that he holds up when he's in the other room. He got tired of holding it up, so he just stuck it in his pants. He just jammed it down his pants.
Objected his dick.
Pretty much. And I was like saying, yeah, like his dick root is just like holding it up. Yes. All right, we'll bring her back up again here. Oh, she's on count 60. We have one more count.
Recklessly endangering safety while using a dangerous weapon.
I got your dangerous weapon.
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 61, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 61.
But he's remarkably quiet for a change.
He's getting ready.
I think he's getting scared is what he's getting.
If you find the defendant
I think
guilty
now
of
it's kind of, I think
161,
reality is
you must
starting
answer
to
the
kind of hit
following
him.
question, yes.
Maybe he's getting a little scared. I
Did
mean,
the
to
defendant
be fair,
commit
I
the
get a
crime
little
of
scared and
first
anxious
degree
before
recklessly
trials. Like
endangering
I
safety while
did
using
a bench
dangerous
trial this morning for a
weapon?
misdemeanor. Like that's not a big deal, but like a real trial, yeah,
If
I
you
get a
are
little nervous,
satisfied
and you
beyond
could
a
say a little
reasonable
scared right before it kicks.
doubt that
But then once the ball's in the air, it's game time.
Yeah, but being
I
this
think I
guy.
skipped a few numbers.
Oh yeah, well, hey, you don't know what it's like to be a free man on the land.
Yeah, I
Does anyone
don't.
think I skipped any numbers?
You
Oh,
know, he
God.
battled
Sorry, it's a lot of
road
numbers.
pirates every day, and
I do the best
Yeah.
that I can. And
he
I was a little distracted by a piece of paper.
was
that
trying to do his job, and those
You're
kids
on
were in the way of
61.
him. I mean, that was horrible.
If you find the defendant guilty of
I
count
bet that's what he's gonna
61,
argue.
you must answer the
Those kids
following
impeded my
question, yes or
travel.
no.
Yeah.
Did the defendant commit the crime of first degree?
I didn't
recklessly
agree to
endangering
join her
safety while
with them.
using a dangerous
No, yeah, they tried to join my
If you
car,
are
and I said
satisfied beyond
no.
a reasonable doubt that all three
Well,
elements
we've been
of
arguing
first
it's the
degree
Carrie,
recklessly
it's the
endangering
Christine
safety have been
defense.
proved as to
Yes,
count
he can
62,
argue. If it was a Honda, he could argue I hit the
you
brake and
should
it
find
wouldn't
the
stop.
defendant guilty of first degree.
It's a 57
recklessly
Chevy. It's the
endangering
Christine
safety as charged in
defense.
count
Yeah.
62.
No,
The
I
car
think
If
did
you
it.
are not so satisfied, you must find the defendant not guilty.
I wonder if they're
as to
gonna.
count 62.
The DA is gonna
If you
get them.
find the
Like, you
defendant
know about
guilty
Kyle
of
Rittenhouse,
count
don't you?
62,
You didn't
must
like
answer
how
the
he shot
following
them boys,
question,
did
yes
you?
or no. Did the
When he went
defendant commit the crime of
rat-tat-tat
first
and went
degree
blah-ta,
recklessly endangering
blah-ta,
safety
blah-ta.
while using
That you
a
did not like
dangerous
that when he
weapon?
did it, did you? You know,
Yeah.
with his
Scandi-
AR.
Scandinavian
If you are
rap.
satisfied beyond
Yeah.
a reasonable doubt that all three elements of first degree
What's the
recklessly
Christine
endangering
defense?
safety
The
have been proved
Christine
as to
was a
count
movie, was a book and a
63.
movie by
You should
Stephen
find the
King about a
defendant guilty of
car that
first
came
degree
to life
recklessly
and started
endangering
killing
safety as
people.
charged in count
We were just
62.
making fun of the Christine defense. Is
If
just
you
the
are
defense that
not so
the car
satisfied,
came
you
alive
must find the
and he had no
defendant not
control
guilty
and
as to
it
count
killed and ate the people.
63.
Rick Gee says our parade's
If you find the
constitutional.
defendant
Good
guilty of
point.
count 63,
Yeah.
you must answer the following question, yes or no.
You
Oh
know,
God,
Did the
she's
ladies
still
and
defendant
going.
commit the crime
ladies and
of
gentlemen,
first
the roads
degree
are made for
recklessly endangering
cars.
safety while using
Oh yeah, it
a
wasn't a
Thank you.
57 Chevy. It was a 58 Plymouth Fury. You're
If
absolutely
you are
correct. Sorry.
satisfied
Yeah.
beyond a reasonable doubt that
Oh,
all
really?
three
Oh,
elements of first degree
Show me where
recklessly
Kyle
endangering
touched you.
safety have been
She's gonna bring
proved
Kyle
In my
in.
forearm, he vaporized my
you should find the
forearm.
Yes,
defendant guilty
she'll bring
of
Kyle in and
first
have him sit
degree
down.
recklessly endangering
That movie gave me
safety
the
as
willies.
charged in count
Hmm.
64. If you are not so satisfied, you must find the defendant.
Well,
not
let's burn through these
guilty
super
as to
chats while
count
she's rambling.
64.
Yeah.
Lancelot, I agree. It might be time for the gag. Oh, we already did this one. At least
If you
yeah,
find the
you can use the
defendant
gag as a
guilty
COVID
of
mask.
count 64, you must answer
Watermelon,
the
thank you so
following
much.
question,
Join
yes or no.
potential
Did the
criminal
defendant
Discord for
commit
the best
crime of
True
first
Shine
degree
recipe.
recklessly endangering safety
What?
while using a dangerous
Just leave it alone. Just leave it alone.
If
It's
you are
good.
satisfied beyond
It's
a
better off that
reasonable
way.
doubt that
Don't
all
tell
three elements
don't
of
tell an
first degree
alcoholic to
recklessly
to
endangering
say any
safety
to
have
leave
been
anything with
proved as
shine
to
in it
count
alone.
Yeah,
Will
no,
the-
yeah, you don't want this
You
stuff.
should find the
Okay,
defendant
well,
guilty
will the opening
True and
statements
Shine,
have a time
True and
limit?
Shine is a DIY hormone replacement therapy that.
Oh no, yeah,
If you
Yeah,
are
that's
not
True
so
and Shine.
satisfied,
They bake it in
No.
their
you must
bathtub.
find the defendant
yeah.
not guilty
You don't.
as
You
to
won't
count
drink that.
65.
Nope. Will the
If you
will the
find
opening
the
statements
defendant
have a time
guilty of
limit?
count 65,
No,
They-
that thing
you
that
must answer the
They do
following
traditionally,
question,
but for
yes
something
or
this
no.
big,
yeah.
Did the
she's.
defendant commit the crime
They
of
probably already
first
mentioned that,
degree
and I don't know how long
recklessly
it's going to be,
endangering
but
safety
they'll have
while
a
using a dangerous
60
weapon?
counts. Like this is a significant. This
Yeah.
isn't
If you
some
are
dude with a
satisfied
shotgun in the
beyond a
7-Eleven.
reasonable doubt that all three
Yeah,
elements of
yeah.
first
There's
degree
just
recklessly
there's no
endangering
limit,
safety
you know.
have been proved as to count
I can't. I
66,
mean, he's either gonna
you
say
should
like
find
I
the defendant
object,
guilty of
or he's
first
gonna go for
degree
7
recklessly
days.
endangering
One of the
safety
two.
as charged in
He's like,
count
I object to all of
66.
this. I object to
If
you.
you are not so satisfied, you must find the defendant not guilty.
I'm out of
as to
order.
count
You're out of order. You know,
Each-
damn
yes.
fucking proceedings are out of order.
Each one of you, you are a road pirate and you
You
don't
must
even
answer
know
the
it.
following question, yes or no.
D-Flash 60. Why aren't the families suing the car manufacturer?
Because
they probably are, because it's America.
No, because they get I think that's meant to be a joke, like, or point out like why doesn't Ford get sued but a gun company gets sued?
Well, I would
because
not
they
be
get
surprised.
left out of court.
Guilty of first degree, recklessly endangering.
I would not be surprised. It's America. You can sue anybody for anything, and
Yes,
that's what you do.
It doesn't go anywhere though.
It doesn't, but I can see them trying it.
Susie saying, how will he cross-examine the witnesses? He'll ask him questions just like anybody else does.
Well, that's the thing that we were talking about earlier is how does he question? How does he question himself? Does he just to get?
Yeah.
Because you can either have the guy that just does that, he gives his statement, or you have like the ones that you've seen where they actually ask themselves questions and answer them.
You don't normally ask yourself. You don't normally do that.
I'm hoping he does that.
You provide a narrative, and the judge
something's happening.
The judge kind of facilitates that narrative along.
Don't forget, he stuck his objection in his pants. Oh no, we'll never forget that, Carlos. That's going to be my new trial thumbnail.
That big girthy objection.
The Dick Root objection.
All right, please be seated.
I'm stuck on Pink Floyd. Animals low in the background to bridge her reading. You have to listen to Animals. Great album.
The defendant is charged with 6 separate counts of violating a duty after being
He violated a duty. That's gross. Scatology has no place here.
The 68th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021.
Oh, for Christ's sake, don't read through
I thought
this.
there were 70-some charges. That's why when you said 60. Was Chianti.
Well, it's like 64, 65, 66, because there were 6 deaths and like 60 or 61 injuries.
Yeah.
To reasonably investigate what was struck. And if
Can I get a summary of what he's charged with? 6 counts of first
He
degree
didn't have to
right.
investigate what he struck.
Yeah. So yeah, basically killing 6 people and wounding 60 or 61 other people.
Felony assault with a vehicle, failure to stop it in a fatal accident. And insert whatever you can.
Brooks will soon be meeting his dad soon in the prison showers.
So yeah, yesterday
he needed his entire life.
Yesterday, Nick and I were hypothesizing he was standing up because he got booty gooned.
Yeah, well, yeah, we talked about that as well.
Okay.
And she's standing up too.
Well, because she needs to stretch her legs.
Yeah. And so it's like that's we've had the chats. What are there no chairs in this courtroom?
Collided with.
He hasn't earned a chair yet.
Reasonable
Yeah.
assistance.
Can unlock an achievement. 5 minutes of silence.
In the accident, including transporting or making arrangements to transport the person.
Hope he eats grapes every day in jail, says John D.
Hospital for medical or surgical treatment.
Get that butt,
It is
says Joe Quixotic.
medical or surgical treatment is necessary, or if requested.
The volume is up on the court, I think.
Contrary to.
Or either I turned it down so we could just talk over this nonsense. Well, it's not nonsense. I mean, I shouldn't say that. We just talk over
this. Is nonsense. This is nonsense. Because you'll hear this again at the end.
Yeah. Let's see here.
But if you,
no, the video's not up.
Count of the information in this case.
Next up, Pink Floyd, The Great Wall of China.
Yes.
Thank you, Paul Byrne.
E. Brooks. On or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Leanna Owen and failed to reasonably investigate what was struck. And if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle, he was
booty goons.
That's
why he's bent over practicing
as possible, and remain at the scene of the accident until he did all of the following.
He's asking his name, for it now.
Address, and the registration number of the vehicle he was operating. To the
so if he had stopped and wrote out the receipt of, hey, here's my card, and then drove off after he killed everyone, they wouldn't have. That's like, come on now.
And if available,
you're charging him for this. Is
exhibit
ridiculous.
His operator's license to the operator or occupant of, or
this is rough, man.
Attending any vehicle collided with.
Been doing this for 5.5 hours.
Reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person.
Imagine if the Vegas shooter had a trial. 59 count murder and over 800 plus injured. Jury instructions would take a year or more to get through.
That medical or surgical treatment is necessary or if requested by the injured person. Contrary to sections 346.67 sub 1.
Yeah. I purposely brought her volume down just because it's repetitive.
Guys, it's all jury instructions. This is the boring stuff. You don't want to hear it. You'd rather hear us talk.
The 70th count of the information.
It is awful.
Case charges that.
This is so funny though, because tomorrow is my 25,000 subscriber
November
celebration
21,
drunken
2021,
Griftapalooza stream,
on Main Street,
and I've already got 26,000 subscribers.
Yeah, well, I know we talked about that before. Yeah, but hey, it works out. What time are you starting up in the morning?
It'll be 8 Eastern.
And failed to reasonably
Okay,
investigate.
I will.
what was
I
struck,
could be on, but I
and if
have.
the operator knew or had reason to know.
That court gave me some.
that the
I got an
accident
they scheduled an
resulted
arraignment for tomorrow,
in
so I'm
injury or death of a
not able
person
to drink, but I can hang
and
out.
failed to stop the vehicle.
Well, I hope
he
you
was
wouldn't be drinking at
operating
9 a.m.
as
even if you
close
could.
to
Well,
the
or
if I
scene of the
wasn't, I
accident as
would.
possible,
Can't let
and
you do this
remain
alone.
At the scene of the accident until he did.
I will send you a
all
link
the
then.
Following. Give his name, address, and the registration number of the vehicle he was
Also, good job
operating.
with Scott. You know, that was a great
The
change for
operator
future
or
conflicts.
occupant of or person attending any vehicle collided with.
So bad.
And upon
But you know, I might get like,
request,
you know, Scott was like gonna have me
exhibit
on at some
his
point. I'm like, great, now I gotta
operator's
like,
license to the operator or occupant
now I'm coming on after
of
that.
or person attending
I was
any
so out
vehicle
of my depth.
collided with, and render reasonable assistance to any person injured in the accident, including transport.
I love all that
making
shit.
arrangements
I love
to
all that shit they
transport
talk about.
the person to a
Yeah, but they're like
physician,
naming certain
surgeon,
bridges
or
on
hospital
certain
for
rivers in
medical or
Ukraine. I'm like,
surgical
I
Oh,
don't
I've
know
been
what the fuck
I
you're talking
follow all
about.
I follow all that
medical
stuff.
or
Yeah,
surgical treatment
yeah,
is
the
necessary,
Antonovsky Bridge. Yeah,
or if requested by the
yeah,
injured
it's not looking
person,
good for the
contrary to
you know, well,
sections
the
I just know I've
the,
got
the more
347.1,
technologically advanced band of Slavs is beating on the
346.74
less
sub
technologically
5 sub
advanced
D,
band of
and
Slavs.
939.50
I just know I've got
sub A sub D of the
Russian
Wisconsin
girls in the
statutes.
stable and Ukrainian
The
girls in the stable,
71st
so you
count
know.
of the information in this
And you're like,
case
ladies, we don't have
charges
to
that
fight.
Seriously.
Darrell E. Brooks,
Can't we all just get
on or
along
about
together at the
Sunday,
same
November
time?
21 of 2021,
Oh God, would
on
you
Main
please
Street
hurry
in the
up?
city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jane Coolidge and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in
Also, I
injury
just
or
want to say,
death of a
frig Nick
person,
Ricada, fuck
and failed to
Keffels,
stop the
fuck
vehicle
Gay
he was
Fesh,
operating
fuck all
as
you
close to the
cocksuckers that
scene of the
reported him.
accident as possible, and remain at the
I
scene
do
of
not
the
disagree with
accident
that.
until he
Yes.
did all of the following: give his name, address, and the registration number of the vehicle he was operating.
She's
To the
literally going
operator
through
or
a hit and
occupant
run.
of or person attending
Yeah.
any vehicle collided with,
Oh my God,
and
this is so
upon
funny.
request and if available,
Somebody
exhibit
did a
his
side-by-side.
operator's
Keffels did a
license
stream last
to
night
the
of like
operator
8,000
or
people,
occupant of
and Nick
or
has like
person attending any vehicle
26,000.
collided with,
Yeah, he
and
had
render
I think I saw him get up to
BT
about 26 at one
Lucas,
point.
you got
in
BTFO'd,
the
just like your
accident,
hairline.
including
BTFO'd.
transporting or making arrangements
Give it
to
10 years, you're
transport
gonna look like
the
Jeff.
person to a physician,
No
a
offense to you,
surgeon,
Jeff.
or
Is
hospital
that your
for
dog or
medical
mine?
surgical treatment.
Mine.
If it
Okay,
is
I was like,
apparent
that doesn't
that
sound like
medical
my
or
dog.
surgical
Okay,
treatment is
it's kind of
necessary,
weirding me out there for a
or
minute.
if requested by the injured
Yeah.
person.
Also, yeah, nothing wrong with being bald, but if you're a woman and you have
This is
male
a
pattern
choice.
baldness, it's yes, but a woman with male not only male pattern baldness, but like that Italian male pattern baldness.
Yeah.
3 sub D of the Wisconsin statute.
Sinead O'Connor. I would have
Well,
done
she
her
was
back in the
Irish.
day.
Oh yeah, that's
Smash her back in the
72nd
day.
count of the information in this case
G.I.
charges
Jane.
that
yeah.
I think bald chicks are
Darrell
kind of
E.
hot.
Brooks, on or about
Well, then you can
Sunday,
have Keffels all you
November
want.
21 of 2020.
No, thanks.
She likes to travel.
on
She's
Main
got a
Street
big
in the
she's got a big
city of
travel
Waukesha,
fund.
I said
Waukesha
chicks,
County,
not dudes.
Wisconsin, did operate a vehicle
This is 2020. I'm
involved
too.
in
I'm not
an
here to
accident
judge.
that resulted in the
This
death
is a safe space.
of Wilhelm Hospital and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was
Don't
operating
forget
as close to the
this.
scene of the
We'll have a
accident as
recess.
possible,
Yeah.
and remain at the scene of the accident until he did all of the
I'll just get a
following.
couple of hours
Give
sleep
his
before
name,
work, and then I'll sleep
address,
at lunch,
the
and then I'll probably
registration
get
number of the
an hour or
vehicle
two of sleep
he was
before I do my
operating.
stream. I'll be
To
good.
the operator or
If not, I'll just do
occupant
math.
of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance.
Yeah,
to any
hopefully Nick
person
is doing this on
injured
Odyssey
in the
tomorrow, because
accident,
I'll be liquored out of
including
my damn mind tomorrow, and I
transporting or
hope some of
making
you'll be here to
arrangements
join me for that.
transport the person to a physician, surgeon, or
Yep,
hospital.
Natalie Portman in
for
V for
medical or
Vendetta, another
surgical
good bald chick.
treatment if it is apparent that medical or surgical
The
treatment
chick
is
in
necessary,
Minority
or
Report.
if requested by the injured person. Contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes.
I like zipper
The
tits.
73rd count of the information
Zipper
in
tits
this
is always a good
case
one.
charges that Darrell E.
Why do you have to go fucking ruin it for
on
me,
or about
Hunch the
Sunday,
dirty
November
roofer?
21 of 2021 on Main Street in the city
Damn
of
it.
Waukesha County, Wisconsin.
Oh,
did
Grace Jones.
operate a
No. Oh,
vehicle
God. That's even
involved
worse
in
than
an
Jada
accident
Pinkett
that
Smith.
resulted in the death of Jackson Sparks.
Not Grace
and
Jones.
failed to reasonably investigate what was struck and if the operator knew.
We're
or
getting.
had
She
reason
sounds
to
like she's
know
going to wrap
that
this
the
up here
accident
at
resulted
some point in the
injury or death of a
near-ish
person
future.
and failed to stop the vehicle he was operating as close to the scene of the accident as possible.
Well, you could
and
also
remain
say
at
it
the scene of the
with
accident
respect to counts
until
1,
he
2,
did
3, 4,
all of
5,
the
and
following.
then say
Give his
do
name,
this. If it's all
address,
just copy
and the
and paste
registration
shit,
number of the vehicle he was operating.
you could
to
consolidate
the
this.
operator or
No, when it
occupant
comes to the
of or
instructions, you
person
can't.
attending any vehicle collided
You've got to
with,
do them all when you do
and
them all.
upon request and if
The
available,
preliminary the
exhibit his
beginning
operator's
instructions.
license
Yeah, I
to
still
the
think they shouldn't be
operator
reading
or
through all this stuff,
occupant
though.
of or
But
person attending any vehicle collided with.
Yeah, I mean,
and
you know,
render
the
reasonable
final jury
assistance
instructions
to
you
any
do, you know,
person
every
injured
charge
in the
has to be
accident,
read through. But this,
including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent
hit and run, failing to give
that
medical
or
treatment.
surgical treatment is necessary, or if requested by the injured person, contrary to sections 346.667 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin
Right.
statutes. The defendant has entered a plea of not guilty to each of these charges.
So your dog now?
Which means the state must
Nope,
prove
my dogs are
every
asleep.
element of each
Across the
offense
house.
charge beyond a reasonable
I hear some barking
doubt.
somewhere, and it's not my dogs.
Ghost dogs.
Section
Give your dogs
346.67 of the Wisconsin
melatonin.
statutes,
Yeah.
commonly referred to as hit and run, is violated when the operator of any vehicle involved in an accident on a highway fails to reasonably investigate what was struck, and if the operator knows or has reason to know that the accident resulted in death of a person, fails to stop the vehicle he is operating as close to the scene of the
Boy.
accident as
There's like
possible,
certain
and
words where
remain at the
Wisconsin
scene
just comes
of the
out.
accident until the operator has given
The
information
operator.
and rendered reasonable assistance to any person injured in the accident. Before you may find the defendant guilty of any count of hit and run, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present with respect to that count. 1, as to each count, the defendant operated a vehicle involved in an accident on a highway. A vehicle is operated when it is set.
These
in
are
motion.
really poorly written.
2, as to each
That it's their jury, it's their standard format.
Yeah.
operated was involved in an accident on a highway. 3, as to each count, the defendant violated a duty after being involved in an accident. A driver who is involved in an accident has 2 duties.
Guilty, done.
The state is required to satisfy you beyond a reasonable doubt that the defendant violated.
I know why
at least
I'm
one
doing
of the
this,
2
but the
duties,
1,600
but you
people
not
that are watching
required to
this
agree
for a
as to
long
which
time,
duty
Yeah.
was
I question
violated.
your sanity.
The first duty is to reasonably investigate.
I can literally think of a million
struck.
things I would rather be doing than
The
this right
second
now.
duty
If
is
I
that
just
a
had, if I
driver
wasn't
involved in an
actually
accident
doing the stream.
involving a person must
Yes, I
stop
can.
and provide information
Well, I need to go back
and
through and
render aid. To prove a violation
my
of this duty, the state must prove the following
photoshopping.
beyond a reasonable doubt: that the defendant knew or had
Man, this
reason to
prosecutor,
know
she just looks like
that
a
the
battle
vehicle he
axe.
was operating
Oh,
was involved in an accident.
Leave Sue
involving
alone. Sue's a good girl.
and that the accident resulted in death
Was
of
Sue
a
on the left or
person,
the right?
and that the defendant did not immediately stop his vehicle
that's Sue over
as
on the
close
right.
to the scene of the accident as
Okay,
possible,
yeah.
and remain at the scene
She's rough.
until he had done all of
Well,
the following.
You get those
Gave his
Wisconsin
name,
winters in your bud, and
address,
you
and the
won't be
registration
looking like
number
no
of the
spring
vehicle he
chicken.
was driving to the
The
person
wind burn.
struck.
There's a lot of nice
And
making
was
casseroles.
requested and was available, exhibited his operator's license to the person struck.
Jay Luca says, "Oh, we're doing other
rendered
things too."
reasonable assistance to any person injured in the accident, including the transporting or making arrangements to transport the person to a physician, surgeon, or hospital for
I do not
medical or
consent to you
surgical
questioning me,
treatment
vices.
if it is apparent that medical or surgical
Thank
treatment is necessary or
How would
is
he know? He's not a
requested
doctor.
by the person.
Yeah.
4, the defendant was
Wait, the person
physically
requests that
capable of
that help you
complying
have to give it to him.
with these requirements. You cannot look into a person's mind to find knowledge.
What?
What a person knows or has reason to know must be found, if found at all, from the defendant's
Cheese
acts,
curds.
words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. The information alleges not only that the defendant committed the crimes of hit and run, but also that the accident resulted in death to a person. If you find the defendant guilty of a count of hit and run, you must answer the following.
Using it as a legal
questions,
CLE
yes or
training.
no.
Yeah, I've got to
accident
finish up my
involve
CLE
death
training before
to
I
a
get
person?
suspended.
Before you may answer yes, you must be satisfied beyond a
gotta finish up by the end
reasonable
of the year.
doubt.
I thought I was
answer to that
ours is
question
June
is
30th, and I still
yes.
haven't done. I thought I was
If you are
suspended the
not
other
so
day. I
satisfied,
just got an email
you
that
must
I
answer the
misread and
question
thought it said, as
no.
of October 1st, you are suspended.
If you are satisfied
but it
beyond
said,
a reasonable doubt,
after
that all
October
4
1st,
elements
you
of hit
will
and
be
run
suspended.
have been
So I'm in
proved
some
as to count
unknown
68,
nebulous
you should
grace
find the
period
defendant
right now.
guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the
Which is
defendant
not gonna
guilty,
happen.
you must answer the following question, yes or no. Did the accident involve death
Yes.
to Virginia Sorensen?
Maybe.
If you are
I don't know.
satisfied beyond a reasonable doubt,
The actual
that
flesh
all
and blood
4
Virginia Sorensen
elements
and the
of
corporate
hit and run have
Yeah.
been
entity
proved
known as Virginia
as
The
to
Sorensen.
corporate
count
entity,
69,
exactly.
you should find the defendant guilty
I see-
of hit
I
and
see
run
death
as charged in
certificate
count
in all caps.
69. If you are not so satisfied, you
Hey,
must
Diamonds and
find
Hannah,
the
what's up?
defendant not
He's on-
guilty.
Yeah, your
I say-
audio has gone
If
scratchy.
you find the defendant guilty, you must answer the
Oh, it
following
has.
That cable.
question,
Yeah.
yes or no. Did the accident involve death to Leanna Owen? If you are satisfied beyond a reasonable doubt that all
Better.
4 elements of
There you
hit
go.
and run
Legal Vice,
have
give us
been
some information
proved
on
as
the
to
area.
count
Is it a small
70,
town
you should
or is it a
find the
suburb of a
defendant
larger?
guilty of hit and run
Waukesha's a
as
big
charged in
is
count
big
70.
for Wisconsin, isn't
If
it?
you are
Well,
not
yeah,
so
it's
satisfied,
it's
you
a
must
decent
find the
sized. I mean,
defendant
it's.
not guilty. If you find the
I thought it
defendant
was
guilty, you
Waukesha,
must
but no, it's
answer the
Waukesha.
following question,
Yeah, it's got
yes or
70,000 people in it
Did the
in the city,
accident involve death to
and
Tamara
Waukesha County
Duran?
has,
That's
as of
Kyle
the
If you are
census,
satisfied beyond a reasonable doubt
well,
that
it's a
all
county
4
next county
elements
over.
of hit and run have been proved as to count 68, you should find the
How many people live
defendant
here?
guilty of hit and run as charged in count 68.
400,000 people. So it's a big
If you are
county.
not so satisfied, you must find the defendant not guilty.
Oh God.
If you
The fact
find
they
the
have a spare
defendant guilty,
courtroom
you must
on
answer
hand
the following
shows they're a
question,
fairly
yes
big place.
or no. Did the accident involve
Kyle
In a smaller
Bogue
county,
is
this
Coolidge.
It's good background noise while I grind
If
away
you are
on Wrath with the
satisfied
Lich
beyond a
King Classic.
reasonable doubt that all 4 elements of hit and
Grind
run
away.
have been proved as to count
Yeah, if this was
72,
if
you
this
should
was a
find
smaller
the
county, that would be a
defendant guilty of
logistical
hit and run
problem.
as charged in count 72.
Diamonds and Hannah, thank you
If
so much
are
for the
not
sticker.
So satisfied, you must find
Big
the
heart,
defendant
thank you.
not guilty. If you find the
I
defendant
wonder if he's going to claim
guilty,
the kids were
you must answer the
holding
following
maritime flags.
question, yes or
Yeah.
no.
She
Did the
Brave is a
does have.
maritime.
involve death
She has
for
the
real
fringe
harm
flag.
possible?
Well, she does, but he could claim that the kids had a French flag, so it's. I hit
If you are
boats, not people.
satisfied beyond a reasonable doubt that all
Wow,
4
Jeff, this is
elements
still
of hit and
on.
run have been proved
Are you
as to
tired?
count
Yeah, I'm
73,
tired.
you should find the defendant guilty of hit and run as charged in count 73. If you are not so satisfied,
Count
you must
73?
find the defendant not guilty. If you find
there's
the
like
defendant
70 some
guilty,
total,
you must
I
answer the
thought.
following question, yes or no. Did the accident
or
involve
no?
death to Jackson Sparks? The
Let's
defendant
picture
is
the
charged
judge
with
bald.
2
No, I like her
separate
black
counts
hair.
of bail jumping.
I like thick black hair.
The 74th count of the information in
Well,
this case
should have seen me like
charges
15
that
years ago. You'd have been loving
Rawr.
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha,
Ow.
County, Wisconsin.
I just think it sounds like
having
a
been
good kung fu
charged with
movie.
a felony
Waukesha!
And having been released from custody under Chapter 969 of the Wisconsin
Chapter.
statutes, did intentionally fail to comply with the terms of his bond, contrary to Section 946.49 sub 1 sub
His
B
bond.
and 939.50 sub 3 sub H of the
Was he not a
Wisconsin
good
statute.
boy?
And
The
Captain
75th
Donut back there.
count
What's he
of the
gonna
information
do
in
if
this
Brooks goes
case
just all
charges that
wild and starts attacking people?
Darrell
Oh,
E.
he's not. Oh,
Brooks,
he's gonna. That
on
guy's
or
got
about Sunday,
experience
November
rattling
21
someone's
of
chiclets. I guarantee it.
2021, on Main Street in the city of Waukesha.
I'm in Kenosha County getting
Wisconsin,
gas right now.
having been
He's
charged
such an.
with
I
Taco
guarantee
Bell?
and having been released from
he's been such
custody
a dick. They would
under
enjoy the
Chapter
opportunity to beat
969 of the
him.
Wisconsin
Oh, I'm
statutes,
sure they would.
did intentionally fail to comply with the terms of his bond, contrary to sections 946.
They'd open a door with his head.
Sub 1 sub B and 939.50
I
sub
can't
3
believe
sub
he's
H of
been
the
this
Wisconsin
quiet.
statutes.
I think he realizes he has to be.
Yeah,
Bail
I think he's.
jumping
I
is
think
defined in
it's starting to
section
sink in now that he has no idea what the
946.49
fuck
sub
he's
1 of the
doing.
Criminal
He's
Code of
waived his
Wisconsin
right to have someone that's
is committed
competent
by
be
one
near
who
him.
has
He's
been
on his
released
own,
from
and the judge
custody
is
on
giving
bond
zero fucks.
and intentionally fails to comply with the terms of that bond.
But I'm sure it'll wear off.
Before you may find the defendant
Yeah,
guilty of any count
he'll quit
of
bargaining
bail
and go for
jumping,
broke.
the state
Well,
must prove
what do you
by
think? Oh, is
evidence
his opening
which
statement going to be
satisfies
"I
you beyond a
object" or is it going to be an
reasonable doubt
8-day thing?
that the following
Oh,
three
probably a little bit of
elements
both, I
were
bet.
present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2,
Blah, blah,
as to
blah.
each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions
And she's talking so
established by
slow,
a
you
court
know.
Commissioner. 3, as to each
That's
count,
what a
the
taser is for.
defendant intentionally
I just want to
failed
tase
comply
everybody
with the terms
at this
of
point.
his bond.
Thank you for
He
keeping us
doesn't have
company,
a
That
says
the
John B.
defendant had the
Yeah.
mental purpose
And for bringing us
failed to
levity.
comply with the terms of the bond.
Ooh, cuffs and a taser.
This
Rawr.
also requires that the
Well, no,
defendant
they have a
knew of the
taser
terms
like
of the
anklets
bond
you can wear.
and
Yeah,
knew
they
that his
little.
actions
We
did
call
not
him the
comply
shocker.
with those terms. The defendant is charged with violating a condition.
Thank you for
of
keeping us
bond
company and
that
bringing us
requires
levity on
that
this
he
sad,
not
sad
commit
day.
any crime.
Congrats on the 26K.
The
Crazy.
state alleges
Much love
that
to the
the
chat.
defendant committed the crimes of first-degree intentional homicide, use of a dangerous
Homicide.
weapon, first-degree recklessly endangering safety,
Homicide.
use
What?
of a dangerous weapon.
I'm getting hungry. I
hit
can't
and
wait till
run
I wake up in
resulting
the
in
morning
death
and I get some
and battery.
homicide.
The state
like
must
commit
prove
homicide
by
on my
evidence
fridge.
which satisfies you beyond a reasonable doubt that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree
Lebanon, it'd be
recklessly
homicide.
endangering safety, use of a dangerous weapon, hit and run
Ooh, I know the bad
resulting
joke.
in death, or battery. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required
You say your
to
name is
agree
Sue?
on which one. The crimes of first degree intentional
She looks like she's just
homicide,
ready
use
to
of a
start
dangerous
swinging.
Weapon, first degree recklessly endangering safety, use of a dangerous weapon,
kid just
and
swimming
hit
at the
and
Y.
run
Can we hurry up?
resulting in death have already been
You're
defined
breaking
for
up
you,
again.
and you should apply the same definitions here. You cannot look into a
It's like he's
person's
doing his
mind
DJ
to
set.
find intent or knowledge. Intent and knowledge must be found, if found at all, from the
Take a speak.
defendant's acts, words, and statements,
Like,
if any,
Your
and from
we
all
get the
the
white
facts and
tonight. Can we hurry
circumstances
up?
in this case bearing upon intent and knowledge.
Flux, are you still here or are
If
you
are
back
satisfied
again?
beyond a reasonable doubt that all three elements of bail jumping have been proved,
Did we
as to
see her
count
during Rittenhouse?
74, you should find the
Who?
defendant guilty of bail jumping
Sue?
as charged in count 74.
No, she's
If you are not so
the DA for
satisfied,
Waukesha County.
you must find the defendant not guilty.
He was in Kenosha
as to
County.
Count 74. If you
So
are
she would have no part in
satisfied
that.
beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 75, you
Nice.
should find the defendant guilty of bail jumping as charged in count 75.
Bail jumping.
If you
Wow.
are not so satisfied, you must find the defendant
must have missed that
not
one.
guilty as to count 75.
He had other charges where he bail jumped.
He did?
The
Oh, for like
76
Yeah.
unrelated?
count
Yeah.
of the information.
But they're just doing it all together because
had,
at that time
Darrell
he
E. Brooks, on or about
Yeah, if you're gonna
Sunday,
run over people, don't
November
have
21
warrants
of
while you're doing it.
2021 at Frame Park in the city
Well,
of
if you kill somebody, the
Waukesha,
first one's free.
Waukesha County, Wisconsin.
You can
did
you can
cause
always go over his
bodily
past
harm to
interactions
Erica
with the law.
Patterson
It's entertaining and
by an act
horrifying.
done with
Oh, I'm
intent
sure
to
there's
cause bodily
many.
harm
Well,
to
there's
that
apparently enough that
person
he's jumped bail on a couple of them.
without that person's consent.
I'm sure they're full of mental health
Contrary to
episodes
sections
too.
940.19
Chad
sub
Tran.
1, 939.51 sub 3
Jeff,
sub
how about
A,
some kogi and soju? Oh yeah, we can do
968.075 sub 1 sub
no
A,
soju tonight. I'll
all
die.
of the Wisconsin statutes.
Just had my whiskey.
Battery, as defined in section 940.19 sub 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with intent to cause bodily harm to that person.
Even
or
she's
another
bored.
without the consent of the person so harmed. Before you may find the defendant guilty of battery, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present.
Yes. And they
1,
are. Oh.
the defendant caused bodily harm to Erica Patterson. Cause means that the defendant's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition.
When you gosh darn aren't nice to
The
someone.
defendant intended to cause bodily harm to Erica Patterson. Intent to cause bodily harm means that the defendant had the mental purpose to cause bodily harm to another human being or was aware.
Wait, what?
that
He was on
conduct
bond for running over his
certain to cause
girlfriend?
bodily harm to another human
Yeah,
being.
it wasn't.
The defendant
It's not the most
caused
flattering set of
bodily harm
circumstances
without the consent
for him.
of Erica
I'm sensing a
Patterson.
pattern here.
4, the defendant
Yes.
knew that
Oh yeah, no, that's why he's
Erica
told.
Patterson did not.
I forgot about that
consent.
part, but I'm glad someone brought it up.
You cannot.
No, you
look
can see
into
that's the
a
thing. You normally
person's
can't
mind
bring up
to find
past wrong
intent and
deeds
knowledge.
unless it shows a
Intent and
pattern of
knowledge must be
behavior. And I think
found,
running
if found
over
at all,
people is
from the
likely to be a
defendant's
pattern
acts,
of behavior.
Words and statements,
Yeah.
if any.
Yeah, he sounds like
And from all the
a bitch.
facts
He
and
won't hit, like,
circumstances
such a bitch, he
in
won't
this
fight
case bearing
people
upon
to just
intent
run him over.
and knowledge. If you are satisfied
sure they'll run
beyond
over
a
his
Well, are they
reasonable
gonna-
doubt that all 4
Are they going to
elements
get
of
that
battery
past
have been
crime
proved
into
as
the
the
trial?
Oh, I don't
count
know. I don't know.
You should
It-
find the defendant.
they might not.
guilty of
I mean, it doesn't really
battery as
matter.
charged in count 76.
I would argue.
If you are not so satisfied, you must
Yeah.
find the defendant not guilty. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You
Yeah,
are not to
Sean knows his
consider
mic
it
is
as
cracking.
evidence against the defendant
It
in
still is.
any
That's why you
way.
need to go to Sean's
It does
potentially
not
criminal page,
raise
subscribe,
any
and
inference
give him lots and lots of super chats so he can afford to buy a new mic cable. Can the DA bring in his Facebook posts?
Opening statements.
I don't know. I don't know what the Facebook posts are.
Is to give the parties an opportunity to tell you
if it's like, here's a Facebook of me planning on going and killing these people, probably. If it's not, probably not.
As it is introduced during the
okay, is this better?
I must
That's much better.
you, however, that the
I don't know what the
opening
deal is.
statements
It was so good last night.
Evidence.
That's what she said.
We have the parties, or before I give them the opportunity to make
we have a new member.
I'm going to excuse the jurors to
Vince Clortho. Thank you so much for joining the clean and sober tier of members.
We'll let you know when we bring you back in.
Oh, thank fuck. Oh, sweet baby.
I like how the banker's boxes are almost organized.
Yeah.
Like he's making a fort to hide behind. No, I think psychologically for him, that's a barrier.
Yeah. Fort Waukesha, the Bronx. Just call me Snake. This is the longest he's ever been quiet.
People are telling me I should restart. I guess I'll restart.
Why?
They're saying I have a problem. I need to restart. Am I okay now?
You're fine with me.
Okay.
I mean, you know,
then I'll hang tight.
Sounds
unless it gets shitty again.
Yeah.
In the meantime, you're like, no, don't leave me alone here. Then I got
please no.
It's like then I got to amuse people.
Oh, are we going to start with opening statements? Seems like it. That's a tough looking bird there in the back. She's like, you fucking move, I'll cut you.
A number of pieces of paper that Mr. Brooks wrote on.
Pieces
have them
of paper.
copies so the state can be aware of that and respond if necessary.
Oh no, what do you do?
So we'll just take a moment while those
He's writing motions on
papers are
napkins.
copied.
Or no.
You did call me. Did it not work? I called him. All right, I'll call again. We will follow.
We will follow you. Well,
just told him to write shit down, so he wrote shit down.
Don Cheadle's sister. Oh man.
We have copies of the filings as well, so you know what will be discussed or at least addressed in some fashion. But I need to provide copies to the state.
I object to the state knowing what I'm doing.
Go ahead, sir.
Hey, you're gonna put something on record there, baby.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out.
You better have solid fucking evidence of that, pal.
About like how I'm looking at you right now. So I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
So one of the victims
flipped
them
off.
off?
Opportunity to exercise preemptory strikes.
One of the jurors, I thought.
Jurors about that.
It was the
You
jurors.
chose not to.
One of the jurors.
So at this point, any issue you have with that juror is waived.
No, it's not. If that juror flipped him, is he saying at selection or today he flipped him off?
I couldn't see
during
all I can see
selection
from that courtroom in there is just you, Your Honor, and the prosecution.
That's a good point. If that wasn't he didn't learn about it, that's juror misconduct. That should be addressed. To say he's waived that, no, he has not. That's appealable right there. That is not a good issue to let go.
If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was
indulgence.
In
you better fucking check
initial appearance.
No, she has
an
to.
Abundance of caution. These are jurors, though, who with the jury questionnaire.
But I have a very sneaky suspicion that juror's going to go.
They had.
Yeah, the juror's going to say, I never did it. But this is why the problem with the juror
no
not
one,
being
to my
filmed.
knowledge, has disclosed anything like
And Rose,
that. But
I
out of an
know,
abundance of
Rose, I know
caution,
nobody
we will
flipped him
ask
off.
that
He's
juror,
lying. But that has to be checked. He makes that
if she was
allegation.
in
It has to
attendance
be
at your
checked.
initial appearance. So for
You
now,
can't-
that's how I'll address it.
That has to be addressed.
I'll advise you of what her answer is later.
Women
Do you
should
know the
not
number
be
of the jurors, sir?
judges.
They
Oh,
have
there's
a
some
number.
tough women judges out there.
I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the top or the bottom row?
The bottom row, the last black chair.
Racist.
The last black chair.
They're all black chairs, sir. So
The
the
last
chair
black
closer-
chair closest to the television.
Racist.
So why don't you say the chair closest to the television in
sir,
the
'cause
bottom
there are
row?
Two sides, right? So there's the last chair on both sides. So I wanted to make clear. You're
Oh, are
saying
we
the chair
arguing over
closest to
which
the television.
chair it
Thank
is?
you.
Oh, fuck.
Front row.
Oh, eat a bag of dicks, dude.
State have copies of the filings.
Cappies. Do you have cappies, Sean?
I will take these in order. The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, I would like my filings addressed. parentheses,
Exactly.
notice of
Judge
special
Alex
appearance,
Manning
statement of
is the
particulars.
bomb.
Both are by
She's a
affidavit,
tough,
file
tough woman judge.
10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings. That's my decision, sir. Next.
Are you
topic.
making a judicial determination that?
Oh,
that was
fuck. She
having
just
no
said it was
merit?
her decision.
Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding a fact.
Your request is denied.
I move
The
for
next-
a
May Your Honor
bad
explain
court.
Mr. Brooks,
thing.
I'm gonna go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making the error, Your Honor.
Mr.
You wanna
Brooks,
explain
I'm
to
not
me?
gonna have a debate with you right now. We
Oh,
are
he
continuing
gets so
on. I'm
close,
giving
and
you
then
the
he
courtesy to
just
respond
goes
to
like
each one of
full
these things.
Brooks.
That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52
Like
p.m.
a judicial, are you making
says,
a
are
judicial
you making a
determination?
judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law. There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not direct,
And
disruption.
Mr. Brooks.
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard in court, will
His
that be
case
honored by
is
Your
going
Honor?
so
That's
well
a
until he
valid
starts
question,
Mr.
because
Brooks,
that's a constitutional
I
right.
have given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even
So-
get these admitted into evidence.
You're doing it
Mr.
wrong.
Brooks, I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand.
That's why you have a lawyer.
But that
you
doesn't mean we're
fuckwit.
going to have a discussion or a debate about what it means, because we're not going to do that.
The rules that you set
So the bottom line is, I don't feel, Mr. Brooks, stop talking. I do not feel.
I was following the rules when you said that I had to make all
And you
objections.
did, and I'm going through them.
writing.
So give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All
Brooks,
I'm saying is,
I'm going to address the next one. So please pay attention.
200 Watt Studio says she gives me emotional damage. Oh yeah.
The First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's all I'm
Brooks,
saying.
again, you have the right to present a defense, but that right is not unfettered. That right, Mr. Brooks, you are interrupting me. Stop.
Because you're talking about
no, because you're purposely doing this, so I
Your
can't
Honor.
get my reasoning
But
out.
I'm
You
not
make it
referring to the
incredibly
Sixth
difficult.
Amendment. I'm not referring to the Sixth Amendment.
Mr.
I'm
Brooks,
to the First Amendment.
She needs to
which
tighten up
clearly
the
says
courtroom
that I
a
have the
bit.
right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor?
I mean, she seems to be really soft and overly lenient with people.
To not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial.
Mr. Brooks, you also have an obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence. That's the playing field that you willingly entered into and made a deliberate decision to waive your right to an attorney and to appear in this case as your own attorney.
To represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to.
Thought it was a lottery ticket?
Know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right now.
You also accepted the terms of the paperwork that I filed
Mr.
out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage in any
He's
type
actually
of
in contempt. He was actually in contempt
because that's
6
what
hours
you're
and
claiming
8
through
minutes
some of
ago.
these filings, and you've
claiming
said that previously.
I am not claiming that, Your Honor.
So,
In any way,
Mr.
shape, or
Brooks,
form,
I am giving you some leeway. You continue to talk over me. It's I'm asking you to follow the rules of civility. Simple rules, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's being asserted.
Here's what's happening, sir. I'm telling you, I'm advising you to respect the rules.
I really need to go grab a drink of water, but I'm not going to miss the most exciting thing that's happened in the last 6.5 hours.
Forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
so I'm gonna, if I need to, I'll remove you to the other
criminal law on
courtroom
Sesame
so that I
Street.
can do this. And yes, exercise the mute button, sir.
And
then I'll bring you back when the jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is clearly not following the simple rule of civility that I have established. He continues to interrupt. He's not providing this court with ability to make rulings on the record without interruption. So this is your.
Do you think she's being too lenient on him? She's being too loose in the courtroom.
The other courtroom.
Will Your Honor honor my First Amendment right?
I'm not answering.
You're muted,
question, sir, because I've already addressed it.
So you're making a judicial determination to
No, this is her. This way,
I am
it can be
not
shown I did
making any
everything I
such
could,
determination,
and that she
sir.
has
You
not.
just said you're not going to answer the
She's done
question
everything
about
to
my
protect his
understanding
rights.
right, which says
Sir,
that
I've
I
already
have
Because
answered
to
the
do all
question.
this
just
extra,
let him go so long.
putting him in the
You
other
have a
room
right to
stuff.
present the
I mean,
defense.
that is
some of that
You
might
have
just
a
be because
right
she's a
to
woman.
be
She doesn't want to fight.
present.
you're trying to twist
You
But
have
I mean,
a
she's
right
really this way.
to present your defense.
She could say, "Look, I did
but
everything I could."
Your rights
And it
are not
one less thing for an appeals court to get mad at.
Your rights.
You're citing the Sixth Amendment.
Well, I get that, but
Your First Amendment in
this
some
this here
respects
just
is
needs to be the judge
circumscribed
going,
by the rules of
shut the
evidence
fuck
and the
up,
rules
sit
of
the fuck
procedure.
down.
Does it say that I have
So that
freedom
doesn't
of
mean you
speech?
get to
Yeah,
say
but
anything that you want in
No,
front of the jury.
I think for her, the
That
problem is
doesn't
saying
mean
no.
you get to put forth any kind of evidence that you want in front of
Well,
the
and
jury.
I mean, then
What it
like,
means, sir, is that
he is
you
facing,
must
he has a
follow-
choice.
Yes,
He's
you're
either
being
going to walk
disrespectful 'cause you're not-
or he's going to jail for the rest
All
of
right,
his life without
he is
parole.
continuously
Yeah.
talking
He has
over
nothing
me.
to be
So at this
intimidated
point,
about.
I'm going to find that he's forfeited his right to be
I have
present as
not
I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any. I'm
his
simply trying
paperwork.
to
He's to be
I
understand
did not
removed to the
consent
other
to join
courtroom
her.
until
Simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your Honor,
everything
I do
set
not
up.
agree
Oh
to
God,
it.
we're going on recess again.
Then you get your water and go to the bathroom.
Yeah, and I need to go get some water. Actually,
Yeah, that's okay. Yeah, I can mind the store for you.
All right, you just got to twist that cable again there to get it all sounding nice and crisp. Oh my Lord!
All right, I can mind the store
There
for
you go. That's perfect. I'll be back in
Yeah,
like
we'll just
2
start
minutes.
building. We'll start building N-word towers. All right, guys. Now that he's gone, we're gonna just everything.
Wait, I'm
just
not
the most
gone
degenerate
yet.
shit ever.
I'm not gone yet.
Get started. Yeah, Fedorovsky, I'll reset it once Jeff comes back. Oh, court TV. Oh, dang it, Jeff, we can't get off there. Oh well. Sean Shapiro. Yeah. Oh, I was talking at 2 times speed. So what do you guys I am Nick Ricada. When do we start with the F words? Now. Oh, jeez, you guys are good. Yeah, it's gonna go on like this, and this is gonna be the entire trial. Where somebody's saying, "Where's her gavel?" She doesn't sound like she's a gaveling type. So it's gonna keep going like this. It won't get any better, guys. I'm sorry. It's not gonna get better. This is gonna be the entire trial. Now, he may have some interesting times when he cross-examines people, but overall, this is him opposing the court. And once again, he doesn't understand stuff, but this is why you have somebody who's a trained professional who understands this stuff there to protect you. And he decided not to have them. So, yeah, imagine this. Who could have seen this happening? Claudia Miller, you're right. They should just assign him an attorney, put the public defenders in, get him started, save time. I don't know why she won't do it. I think that's her biggest liability. I think Nick and I talked about that yesterday. That's the biggest liability. She will screw this up by letting it happen. Luke Pearson saying, did Brooks do enough to preserve the juror issue? If he can articulate that I couldn't see it because you put me in the other room, now that room being put in the other room is self-inflicted. It's a juror issue, but when they come back and say we asked the juror and the juror said I didn't do it, that kind of takes care of it. Unless they can show there was video that showed this. And hold on one second. I need to close my door because you guys could probably hear somebody else talking. All right. Sorry about that. Yes, his opening statement is going to be very interesting. He is really is Biden going to pardon marijuana convictions? I have no idea. I don't know what they're going to do. Yes, she doesn't sound like the court controlling type. She She might not be, but remember, this is a little different, guys, than any judge is really going to have ever dealt with. So it's every time it's a different. She's the first time handling it on a stage like this. So I don't know how. Like, there's not a whole lot of practicing here.
I think she's doing a good job.
Yeah.
I mean, the best she can do in the circumstances.
Yes. Somebody's saying Biden's going to do all federal marijuana, which is interesting because they fired people in the White House who had used marijuana.
She's horrible. She's not horrible.
No, she's far from horrible. I've seen some awful judges.
What?
Oh my God, he actually is going to do it.
Oh, yeah?
Yeah.
So?
Wow, which is funny because when he started, when they first started their going into the White House, you had to fill out some like security questionnaires, and if you mentioned you smoked weed, they were firing people left and right.
I'm smelling some AOC's hand in this, and you know she's like smoking the weed.
Maybe I think it's done maybe for the midterms, but Biden is not he doesn't like drugs and he doesn't like all that stuff. I mean, he bragged about back in the 90s being the first guy to promote so many death penalty eligible federal crimes. He was on record on the floor of the Senate doing that. So
200 watt studio said I missed a super chat.
Yeah, I think you may have missed one.
I'm
you were asking you were asking a question about the contract where he was scratching stuff out.
Oh yeah.
So no, they view that like, do you remember the UCC stuff in school where actually I don't, not to be offensive, I don't know when they were using UCC when you were in law school, right?
Yeah.
Well, I don't know. I don't remember when they started using it, so I don't know.
Yeah.
It's so anyway.
I think he was scratching out like the
what I'm agreeing
do you
to.
understand stuff, and he was doing the soft set.
There's other stuff.
Scratching out understand and writing in I've been informed.
Yeah. And this is like an old way of doing contracts. When you were signing a contract with somebody, if you're scratching parts out and they still signed it, that was their way of, if you scratched out a provision and they still signed it, that was a traditional way of them agreeing to that provision not being in the contract anymore. There's a lot of different ways, commercial contracts. You could still do it today, but it's not a common thing. That's why he's trying to say, like, I didn't agree to this, this, and this, but I scribbled it out. And then she accepted it. And by accepting it, that means it's okay. So that's all the stuff he's doing there.
Yeah. It's just like just playing the lottery, just scratching things out.
Mm-hmm.
I've got like a good 30 minutes left in me. I'm not even gonna make it to opening statements today. I think it's 4:51 a.m. here. God damn it.
Hey Jeff, give me a second. I'm gonna restart just to get my computer working fine. Apparently
all right, you sound perfect now, but
they're like, oh, you gotta fix it. Your drivers are bad. So
your drivers. All right. Well, I'll be here. I'm not going anywhere yet.
Yeah. All right, I'll be right back.
You do that. I'm trying to find
these people aren't telling me to hit Alt F4.
Have you tried unplugging it?
Yeah. Well,
we'll still be
I'll
here.
see you in a second.
All right, cool. Now we're back here in this nebulous zone where we're just waiting. We have no idea how long this recess is going to talk. And I'm scrolling up. Oh, there we go. We finally got it. Wait, you sent me a super chat to say that I skipped your super chat? All right. Now that means I got to scroll. You don't have to do that. Hang on. There was a bit where I phased out there. All right. Yeah. All right. We're going back. We got a bunch of super chats to get through here as soon as I get everything lined up. Holy crap. Yeah. Oh, we read that one. Oh my God.
Michelle's not here, so we're not.
We're back
not on the record. I just want to test.
We are back. We're not back. There's the clock. There's the flag. No, I read that one. I'm confused. All right, let's go back through here. I read the emotional damage one. I read that one. And then you sent me you skipped my super chat. So thank you for that. And then you told me again, or you're talking about this one here that I've had for a while. The Brooks should hire Boozy to say he ran over bots. He just ran over bots. Was that the one you think I skipped? Yeah, I guess. But those are the three I have from you. Thank you so much, though. By the way, wow, an orange sea lion, Sean Shapiro. What did he say while I was gone? I was walking around the house getting some water. The back and forth is becoming embarrassing for her.
Mr. Brooks is now appearing from the
Sean's back.
courtroom prior to the court
now
taking
I can't hear
short
you.
break. The court was attempting to address
earnest money that state prosecutor has easiest money state prosecutors ever made.
No, it's not. This is going to be awful for them.
It's going to be awful for everybody.
Because they can't. They have to protect the record as well. Because he's not going to protect it. They got to make sure it's done legit.
What I will refer to as filings, one of which
it's going to be so much work.
To Deputy Wittig at 12:05, so that was right around the time we broke for lunch. A second one, 1:52 p.m. Today's date, October 6th, and then there's
get ready to drop the beat. Here comes Darrell.
October 6th, 2:03 p.m.
Darrell in the house,
and then
DJ Bumper.
Looks like the time is 14:28.
You got people calling you Sean Shapiro. What were you doing while I was gone?
Apparently, I talked really fast when the thing was all screwed up.
Mr. Brooks, I'm going to make a record first as to why.
Or I was just ripping through things real fast. I don't know.
Hopefully, get to the filings. I need you to not interrupt me at the moment. You are unmuted, but.
Let's bring the volume up here a bit more.
The court completed the preliminary jury instructions and the reading that is to the jurors. I excused the jurors so that they could take a break, but also because I knew there were a number of.
Is Flux here? Flux was here. Flux was here a minute ago. I'm sure she's still here.
Mr. Brooks, I
just switched to T-Mobile because I've jerked around by Verizon. Never would have thought to go to Twitter.
To opening statements.
Oh, nice.
As I attempted to address
DJ Hit and Run DMC.
Yeah. I'm scrolling down to get to that one.
That's awesome. My observation and opinion, and I'll make a finding that it was pretty much a consistent.
I think you can beat these charges.
Talking over me by Mr. Brooks. I wasn't able to.
They're going to bounce right off him just like those kids on his bumper.
Go through any of these filings with any specificity. I attempted to go through the first one.
There we go. 200-watt studio. DJ Hit and Run DMC.
Address that. And then we were talking about his second one when really it kind of devolved from there.
That's beautiful.
The record is very clear that Mr. Brooks has been advised on multiple occasions of my expectation regarding courtesy
music
and
catalog
in this.
Someone asked if I'm going to pick up where Jeff left off. No, I've got some stuff I got to get done this afternoon before my stream tonight.
I expect him to follow minimum.
9:30 tonight, by the way.
It shows a complete and utter
so
lack of respect
9:30 your time. That'd be 10:30 a.m. my time.
Yes,
you're central, right? Yeah, you're central, right?
No, I'm Eastern. I'm in Ohio.
Ohio's Eastern?
9:30 Eastern.
After repeated warnings.
That's got to be like right on the edge of Eastern, isn't it?
The court made it.
I think Indiana starts to be central.
His right to be present in the courtroom while we discuss his.
I'm much louder now.
Filings.
That's a good thing.
The record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me.
You could find this objection, Judge.
Mr. Brooks, I'm not done. I'm going to mute him because frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which is why I believe he engages in the conduct that he does.
Don't do that. Don't be expressing too much opinion there, Judge.
Thought process.
Yes.
It disrupts the proceedings.
Yes, he knows how to discombobulate women by interrupting them.
Rules when the jury
He's
was
the
here
king
and I was
Chad.
going through the jury instructions. I know you had some objections. You wrote them all down. You followed that.
She just explains too much, I think.
After I got through the jury instructions,
this transcript's going to be like a fucking War and Peace.
Yeah, we've had a lot of people going, "Oh, this poor court reporter."
With your interruptions,
yeah.
It doesn't matter to this court if you're mild-mannered, if your tone of voice is a normal tone of voice, meaning it doesn't matter to me that you're not raising your voice, you're not
it's like
making
he's whacking it, doesn't it?
or anything like that. That certainly would take things.
Yes,
to
the
next
jury's in the
level,
room
in
for
my
this.
opinion,
As
but
far as I know.
it's
No, they're not. No,
necessary
they're not.
for this
No,
court
no,
to
no.
make a
Oh no, that
finding
last part the
that
jury
your
was out too.
behavior is,
The jury's not in the room for any of
disruptive.
those motions. Those were all non.
This
all the pieces of
obviously
paper. I was like
comes on the
zoning out.
heels of
That's
your
why
the
we
last
wanted
half
to
hour
do
the
it.
jury's been out of the
where you
room.
spent
There's no
the
way they'd
vast
be in there.
majority of,
That would be on
the
automatic
morning
mistrial,
in the
like
other
retrial.
courtroom based upon
Object this
your
D.
conduct.
This Dioc.
Jeff,
And,
get something to
once
eat. Yeah,
again
that's
relied
why
on
it took a little
the
bit longer. I just went for the water and I got
decision in
sidetracked by
Illinois
this
versus Allen,
amazing
397
lamb
US
and Guinness stew that I made
337,
yesterday.
a US
Had a
Supreme
couple
Court
bites of
case
that.
from 1970 on the options the court has
Orange jumpsuits.
constitutionally
If cotton looked comfortable.
when faced with a disruptive defendant, someone like Mr. Brooks, who cannot conduct himself consistently with the decorum and respect that is inherent
Thank you,
in
injury
the
required.
concept of courts and judicial proceedings. The consistent interruptions.
Oh, and thank you,
are
Deb
not
Hackney,
only
for that as well.
disruptions, but it interferes with the proper administration of this trial. It disrupts the dignity, order, and decorum of this court. Those are the hallmarks
Court
of
just
all
copy and
court
pasting this
proceedings.
part.
I'll make a finding that he flagrantly disregards in the courtroom elementary standards of proper conduct by repeatedly interrupting this court.
I'll be right back, Jeff. I have to
He
make a
has
call.
forfeited his right to be present while we discuss all of these filings. I'll also
Uh-oh,
make a
he's raised the
finding,
objection sign.
that the technology that we are
We have an
utilizing here
objection.
today,
You can't
the
object
Polycom,
here,
the
you
Polycom,
dumbass.
The audio and video have been working very well this afternoon. No issues with that, and that it's the functional equivalent of Mr. Brooks being in this courtroom. It gives him the opportunity and the ability to meaningfully participate while the court is still able to control his behavior by exercising the mute button, as I have repeatedly throughout these proceedings. I believe all of the documents speak for themselves, I should say. But what I will do is go through them one by one from the beginning. Since they're Mr. Brooks's filings, his position has been made known. I'll ask the state to respond. If I feel any additional follow-up is
Of
needed
course you
from
have an
Mr. Brooks,
objection.
I'll ask him for that, and then I'll make a decision. So even if that's backtracking a little bit, it's a little bit easier to do that with him in the other courtroom. So
They're not going to get to testimony
one that I will
today.
deal with is the one that's got today's date and
It's
12:05.
3 p.m.
I addressed it
there.
earlier in terms of
I think the jury has just gone home for the day.
that I did not believe it was a filing that required any court response. And I'll ask the state if the state sees
So
any of
just
that differently.
I'm fading fast. It's 5:02 a.m. here.
United States versus Beneby,
I've been literally streaming all night. And I've got a fuck ton of streaming to come up later today and tomorrow. And when Sean gets back, I think we'll just cut it loose here because there's not a lot of exciting that's going to happen for the rest of the day.
A defendant who identified himself as a sovereign citizen. The court goes into a nice discussion as to such claims having no merit whatsoever. The quote is, the proposed sovereign citizen defense has, quote,
yes,
no
we know you have an
conceivable
objection.
validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout.
You
the
just look like an
remainder of this
NPC
trial
character in a
sovereign
farming
citizen
game.
defenses have been attempted. There's a lot of cases on this.
Farming simulator. What was that?
She's something like this. Yeah, she just looks like an NPC character in some like,
in no way,
you know, like
any
farm
of these
sims
defenses,
game. Just,
such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent.
That's because they're all corrupt, Sue. You're in on it.
Really well with the facts of this case.
she did it.
I would note the documents he refers to in this particular piece of paper references the notice of special appearance, the statement of particulars, both are by affidavit. Those are two of the common sovereign tactics. And I believe Benaby, in the language that you cited, is directly on point, and that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second
I'm wondering if like she has asthma or something. She does these breathing things every now and then.
She might be.
To what's being ruled upon. Then the second filing, we heard him discuss at length, so I'll just have the state respond to that, and that was his claim that his First Amendment rights to freedom of speech are not being honored in this courtroom.
So the court has been abundantly patient in allowing Mr. Brooks to make appropriate, relevant legal arguments. The court is 100% accurate that no constitutional rights is absolute, and there is
absolute.
They can be fettered under appropriate situations, and you've made an excellent record as to why that is appropriate in this case.
You're just kissing ass. You made an excellent record.
I was just gonna say she's like she's like Miss. I was literally just gonna say she's like Miss Brown Nose Prosecutor.
Oh, she's gobbling up that.
That he will be allowed at appropriate times under the rules of evidence, under the to present his defense. It appears to me at times he may confuse the ability to file something into the record with the ability to present evidence. We have yet to start the evidentiary phase of this trial.
We'll never.
That is true. He is messing that up.
In addition, any of his specific objections should be brought by motion. Even if that's an oral motion, it should be.
I've got your oral.
You've told him half the time to write stuff.
Oh,
that's not fair.
Relief.
She keeps on saying you need to write it, so don't say oral motion. Now.
Claims that have no
that's going to be confusing as shit. That's not fair.
In law or fact, it's really conclusory.
Sorry, I get a little mad when they do that shit to people.
Under no obligation to address.
I mean, it looks like you're jerking around at that point.
Statements by him that are not properly made, both in form and in substance. This record's replete with references.
Replete. There's a good word we don't use much.
Just simply spouting.
That's a fancy judge one.
Amendments.
That's a 25-cent word.
Theories without those fully being established in the record. And again, no constitutional right is absolute. The First Amendment rights of an individual can certainly be fettered.
The 13th Amendment, Judge?
That is especially true.
I was gonna say, I can think of a few that are pretty absolute.
Hey, does that mean the amendment for the income tax is not
decorum?
Yeah.
I'm just saying.
Defense. He has a right to present a defense, but his rights to do that must comport with the law, and that law is what I've already pointed out.
I am the law.
So I'm going. Not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court.
Then say yes.
So I've answered this. We'll move on to the next.
You don't have to
one.
explain yourself to him.
That is and he is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next.
Hey, 200 watt
finding at
studio. Thanks.
158,
I'm
there's
out.
still
Get your
motion
damn
to
computer
prove
fixed, Sean.
jurisdiction, please. Also motion to dismiss for no proof of jurisdiction.
Is that fucking up
Also
again?
motion for finding of fact. Again, none of these things.
I think it's just your cable.
Cite
It sounds
to
like a
any
loose
legal
cable.
authority
Like
or
a
any
like a short
factual
in the cable.
basis, nor do they request any specific relief.
Deb
Here's
Hackney,
what I
bedtime,
rely
Jeff. You've
upon
done
the
more than
Beneby
enough.
Decision from the Seventh Circuit that these are just various arguments raised by sovereigns that have been debunked and have been addressed that have no place in our justice system. And therefore, I will deny the requests in that piece of paper summarily without further consideration. I know he makes repeated objection to either how I say his name or how it's referenced in the caption. There's a continuing objection that I will note. His filings speak for themselves. How he
Eve
wishes
Barlow's
to be
rotten
addressed.
crotch says Judge
This
Darrell is
court
just
will
role
refer
playing.
to
Brooks
the
left her
name that is on
with a fadge
the
like a 50
information
caliber
in
exit
this
wound
case. That
last
is the
night.
official charging document.
Ouch, that was harsh.
And that is what I will do. If I mispronounce his first name at times, my apologies.
Is
I
it
know I
Darrell
said
or
it,
Darrell? She keeps
his
calling
name
him Darrell.
repeatedly throughout those jury instructions. I know.
Now I'm gonna pull her out here because like we're at it's 3 o'clock in the afternoon. They're not gonna start opening arguments today. The opening statements.
No, it's 4 o'clock. Yeah, they're definitely not.
Yeah. And it's 5:09 here. I need to get at least 3 or 4 hours sleep before I go and try to pretend to be productive during the day.
I don't know how I'm going to stream tonight if this is not working.
It works sometimes. You're perfectly fine right now.
Drivers.
Yeah.
Well, do I really have this problem, or are people just fucking with me? Because I know sometimes people have to.
No, it's crackly, and that's why I think it sounds like a short in a mic cable or something. That's what it sounds like to me. It sounds like a short in a mic cable. But yeah, this is they were supposed to have started opening arguments this morning, but nothing's going to be easy, and that's why she has blocked out the entire month of October for this trial. And she might need a little more than that the way it's going. Wait, what's this comment here? Legal Vice is dead serious. It's roboting, a bit like a driver issue. It's sounding, but to me, it doesn't sound roboting. To me, it just sounds like crackling, like, well, what do I know? It's not my computer. Should have just powered through the rest. There's still like at least 2 hours left to go here, because it's like 3 o'clock there, 3:11.
It's 4:11 here
in Wisconsin.
Oh no, it's 3:11 there. Yeah, sorry.
So there's still like an hour and a half or 2 hours to go there, and I just can't do it. I'm fading fast, and I sort of need to keep my day job. But like we've been going since 8 o'clock, 9, 10, 11, 12, 1, 2, 3, 4. God, I've been going 10 hours. Fuck me. Well, 9 hours. Yeah, I don't know what to say. We just started out talking about Rick, and like you said, like Rick Nikita, my see, that's where I am. Rick Nikita. We've been talking about Nick Nikita, the things that happened today, and as Sean so eloquently put it, fuck YouTube, fuck Heffels, and fuck everything that has anything to do with it.
Fuck Boozy, who claims that they're claiming responsibility now.
Yeah,
it's like a terrorist attack. They're claiming everything.
It's exactly what I was saying. It's literally what I was just saying. It's like it's terrorist attack, and it's usually the people that claim responsibility had nothing to do with it. We still don't know why, but it's pretty much a near certainty that it had to do with him reading the names. And
it sounds like they may have gone back and tried to get him for older statements he's made too. I don't know if it's clear yet.
Yeah, we won't know until his manager gets back to him or things like that. But the only thing we can really do is just keep the memory alive.
Yes. Stay positive.
I've already told this story twice, but it's like a funeral, and like it's like when your like wife or somebody dies, and you're like, the last thing I said to her was I called her a fucking bitch, because I went this 2 days with no sleep, and now I'm just adding number 3 to it. Why not? I went to work, did my stream, did other stuff. Then I got 2 hours of sleep. I woke up, I worked a full day, did a 6-hour stream, went on Nick until 6 o'clock in the morning, overslept, got up, and I was talking to Legal Mindset, and I'm like, Andrew, I said, God, I'm getting just tired. I got to do this. Pope Nick summoned me. I've got to do it. He's like, your sleep is really important. Sometimes you just got to tell Nick no.
He said, well, here, Jeff, try these. This is called PCP.
Jeff is no Ricada. Jeff is not trying to be a Ricada. I do not claim to be him. I do not want to be him, and I could never be him. But so I'm like, okay. He's like, yeah, and your sleep is important. Sometimes you got to tell Nick to you got something else to do, and you'll come back next time.
Yeah.
And I said, yeah, I need to do that. I do need a good night's sleep. So last night I was planning on I kept everything like 90 minutes. I'm like, all right, I got to go to sleep. And of course, me and my ADHD, I go, I haven't watched House of Dragons yet. So I had to watch that whole episode. And then I get doing other things. And at 3:16, I put my head down on the pillow. I just go, all right, I'm done. 3:16, I lay down. 10 seconds later, Nick sends me the deal. Do you want to come on and do the trial watch with me? And it took me like 5 minutes. I'm just laying there going, okay, Nick has called me. I got to do it. I got to be there for Nick. I got to go do this. And then I'm thinking, but Andrew said, get your sleep. So I'm like, hey, Nick, do you think if I take a rain check on this? And he's like, yeah, no problem. And I just instantly fell asleep. And I woke up a couple times hearing his voice talking, because I left the phone on so I could hear the trial until I fell asleep. And then my alarm went off at 8 a.m. here, and I hit snooze however many times until it just leaves me alone. And then I heard Kurt's voice, and I thought, okay, Nick has just ended his stream, and YouTube just flipped me over to one of Kurt's videos. But then I woke up and I go, oh God, I didn't thank Nick. I didn't thank Nick for being understanding. I better thank him for allowing me to take a rain check until today. So I send him the text. I'm like, hey, thanks a bunch. I appreciate it. And apparently that was like 30 minutes after he'd been yeeted.
Oh no.
Yeah. No. And so then I took a piss, I came out, and then I went, all right, let's go back to the trial, and then I'll just watch what I fell asleep through. And suddenly it wasn't there. So my text reads, timestamp, thank you. Yeah, I appreciate it. 2 minutes later, oh fuck, I'm such an idiot. So it was like, the last time Nick was on YouTube, I told him I didn't have time for him.
Guys, you're saying really I should do something like a sample buffer. I have no idea what the fuck you're talking about.
Yeah, we're old. Come on.
No, I'm not even a boomer. I'm just not an audio guy. It's like I plug mic in, I talk. That's all I know.
Yeah. Oh, the car doesn't start. Turn it on, off, rattle a couple of cables, jump start it, call the auto people.
Yes. Key makes car makes car run.
Yeah. If jumping it doesn't start it, well, what do you want me to do? Oh God. But anyway, I really hope Nick streams this on Rumble tomorrow, so I don't have to, but I'm going to be doing, well, first go ahead. Tell us what you're doing up here in the next few days.
Well, tonight I've got a stream, normal weekly stream. We'll be covering what's going on with Mr. Brooks. We'll be covering Nick. And guys, honestly, right now, he's not gone. He's not dead until we know for sure he's dead. So he's still fighting for a while. So we're far from over.
Yeah, you got to draw that line in the sand.
This week, tomorrow, I'm not sure because I'm probably going to be busy all day. I won't have a chance to stream it. So. But I will be on Friday night. Just screwing around. So, yeah. Good times.
Well, for me, coming up in 12, my brain is just shutting down. So we're looking like 15 hours from now. I will be doing my 25,000 subscriber super drinking griftathon deal where we're just gonna get drunk. People are gonna pay me to drink. Gonna bring on some YouTube peeps, like potentially
that will be fun in the morning.
Yeah, legal mindset. Hopefully Nick can at least just pop in, show his face. I'm trying to think of the people that have confirmed. Law Talk with Mike, Alita from Legal Bites, Legal Mindset. You, Drex will be here.
Oh yeah, Drex early in the morning. Nice.
Yeah, he was supposed to be here earlier today, but to talk about Nick, but I guess he was late because he was pulling hard for Nick all night long. But there's gonna be I've invited about 15 or 16 people. And I about half have confirmed they're going to be there. I just can't think of who. And people just pop in when they can and leave when they can. Tug said he might be there. But when I'm doing this, everyone is having their normal day, so I don't expect anybody to be there. But that's what I'm going to be doing tomorrow. It's the Griftathon, so I don't have to do it for the rest of the month. Just get it all out of the way in one day. Saturday we have the special stream with Steph the Alter Nerd. That's going to be a lot of fun. Check Twitter and YouTube for the times. Monday we're back to Maritime Monday. Tuesday will be Alec Baldwin Day, because there's been even more settlements.
He settled out. Yeah, it's crazy.
Yeah, he settled out with that. There's some other lawsuits being filed, and there have been his very, very first telephone interview he did with the police has just been released. So we'll go through and watch that. Then next Wednesday, I have no idea. Thursday we'll be back to OJ Simpson. That's the next week. God, everybody that like stuck with me through this whole thing. This has been a really weird night for me, and I deeply, deeply appreciate all of it. I appreciate the support. Far and away the most concurrent viewers I've ever had on my own organic stream, where I wasn't a guest on somebody or somebody wasn't a guest on me. It's been good. I deeply appreciate the mods. Mods, you guys are fucking superstars for sticking through all of this, coming and going. Chat, you're the best chat on the entire internet. The Vice Squad rocks. And Sean, you've stuck with me through this. You saved my life there, brother.
I'm glad I helped. And guys, if Darrell gets to do his opening today, we'll cover it tonight. So
yeah, I mean, God, I was just like, oh my God, they're taking another break. What the fuck am I going to talk about?
Yes, the jury instructions are awful though. But yeah, I'm glad I saved you, Jeff.
You did, and we got way more. I've picked up about 1,000 subscribers today. Well, about like 600, I guess. So I'm gonna have 26,132 subscribers for my 25,000 subscriber stream. Cool Frog, you just got here. Hey, I didn't know you were hiding. Cool, we would have had you on here. You loser, where are you? I didn't know you were hiding out there. Oh, apologies. I didn't know you were lurking. Thank you so much for that, Cool Frog. All right, guys, that's it. Got to shut it down. I always hate saying goodbye, but Sean, thank you so much for being here. Everybody go over there to Potentially Criminal. And if you haven't subscribed, which I'm sure you have, if you know him, you know, if you know me and you don't know him, that's your problem. You've got something wrong with you, because you know, he's way more important and knowledgeable about everything than I am. So get over there,
stop,
like and subscribe to his stuff. And I'll see y'all tomorrow. And we'll take care.
Everybody. See you.
Enjoy your
tomorrow. It'll be great.
Oh, wait, I think I've got one more super chat. Do I have? Oh, you do. Jillian, thank you so much for hanging in there with us, Jeff. Ooh, just under the wire. All right, take care. See y'all later. Bye.